Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated
Hello?
assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today. Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was
Walmart.
biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the scale.
Dati mihi Anglican for his service watching.
Literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Remember in the beginning when we started 110 years ago?
Welcome back to the Court of Public Opinion. I am the Recovery Addict. You guys are going nuts with those sound effects here this afternoon. So, welcome back. I think, we have to find another one. I think is it this one?
Because we here in Canada hate you and hope for bad things for you. Because we hate you.
That's not it.
I have the rights to protect myself, don't I?
That is in the rule book of the laws.
That is in the rule book of laws. That's not the one either. Is it this one?
Because we here in Canada.
No, that's the same one. Found it.
This police unit is trying to box him in, but instead he just crashes into the tree.
That's a good one. All right, I can have fun with the sound effects too, you guys. I know how to push the buttons. So, quick witness.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
There we go. All right. Well, she found out. That's the one I was looking for this whole time. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Hope you had a fantastic lunch as we are getting set to hear what should be the closing final moments in the case in chief and the closing statements. Oh, the water bottle's back.
Happy birthday.
See that?
You look good.
Behind Rudy's Fairing member for 20 months. OG. Thank you very much. Let's see. Runkle from British Columbia. Yes, Ian Runkle. Good fellow. Highly recommended. Let's see. I forgot to tell you it's my mom's birthday. Mom, happy birthday, Mom. Happy birthday.
I object.
I'm older than your mom. Twin tail. I'm older than your mom. The Angelo also 24 months. Oh, gee. I've been waiting for this moment. Yay, best court watching channel on YouTube. On the tube. Thanks, everyone, for making it possible. That's correct. 24. Oh, gee. The Angelo. Love it. I hope I didn't miss anybody else in there. If I did, let me know. I'm a grandpa. That's what it is. All right.
Shame on you, sir.
Shame. Plenty of shame to go around.
Is that correct?
All right. Hope your lunch was fabulous. I had enough that I might have a good nap this afternoon because I had a good sandwich, a ham sandwich with just regular dill pickles, not with spiced maple bourbon because they weren't. I had to put them in the fridge. They're not cold yet. You have to eat them cold. And it was delicious. A little bit of honey Dijon, not honey, just Dijon mustard, some pickles, ham sandwich, a little cheddar on there as well. And then I finished it off with a big old handful of Dots pretzels, which are delicious. And so that's what's going to put me to sleep. And I only have one bottle of water. I think we need to do a Sam's Club run. Stock up on Deer Park water. Not a sponsor, by the way, yet. Deer Park, hit me up. Do we have a court watcher? Nap on the couch or in your chair? Chair, of course. Evangeline Light, thank you very much for the super sticker. Yarn and Knots, member for 14 months. Love it here. Great community. Thanks for all you do. All right. Thank you, Yarn and Knots. Appreciate it. You'll have to send me pictures because I know you're crafting while you're listening. Your name is a dead giveaway when it comes to that. Let's see. We have a court watcher in the courtroom. Her name is Melissa. Wonderful. Melissa, thank you very much for being there in the courtroom. Cure Fan San Diego. Your name is not hard to say, but I have a hard time saying it. I don't know why that is. Welcome. Good to have you here. Please put chats on screen. Ask and you shall receive. Are we not? Are we doing no chats? No. Here we go. Let's do audio though. Let's do audio. Let's see, 7 is hot. There we go. We've got audio. Shannon, member for 26 months. Can't wait for my birthday song tomorrow. Same age as RA. 1977 was the best year. It's a good vintage. Good year. Best year, building Lego Imperial Star Destroyer and watching Court. Spring break. Love it. My wife decided spring break was for spring cleaning. And I suddenly got very busy in the studio. I wish I could help. There's just so much to do. Phil is here. Tayo Toys, member for 36 months. Phil, you are in fact an OG. My accountant is trying to Darbo me. Phil, those dang accountants. All the bean counters, they're the same. Graduated from high school in 1977. Nice. How much time is each? I don't know how long they're going to have. We haven't heard yet if there's a timer in place. But we'll find out. We'll time them and see how it goes. I think today would be the last chance for them to recall witnesses for rebuttal, but I don't think anyone's scheduled. I'm making Rocky from Project Hail Mary. Good on you, Troy. Judy V, member for 1 month, says only a member for 1 month, loving and lurking here for longer. Love it, Judy. Thank you very much. Appreciate you being here. All right. Did Kim win the internet? Kim, is this your sign that we, in fact, have to give to you the internet? Everything IP related is your responsibility, Kim. If you were first in chat, that is, in fact, your punishment for being prompt and punctual. Congratulations and good riddance. Are we doing closing arguments today? Yes, we are supposedly doing those. Wizard of Ezzy, just being here is awesome. Thank you very much. Love it. And you did the exactly right thing. Just tag me if there's something that desperately needs my attention, and I will try to read it. I try not to miss those. Let's see. The court watcher has the burner number. She's sitting behind the fence. Awesome. Wonderful. We can't wait to hear. I'd love to hear, honestly, I'd like to know a little bit about who is in attendance. We haven't seen much on the gallery besides the defendant's parents who've been there. But realize without a clear, I know this sounds weird, without a clear and defined victim in this case, which you think, well, we saw the pictures. We know who the victim is. But in this case, who is the victim is in dispute. The complainant may not have the right to just attend regardless, and she is on the witness list. So I don't know. She might be there. She might not. She might not have any desire to be there in court. Aloha, y'all. Nikki, thank you very much. Still looking at the ceiling here. The camera's done pretty well not showing the gallery. This is a crazy case. Zen, it absolutely is. It is wild. Mostly, the thing that's wild about it is the defendant really is hoping that the jury believes his testimony and no one else's, and that's a tough position to be in as a defendant. You've got a lot of evidence that's been presented. Some of it is literally photographs, video, tangible, like a rock, a bloody rock. And I mean that not in the British sense, but like a rock covered in blood. You've got these bits of evidence that the jury's to consider, and the way you tell the story and the way the evidence tells the story isn't matching up. It is a big ask. It's a big ask to have this jury look at this evidence and look at that rock covered in blood that was swabbed from all over the part where there was blood, and all the blood came back to basically being her, and a little bit of possibly touch DNA from the part that didn't have blood from him. That's a big ask to say, yeah, that's from me, when she hit me upside the head, and I don't know how all her blood, it's a big ask. If that were my husband, I couldn't be in court because I'd be calling him a freaking liar. Shady. She basically did. So many questions. What did he do with her phone and purse? He just doesn't know. He doesn't have an answer for that. And, I'm curious. The metal detectorist in me obviously says, I realize it's some rugged area, some big cliffs, but with drones and everything else, I think you might be able to. There might still be some evidence on the mountain to be recovered, because it couldn't have gone too many places. All right. Do we think there will be a state's rebuttal witness? I don't know if they will. I haven't heard yet. Down the cliff, possibly. I'm wondering if like, a warrant served to the cell phone provider might give the last known ping location address for the phone before it was thrown or broken or taken apart or something like that. It might at least put you in the right area, right, to search. Michelle, member for 33 months, says faking work to get out of spring cleaning is grounds for no YouTube. I don't know anyone who would do that, Michelle. It's just, nope. I don't recollect. Did I say? I've got work to do. It's not faking work. Yeah, I'm going to be helping. I've got a lot of painting to do, actually. Red Pan gifted 5 memberships. Thank you, Red, one of our great mods and a good friend and supporter of the channel for a long time. Thank you. It's wonderful to have some great mods here. I do ask you that you be sort of respectful, not sort of, really respectful to the mods would be great. This is already tried to turn the internet off today to get him to do cleaning. That was an accident. She just slid a box and it unplugged the internet while we were live. Yeah, we'd love for you to be very respectful to the mods. They are trying to make sure everyone has a great time today. And is able to enjoy watching court as much as we all do. So please give them a little bit of grace and space. And if they have to gently remind you to change direction a little bit, they don't hold grudges. They don't, and I don't either. So just enjoy. We're gonna have a fun day today. All right, Wizard of Ezzy, look at that. Red Pen hit you with a gift. That's wonderful. Good to have you in green. Congratulations. Does prosecution go first, and do they get a follow-up? Hooter, this is a great question. In Massachusetts, which was the last trial we watched, the prosecution went last, but they each went once. And we've also seen cases where the prosecution goes first and last. It's bifurcated into two parts, and the defense goes in the middle. I predict that's probably going to be the case here, but I don't know. We haven't watched a lot of courts in Hawaii, so we'll have to wait and see. Warm salutations from British Columbia, Canada. I have to play Runkles.
Is that correct?
That's not it. Sorry, it's this one. When you say Canada, I have to say...
Because we here in Canada hate you and hope for bad things for you. Because we hate you.
Yes. A little bit of Ian Runkle there. Well, completely out of context as well. If you know Ian, that is... I don't think he hates anybody except for UPS.
Have him send someone with more experience.
Have you heard about the timing for the closings? No, Drama Llama Mama. It's just going to be today. The judge has said, we're going to give you the case today. To the jury. You'll start deliberating today, which means, less than 8 hours divided by 2. So that's the best I can do. The year I lived in Vancouver was the best year of my life, says Kimberly. But it's beautiful. Snowy in Alberta this afternoon. You guys, it's springtime. You need to, I've got like flowers everywhere around here. North Carolina is gorgeous this time of year, and which is good because it's about to become swelteringly hot. But it's absolutely gorgeous. Ian hates loads of people. Yeah, but he does so in a cute way that makes you sort of smile. Let's see. All right, can't pronounce anyone's names yet. Drama Llama Mama rolls right off. I've had some practice with that one. Galileo May. Did I do that right? Galileo May. Runkle is our elf. Love it. 72 degrees here. We're still about 9 minutes away from court starting, so we can talk about some things before we expect the judge to come in with the jury. Ian is the elf I didn't know I needed in my life. Calling at you with your horse rescue with the live cams of the horses. Says we've got snow. We're snow covered in New Hampshire. It's wild. It is so warm here. Like I've got my fan going and our AC is on upstairs. Runkle is my emotional support Canadian. Love it. First time ever, Galileo May. First time. Is there anything that defendant said that sounds believable to you? Yes. Darlene, I would say yes. There was a lot he said that sounded believable. And most of it was stuff that we probably listened to and said, why are we hearing this? Why is this relevant? Well, it's relevant because he can answer it truthfully, and it comes across as believable because it is. It doesn't help us decide the facts of the case, but there was a lot where he was just describing, dates, planning the trip, got up and had breakfast, where we did. All those things sounded very, very believable to me because I think they were true. I think he was telling the truth on many, many, many of those facts. It's just those key bits that are also important about what was happening right before the nurses walked up there and saw him, rock in hand, straddling his wife with, hitting her in the head. That part is where he needs everyone to think that something else happened than what people think happened. And that didn't come across as believable to me. Let's see. I believe he was sad when he talked about his son jumping too. I believe that emotion was real over his son. I think you're right. I don't think he's completely heartless, like has no soul. But I think he made some terrible decisions. Do you support Miracle Whip? I'll give a gift if you give the correct answer. Well, it wouldn't be... Okay, look at the name. It's got miracle in the name. It's got to be good, Josh. Miracle Whip. I had it on my sandwich today. It's delicious. Lori Genealogy, welcome to the gallery. Thank you very much. Good to have you here. In addition, he tried to kill her allegedly. The key bits in her hand, not believable. Behind Rudy's fairing. As a guy, I've never been in his exact situation where I was, tiger by the tail, figuratively. I've not been in that situation, but I've played, soccer on the field at recess, and injuries happen. And let me just say that in the moment of the injury, it is all consuming, like attention-wise. There is nothing else that you're going to be like, oh, she was doing that, and so I just continued trying to take off my bag or whatever and trying to get her to let go of my hands and untangle my leg. Nope. You lost me right there. That did not happen for $500, Alex. That was just, yeah, it's not good. Bad Mouse Finals, got my taxes done today, getting back a whole $23. Might go out for tacos and Taco Bell with that. You can almost pay for gas and the tacos, but it's definitely better than owing. Oh, that's good. Albatross Bird, thank you for clicking the subscribe button. In just a couple minutes, we'll be able to let you chat. There's a 5-minute delay just to prevent some of the trolls. Look forward to seeing you in chat. Mountain Troll, why are we talking about Miracle Whip pre-trial? Because it's lunchtime and food features prominently on this channel, especially on the podcast. Every Thursday night we have a podcast where food tends to come up a lot. And dad jokes. Greeners says, I have my closings outfit on. Oh, you've got a lei and the Hawaiian shirt. It looks good. It looks gorgeous. First time here, says Cynthia. First of many, I'm sure. What are you covering next? Well, we've got a trial up in Ohio that's going to be starting later in April that we're looking to get people in the courtroom covering. So that'll be a fun one. We are at closings. Dispatch Debbie for sure. Bring back verdict eyebrows. Oh, that's way back. That's a Brandy Churchwell moment. The verdict eyebrows. Good reference there. I think mine were thrown away. I'm like 98% sure they were thrown away. Aloha shirt, not a Hawaiian shirt. See, I don't know the lingo, nor do I have a shirt. I might need one, Greeners. If you could design one for me, maybe we could do an Aloha shirt. Phil, thank you for taking one for the team on this one. Inquiring minds want to know. Thanks for sharing. Susie, member for 25 months, says, finally enjoying my pink courthouse. Thanks, RA, and great mods for all the fun. You're most welcome. Just about 3 minutes away from what should be our starting time. I'm going to bring the blue bars back. I like them better. There we go. Just brightens up my screen a little bit. Does anyone believe they have proven assault but not attempted murder? This is a great question, Gabby. Proven assault would be with The Rock, right? A defense to assault would be self-defense. In defense of oneself, that would be a defense to assault. So if they've proven assault beyond self-defense, that would mean that the jury would have to have not believed his story about hitting her with the rock in self-defense. I would be surprised to think a jury could get that far and then not also take the next logical step to say, and the other parts probably weren't true either from him. So that's an interesting, it's a precarious landing point to think that they've proved assault because he's acknowledged it. He acknowledged he hit her twice. I think initially they said once, then their expert said twice or to 3 times, so now they say twice. But it's an interesting place to stop mentally with the conclusion. I can't be the only one who did the test, Phil. There may be other people, but they haven't fessed up if there are. Greeners decided to look a little more casual. Oh, my goodness, I love that. You got the shirt on, the ball's in your court. Love that shirt. We might need to make that one, Greeners. I know it's sort of designed on a shirt right now. I might need just the image itself. Is that something you can make happen? RA and mods, miss you all. Be back soon. Welcome. Thanks for stopping by and saying hi. Appreciate it. Helen Smith, welcome to the gallery. Brand new member. You're one of us now. You can never leave. We probably should have told you that first, but it's all good. Northwest was going to do the test, but was missing some critical equipment. Makeup of the jury. If we've got a court watcher, that's one thing we'd love to find out. Just a general perception of what the jury's made up with, of and who, and which ones are taking notes and all that. What if those nurses hadn't been there? Susie, I'm a firm believer that even though the injuries she sustained to that point in the attack would not have ended her life, had the attack continued, it very well could have. That's the level of attacks going through all that skin, hitting the bone on the head, loss of consciousness, very probable. And if loss of consciousness occurs, then the defensive maneuvers she was doing with blocking with her hands or with her arms to try to stop and kicking and grabbing, if those had not been taking place, the attack could have escalated much more violently, where she was not fighting back and not able to mitigate any of those blows. So I think it's crucial that they showed up when they did. Extremely, extremely fortunate. Change my name to Purple Nuggets. Careful, when you change your name, sometimes you're stuck with it for a week or two. Kathy Russin from Law and Crime had tweeted, thank you very much, Susan, for this, that the jury is 7 women and 5 men. Interesting. Greeners, thanks. I appreciate that. Waiting now with 1 minute past 3 o'clock. Just started the morning hour of 9 in Hawaii. Has the defendant been in custody all this time? Yes. Let's see. Legally Bond, I need to find the case. I can't remember off the top of my head. Is it Caleb Flynn? Miami County, Ohio, I think is where we want to go next, as far as a big trial. He was the TV personality, right? He was on America's Got Talent or something like that. Golden Buzzer winner. Are you still eating maple bourbon pickles? I had some just the other day, and there's some cooling in my fridge right now. So I guess that answer is yes. I'm in Ohio, may be able to help with the next trial you're looking at. Wizard of Ezzy, a couple things depending on how media access goes for that trial. I might be looking for some tech help, or I might be looking for, if you're able, just a court watcher. Sort of very different roles, but let me know what it's Caleb Flynn. Yeah. Caleb C. Flynn. American Idol. That was it. American Idol. I get my TV shows mixed up. I don't actually watch TV, which is the problem. One county away from Miami County. Galileo May says, regarding maple pickles bourbon, do the new label ones taste the same as the Walmart ones? Make sure it says spicy maple bourbon pickles. If it has those four things, they're basically the same. I've never found a flavor of spicy maple bourbon pickles that tasted different from what I know and love. It's like it's one flavor that's consistent across the board. If you just find spicy maple pickles, that's not the same. Can't remember, was his ear bleeding when he did FaceTime to his son? If it was not commented on. His son saw the blood on his shirt and asked where the blood was from. If his ear had been bleeding at that point and like blood running down his ear, I think the son would have commented on that. I don't think that's what he saw, though. Did his wife first testify? She did. She was very, I'm not sure if she was the first witness, but right at the very beginning of the case. And incredible witness. Just very consistent in her answers to both prosecution and defense. Very matter of fact, very in control. For most of it, there were some points where she did tear up a little bit, but just very much in control of herself and her emotions. And I, from my perception, very believable. Her credibility was right up there where. There was never indications that there was deceptive behavior in how she was answering. She was always just straight, forthcoming with the answer, regardless of the question. So, and her son Emil was also, very similar to her. I don't watch TV. Aside from this TV in my studio, like this one that I'm looking at over there, I don't have a TV, and this one we don't have. It's not even connected to the internet. So, I don't watch TV. Watch a lot of YouTube. Does that count? Jennifer says, no one wants to touch my question with a 10-foot pole. Now that tickles my fancy. Let's go back and look and see what it was. Would there have been bruising on the... Oh! Less ticklish. That's a doctor question. I would say that if it all went down the way that that was described, he was not instantly relieved of pain right when the grip was released. Here we go.
373 for further jury trial. Counsel, can I have your appearances, please?
Good morning, Your Honor. Good morning, ladies and gentlemen. Deputy Prosecuting Attorney Joel Garner for the state. Also present is Deputy Prosecuting Attorney Franklin Don Picaro Jr.
Good morning, Mr. Garner. Good morning, Mr. Picaro.
Good morning, Judge.
Good morning, Your Honor. Good morning, ladies and gentlemen. Thomas Otake and Method Dirks on behalf of Gerhard Koenig, who is present.
Good morning, Mr. Otake. Good morning, Mr. Dirks. Good morning. Good morning, Dr. Koenig. Good morning, Garner. Gentlemen, you can all be seated. Ladies and gentlemen of the jury, good morning to all of you. Welcome back to courtroom 15. It's good to see you. I have to admit, it was a long weekend when I started court yesterday and I walked in and I didn't see you. I thought it was a bit odd. So it's good to see all of you here back in court. Here's the schedule for today. I've had a chance to talk about it with the attorneys. We're going to finish up the presentation of evidence this morning. We don't expect it to take very long. And then I'm going to be reading the jury instructions. The jury instructions are the law that you must follow in this case. And then we'll take a break. and we'll physically reset the courtroom. When we come back from that break, from that first recess, we'll move straight into the closing arguments of the attorneys. So the prosecution will have its chance to begin with its closing argument. We'll take another break, reset the courtroom. The defense has the opportunity to present its closing argument, followed by any rebuttal argument by the state. Once the closing arguments are done, I will have the final charge to the jury, and I'm going to ask the 12 jurors that are going to deliberate in this case to go into the jury deliberation room to begin consideration of the case. I expect all of that to happen this morning. I smile a little bit. What I mean is all of that is expected to happen before lunch. Our lunch break may be a little bit later, just so we can get all of that in before you begin your deliberation. As you already know, lunch is going to be brought in for the deliberating jurors. So that's the schedule that we're looking at. Lunch maybe a little bit later than 12:30, but hopefully not too much later. So that's the schedule for today. Before we continue, does anybody need any more notebooks, any pens? I see no hands. Mr. Otake, does the defense wish to present any other evidence in this case?
Yes, Your Honor. The defense will recall Detective Thomas E. Numa to the stand.
Please.
Ooh. Detective Thomas E. Numa. This guy was not a good witness for the prosecution.
You can have a seat, Detective. Detective, you are still under oath.
Okay.
Good morning, Detective.
Good morning.
Just a few follow-up questions. I'm going to keep this short, but there's a few things I wanted to ask you about. You testified last week when you were called in a case by the state and asked questions by the prosecutor. You testified about your search of Gerhard's computer and how you went through a number of files that were seized pursuant to the search warrant, correct?
Yes.
You worked with Mr. Gardner, the prosecutor, in preparing for trial in terms of going through the computer documents and your testimony, yes?
I work with the lead detective, but as far as the exhibits, the prosecutor's office were in charge of it.
Yeah, so you worked primarily with the lead detective, but the prosecutor's office and worked with HPD to settle in on the exhibits, yes?
Yes.
Now, one of the things that the prosecutor focused on in his questioning of you and in his questioning of Gerhard.
Objection, argumentative, and beyond the scope.
Oh, let him set up the question. And please ask.
Related to the files seized, one of the things you're asked about was the last access timestamp on the files. You remember testifying about that?
Yes.
And isn't it true, Detective, computer operating systems like Windows records when files were last accessed, yes?
Yes.
And then you use the Magnet Axiom software in this case to pull certain files that you are allowed to pull by the search warrant, yes?
Yes.
Axiom then reports, amongst other information, what is called the last access time for those files, yes?
Yes.
Okay. And that's the last access timestamp generated by the computer system, yes?
Yes.
Now, Detective, isn't it true computers routinely access files on their own without human action, correct?
Yes.
For example, operating system processes sometimes access files, yes?
Yes.
Search indexing functions on a computer can access files, yes?
Yes.
Antivirus or security scans can access files, yes?
Yes.
Backup or sync programs can access files, yes?
Yes.
All of those can access files. A computer can access a file doing those things without any human clicking on or viewing the file, correct?
Yes.
And when a computer accesses files that way, it will often update the last access time, yes?
Yes.
Even though it was not a human that accessed the file, correct?
Yes.
And you talked about your experience and the training that you've gone through to become qualified as an expert in computer forensics. Have you read literature related to computer forensics and the appropriate use of these timestamps?
Yes.
Isn't it true that there is literature that cautions computer forensic examiners from drawing too strong of an inference from the last access timestamp because of this issue related to computers accessing files instead of humans? Have you read literature that talks about that?
Yes.
Now, to be fair, the search warrant only allowed you to look at some files, some files that were accessed, yes?
Yes, just within the time frame in 32 items.
Yeah, the search terms, right?
Yes.
So you didn't have access to all of the files that may have been open or accessed during that time period, correct?
Yes.
And that being said, you cannot rule out with certainty that some of the last accesses you discussed last week may have been caused by automated processes instead of a human, correct? You cannot rule that out with any degree of certainty. Well,
yes, that's correct. Based on the data I received, yeah, I cannot rule it out.
Okay. Thank you, Detective. No further questions.
Mr. Garner, any cross-examination? Yes, please.
This guy on the stand is not an expert.
Okay. Good morning, Detective.
Good morning.
Welcome back. All right. So you were asked just now about the computer opening up files on its own. Is that right?
Yes.
How does that apply to the files that you testified about last week?
So for the files to open up automatically, so there's a thing called antivirus software, right? So how that program works is there's two options, right? One is if you want to do a quick scan, which would target specific files, which is known by the company where the malware or the virus might be hiding inside the computer. And there's also another a term we use is a full scan, which the antivirus software will scan the entire computer, right? Every files. How that works is if you do a full scan, it's going to look at every individual files and it's going to create a new access time. It's going to verify that these files does not contain virus. For targeted, it's going to be looking at certain files or folders which may contain the virus, right? If it doesn't have it, then just that folder itself is going to have all the same date, time where it was accessed, because how the virus scan works, it's a sweeping. It might show in within the same date, the time, within milliseconds apart.
Okay. Now, based on the fact that there are multiple different dates where all these different files, the financials, the divorce documents, where all these were accessed, what does that tell you about whether this was a virus scan or a person?
Okay, so how using the Axum software, if it's a case that's involved, if it's important to last access time, the file created date time or the modified date time, what I usually do is I look at the metadata. The metadata is data about the data. So for example, for photos or videos, right, it contains data such as created date time. It also have a modified date time. It's going to also show the last access time. It's going to contain GPS location data and the make and model of the device that was used to capture it. For files, it's going to contain basically the same thing. Might not have the GPS location data, but it might contain the author's name. And as far as when I was looking at when I filtered, just by looking at the date range where it was last accessed, I noticed that all the dates and the date and time that was accessed were all different. It'll be a strong indication if all the access time were all within the same date, the same time, within milliseconds. If it shows that there was over 50 files that were accessed at the same second, then that would be a strong indicator that there was some kind of automated software that accessed all of them, and it's humanly impossible to open up 50 files within a second.
Okay, so let's focus on the files from the defendant's folder that we talked about last week about divorce. Those files were accessed between December 2024 and February 2025, is that right?
Yes.
On at least 4 different days, correct?
Yes.
And what does that tell you about whether it's human access or antivirus software or automatic access?
Okay, so just based on the limited data that I received, it appears that it was likely a human action that caused it, because if the antivirus software went into that folder, it's going to do a sweep of all the files within that folder. It's not going to just individually pick one file for that day, come back a couple days later, look for another file, and so on.
So overall, the file access that you talked about last week, is that more consistent, or that file access that you talked about last week is more consistent than with user access than automated access, correct?
Based on the data that I had, yes.
Okay. Thank you. No further questions.
Detective, you said based on the data that you had, and you said based on the limited data I recovered, it appears more likely to be human. But you say based on the limited data because you didn't have all the data to look at what other files may have been open at that time, correct?
Yeah, so, yeah, correction. So based on the limited data, it appears that it was a human action, but I'm not certain because I will need the full access to the computer.
Thank you, Detective. Nothing further.
Any other questions for Detective Ayden?
No, thank you.
Detective, thanks for coming back.
Okay, thank you.
Too bad Gerhardt remembers opening some of the files.
Does the defense wish to present any other evidence in this case?
Your Honor, at this time the defense rests.
Thank you. Mr. Garner, does the state wish to present any rebuttal evidence in this case?
No, Your Honor.
And we're done.
Counsel, if I can briefly have you appear at the natural record. I'm sorry, on record.
All right, they're going to go to sidebar, discuss everything here. We're going to get the jury break. We have heard all the evidence that is to be presented as evidence in this case. So at this point, it is fair for us to start a poll in chat, and just listen very carefully because I always put not guilty first, right? So there's a presumption of innocence. So my question is going to be, has the state proven the case against Gerhardt? I don't know how to spell his name. I say Dr. Koenig. So the first answer is going to be no. So if you're looking for a yes right away, don't click the first answer. Has the state proven the case against Dr. Koenig? Polls up right now. We'll let you go ahead and vote. We're going to probably do some other calls as well. Another poll like t-shirt or thong merch for balls in your court.
Thank you, Counsel. So at this point in time, ladies and gentlemen, I'm going to read the jury instructions to you. Ms. McCallum is going to pass out to each of you one set of these jury instructions. So you're welcome to read along with me, but you're not required to do so. Because when you go into the jury deliberation room, each of you will have your own set of jury instructions.
We're going to time these jury instructions just to see how long it takes. I'm guessing about 25 minutes.
We still short?
We're missing a copy for a juror.
Does anybody not have a set of jury instructions? Okay. So ladies and gentlemen, I will now instruct you on the law that you must follow in reaching your verdict. You are the judges of the facts of this case. You will decide what facts were proved by the evidence. However, you must follow these instructions even if you disagree with them. You must consider all the instructions as a whole and consider each instruction in the light of all the others. Do not single out any word, phrase, sentence, or instruction and ignore the others. No word, phrase, sentence, or instruction is more important just because it is repeated in these instructions. In the event that a statement or argument made by a lawyer contradicts or misstates these instructions, you must disregard that statement or argument and follow these instructions. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case, unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan, but an essential part of the law that is binding upon you. It places upon the prosecution the duty of proving every material element of the offense charged against the defendant beyond a reasonable doubt. You must not find the defendant guilty upon mere suspicion or upon evidence which only shows that the defendant is probably guilty. What the law requires before the defendant can be found guilty is not suspicion, not probabilities, but proof of the defendant's guilt beyond a reasonable doubt. What is a reasonable doubt? It is a doubt in your mind about the defendant's guilt, which arises from the evidence presented or from the lack of evidence, and which is based upon reason and common sense. Each of you must decide individually whether there is or is not such a doubt in your mind after careful and impartial consideration of the evidence. Be mindful, however, that a doubt which has no basis in the evidence presented, or the lack of evidence, or reasonable inferences therefrom, or a doubt which is based upon imagination, suspicion, or mere speculation or guesswork is not a reasonable doubt. What is proof beyond a reasonable doubt? If, after consideration of the evidence and the law, you have a reasonable doubt of the defendant's guilt, then the prosecution has not proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant not guilty. If, after consideration of the evidence and the law, you do not have a reasonable doubt of the defendant's guilt, then the prosecution has proved the defendant's guilt beyond a reasonable doubt, and it is your duty to find the defendant guilty. You must consider only the evidence that has been presented to you in this case, and inferences drawn from the evidence which are justified by reason and common sense. The charging document is a mere formal accusation, and it is not evidence of the defendant's guilt. You must not be influenced at all because the defendant has been charged with an offense. Trial procedures are governed by rules. When a lawyer believes that the rules require it, it is their duty to raise an objection. It is my responsibility to rule on such objections. You must not consider objections made by lawyers in your deliberations. Statements or arguments made by lawyers are not evidence. You should consider their arguments to you, but you are not bound by their memory or interpretation of the evidence. If I have said or done anything that has suggested to you that I favor either side, or if any of my statements or facial expressions has seemed to indicate an opinion as to which witnesses are or are not worthy of belief, or what facts are or are not proved, or what inferences should be drawn from the evidence, I instruct you to disregard it. You must also disregard any remark I may have made unless the remark was an instruction to you. You must not be influenced by pity for the defendant or by passion or prejudice against the defendant. Both the prosecution and the defendant have a right to demand, and they do demand and expect, that you will carefully and impartially consider and weigh all of the evidence and follow these instructions, and that you will reach a just verdict. You must disregard entirely any matter which the court has ordered stricken. You may, but are not required to accept as conclusively proved any fact or event which the court has judicially noticed. You must accept as conclusively proved any fact to which the parties have stipulated. While you must consider all of the evidence in determining the facts in this case, this does not mean that you are bound to give every bit of evidence the same weight. You are the sole and exclusive judges of the effect and value of the evidence and of the credibility of the witnesses. It is your exclusive right to determine whether and to what extent a witness should be believed and to give weight to his or her testimony accordingly. In evaluating the weight and credibility of a witness's testimony, you may consider the witness's appearance and demeanor, the witness's manner of testifying, the witness's intelligence, the witness's candor or frankness or lack thereof, the witness's relation, if any, to a party, the witness's temper, feeling, or bias, if any has been shown, the witness's means and opportunity of acquiring information, the probability or improbability of the witness's testimony, the extent to which the witness is supported or contradicted by other evidence, the extent to which the witness has made contradictory statements, whether in trial or at other times, and all other circumstances surrounding the witness and bearing upon his or her credibility. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. In weighing the effect of inconsistencies or discrepancies, whether they occur within one witness's testimony or as between different witnesses, consider whether they concern matters of importance or only matters of unimportant detail, and whether they result from innocent error or deliberate falsehood. If you find that a witness has deliberately testified falsely to any important fact, or deliberately exaggerated or suppressed any important fact, then you may reject the testimony of that witness, except for those parts which you nevertheless believe to be true. You're not bound to decide a fact one way or another, just because more witnesses testify on one side than the other. It is testimony that has a convincing force upon you that counts. and the testimony of even a single witness, if believed, can be sufficient to prove a fact. The prosecution is not required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or who may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. The defendant has no duty or obligation to call any witnesses or produce any evidence. The defendant in this case has testified. When a defendant testifies, his credibility is to be tested in the same manner as any other witness. The defendant has a constitutional right and a legal duty to be present throughout the trial and while other witnesses testify. You must not draw any unfavorable inference regarding the credibility of the defendant's testimony on the basis that he was present during the trial. During the trial, items are received into evidence as exhibits. These exhibits will be available for your review when you deliberate. In addition to facts which counsel have stipulated to be true, and facts which the court has taken judicial notice of, there are two types of evidence: direct evidence, such as the testimony of witnesses who assert actual knowledge of a fact, and circumstantial evidence, which permits a reasonable inference of the existence of another fact. Facts may be proved by direct evidence or circumstantial evidence, or by a combination of both. The state of mind with which a person commits an act, such as intentionally, knowingly, recklessly, or negligently, may be proved by circumstantial evidence. While witnesses may see and hear, and thus be able to give direct evidence of what a person does or fails to do, there can be no eyewitness account of the state of mind with which the acts are done or omitted. But what a person does or fails to do may or may not indicate the state of mind with which he does or refrains from doing an act. A person is not guilty of an offense unless the state proves beyond a reasonable doubt that the person acted with the required states of mind, as these instructions specify, with respect to each element of the offense. The instruction for the offense charge specifies the states of mind required to be proved. During the trial, you heard the testimony of certain witnesses who were allowed to provide opinion testimony. Training and experience may make a person qualified to provide opinion testimony in a particular field. The law allows that person to state an opinion about matters in that field. Merely because such a witness has expressed an opinion does not mean, however, that you must accept this opinion. It is up to you to decide whether to accept this testimony and how much weight to give it. You must also decide whether the witness's opinions are based on sound reasons, judgment, and information. The defendant, Gerhard Koenig, is charged with the offense of attempted murder in the second degree. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. There are two material elements of the offense of attempted murder in the second degree, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant intentionally engaged in conduct, and 2, the conduct, under the circumstances as defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit murder in the second degree, which is intentionally or knowingly causing the death of another person. Self-defense
He's 11 minutes
is a
in.
defense to the charge of attempted murder in the second degree and its included offenses. Self-defense involves consideration of two issues. First, you must determine whether the defendant did or did not use deadly force. Second, you must determine whether the force used was justified. The burden is on the prosecution to prove beyond a reasonable doubt that the force used by the defendant was not justified. If the prosecution does not meet its burden, then you must find the defendant not guilty. The first issue is, did the defendant use deadly force? Deadly force means force which the defendant uses with the intent of causing, or which he knows to create a substantial risk of causing, death or serious bodily injury. Force means any bodily impact, restraint or confinement, or the threat thereof. If you determine that the defendant used deadly force, then you are to proceed to the section of this instruction entitled Deadly Force Used. If you determine that the defendant did not use deadly force, then you are to proceed to the section in this instruction entitled Deadly Force Not Used. The determination of whether or not the defendant did or did not use deadly force must be unanimous. You must then follow the law in the applicable section to determine the second issue, which is whether the force used by the defendant was justified. Deadly force used. The use of deadly force upon or toward another person is justified if the defendant reasonably believes that deadly force is necessary to protect himself on the present occasion against death or serious bodily injury. The reasonableness of the defendant's belief that the use of protective deadly force was necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be when the deadly force was used. The use of deadly force is not justified if the defendant, with the intent of causing death or serious bodily injury, provoked the use of force against himself in the same encounter. The use of deadly force is not justifiable if the defendant knows that he can avoid the necessity of using such force with complete safety by retreating. Deadly force not used. The use of force upon or toward another person is justified if the defendant reasonably believes that the force is immediately necessary to protect himself on the present occasion against the use of unlawful force by the other person. The reasonableness of the defendant's belief that the use of protective force was immediately necessary shall be determined from the viewpoint of a reasonable person in the defendant's position under the circumstances of which the defendant was aware, or as the defendant reasonably believed them to be. The defendant may estimate the necessity for the use of force under the circumstances as he reasonably believes them to be when the force is used without retreating. Unlawful force means force which is used without the consent of the person against whom it is directed, and the use of which would constitute an unjustifiable use of deadly force or force. A person cannot consent to the infliction of death, serious bodily injury, or substantial bodily injury. Self-defense is not available for the included offenses of assault in the second degree by recklessly causing substantial bodily injury, and assault in the third degree by recklessly or negligently causing bodily injury, if the prosecution proves that 1. The defendant was reckless in believing that he was justified in using deadly force or force against the other person, or 2. The defendant was reckless in acquiring or failing to acquire any knowledge or belief which was material to the justifiability of his use of deadly force or force against the other person. If, and only if, you unanimously find that all the elements of attempted murder in the second degree has been proven by the prosecution beyond a reasonable doubt, and you unanimously find that the defendant was not acting in self-defense, then you must consider the affirmative defense of extreme mental or emotional disturbance. Extreme mental or emotional disturbance has 2 elements. These 2 elements are, 1, the defendant was, at the time he attempted to cause the death of the other person, under the influence of extreme mental or emotional disturbance. And 2, there was a reasonable explanation for the extreme mental or emotional disturbance. The reasonableness of the explanation shall be determined from the viewpoint of a reasonable person in the circumstances as the defendant believed them to be. The question of the defendant's self-control, or lack of it, at the time of the offense is a significant factor in deciding whether he was under the influence of extreme mental or emotional disturbance. The defendant must prove an affirmative defense by preponderance of the evidence. This means that the defendant must prove that it is more likely than not, or more probable than not, that each element of extreme mental or emotional disturbance occurred. In determining whether the defendant has proven an affirmative defense by a preponderance of the evidence, you must consider all of the evidence that has been presented to you regardless of who presented it. If you unanimously find that the defendant has proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted manslaughter based upon extreme mental or emotional disturbance. If you unanimously find that the defendant has not proven the elements of the affirmative defense by a preponderance of the evidence, then you must find the defendant guilty of attempted murder in the second degree. If you are unable to reach a unanimous verdict as to whether the affirmative defense has been proved or not been proved, then a verdict may not be returned on attempted murder in the second degree. If, and only if, you find the defendant not guilty of attempted murder in the second degree, or you are unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of attempted assault in the first degree. A person commits the offense of attempted assault in the first degree if he intentionally engages in conduct under the circumstances as he believes them to be, constitutes a substantial step in a course of conduct intended to culminate in his commission of assault in the first degree. There are two material elements of the offense of attempted assault in the first degree, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant engaged in conduct which, under the circumstances as the defendant believed them to be, was a substantial step in a course of conduct intended by the defendant to culminate in the commission of assault in the first degree. And 2, the defendant engaged in such conduct intentionally. Conduct shall not be considered a substantial step unless it is strongly corroborative of the defendant's intent to commit assault in the first degree. The defendant commits the offense of assault in the first degree if he intentionally or knowingly causes serious bodily injury to Ariel Kone. If, and only if, you find the defendant not guilty of attempted assault in the first degree, or you're unable to reach a unanimous verdict as to this offense, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the second degree. This offense can be committed in one of two ways: assault in the second degree, substantial bodily injury, or assault in the second degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the second degree, substantial bodily injury, if he intentionally, knowingly, or recklessly causes substantial bodily injury to another person. There are two material elements of the offense of assault in the second degree, substantial bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused substantial bodily injury to Ariel Kone. And 2, the defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the second degree, dangerous instrument, if he intentionally or knowingly causes bodily injury to another person with the dangerous instrument. There are three material elements of the offense of assault in the second degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Kone. And 2, the defendant did so with a dangerous instrument. And 3, the defendant acted intentionally or knowingly as to elements 1 and 2. We are to consider each alternative of assault in the second degree separately. The fact that you may find one of the alternatives has or has not been proved beyond a reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the second degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, have been proved beyond a reasonable doubt. Proof beyond a reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the second degree. If, and only if you find the defendant not guilty of assault in the second degree, or you are unable to reach a unanimous verdict as to any of the alternatives, then you must consider whether the defendant is guilty or not guilty of the included offense of assault in the third degree. This offense can be committed in either of two ways: assault in the third degree, bodily injury, or assault in the third degree, dangerous instrument. As to the first alternative, a person commits the offense of assault in the third degree, bodily injury, if he intentionally, knowingly, or recklessly causes bodily injury to another person. There are two material elements of the offense of assault in the third degree, bodily injury, each of which the prosecution must prove beyond a reasonable doubt. These two elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Koenig. And 2, the defendant did so intentionally, knowingly, or recklessly. As to the second alternative, a person commits the offense of assault in the third degree, dangerous instrument, if he negligently causes bodily injury to another person with a dangerous instrument. There are three material elements of the offense of assault in the third degree, dangerous instrument, each of which the prosecution must prove beyond a reasonable doubt. These three elements are: 1, on or about March 24, 2025, in the city and county of Honolulu, the defendant caused bodily injury to Ariel Koenig. And 2, the defendant did so with a dangerous instrument. And 3, the defendant acted negligently as to elements 1 and 2. The fact that you may find one of the alternatives has or has not been proved beyond a reasonable doubt does not mean that you must reach the same decision with respect to the other alternative. In order to find that the offense of assault in the third degree has been proved, you must unanimously agree that the same alternative, or both of the alternatives, has been proved beyond the reasonable doubt. Proof beyond the reasonable doubt of one or both of the alternatives will result in the conviction of only one offense of assault in the third degree.
It's 24 minutes in.
Ladies and gentlemen, I'll amend the instructions so that it reads the way I read it out loud. If and only if you find that the prosecution has proved the offense of assault in the third degree beyond a reasonable doubt, then you must also consider whether the fight or scuffle was entered into by mutual consent, whether expressly or by conduct. You must determine whether the prosecution has proven beyond a reasonable doubt that the fight or scuffle was not entered into by mutual consent. This determination must be unanimous, and it is to be indicated by answering yes or no on a special interrogatory that will be provided to you.
I didn't know Hawaii was a mutual consent.
Dangerous instrument means any weapon, device, instrument, material, or substance, whether animate or inanimate, which, in the manner it is used, or is intended to be used, is known to be capable of producing death or serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Substantial bodily injury means a major avulsion, major laceration, or major penetration of the skin, or a burn of at least second-degree severity, or bone fracture, or a serious concussion, or a tearing, rupture, or corrosive damage to the esophagus, viscera, or other internal organs. Bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally with respect to his conduct when it is his conscious object to engage in such conduct. A person acts intentionally with respect to attendant circumstances when he is aware of the existence of such circumstances or believes or hopes that they exist. A person acts intentionally with respect to a result of his conduct when it is his conscious object to cause such a result. A person acts knowingly with respect to his conduct when he is aware that his conduct is of that nature. A person acts knowingly with respect to attendant circumstances when he is aware that such circumstances exist. A person acts knowingly with respect to the result of his conduct when he is aware that it is practically certain that his conduct will cause such a result. A person acts recklessly with respect to his conduct when he consciously disregards the substantial and unjustifiable risk that the person's conduct is of the specified nature. A person acts recklessly with respect to attendant circumstances when he consciously disregards a substantial and unjustifiable risk that such circumstances exist. A person acts recklessly with respect to a result of his conduct when he consciously disregards a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if, considering the nature and purpose of the person's conduct and the circumstances known to him, the disregard of the risk involves a gross deviation from the standard of conduct that a law-abiding person would observe in the same situation. A person acts negligently with respect to his conduct when he should be aware of a substantial and unjustifiable risk taken that the person's conduct is of the specified nature. A person acts negligently with respect to attendant circumstances when he should be aware of a substantial and unjustifiable risk that such circumstances exist. A person acts negligently with respect to a result of his conduct when he should be aware of a substantial and unjustifiable risk that his conduct will cause such a result. A risk is substantial and unjustifiable if the person's failure to perceive it, considering the nature and purpose of his conduct and the circumstances known to him, involves a gross deviation from the standard of care that a law-abiding person would observe in the same situation. The law allows the introduction of evidence for the purpose of showing that there is more than one path to prove an element of an offense or to disprove a defense. In order for the prosecution to prove an element of an offense or to disprove a defense, all 12 jurors must unanimously agree that the same act has been proved beyond a reasonable doubt. You must not discuss or consider the subject of penalty or punishment in your deliberations of this case. A verdict must represent the considered judgment of each juror, and in order to reach a verdict, it is necessary that each juror agree thereto. In other words, your verdict must be unanimous. Each of you must decide the case for yourself, but it is your duty to consult with one another and to deliberate with the view to reaching an agreement, if you can do so without violating your individual judgment. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest belief as to the weight or effect of evidence for the mere purpose of returning a verdict. You have been allowed to take notes during this trial. When you begin deliberations, you must follow some important rules with regard to notes. 1. Notes may be used only by you to assist in refreshing your memory of the evidence. Notes are not a substitute for your own independent memory of the evidence. 2. Keep your notes to yourself and do not share or read them to any other juror. 3. You must not give certain evidence more weight simply because it appears in your notes. Do not assume that your notes are accurate or complete. 4. Some of you may not have taken notes. If you have not taken notes, you should rely on your memory of the evidence and should not be influenced by the fact that another juror took notes. Notes are not entitled to any greater weight than the memory of each juror as to what the testimony may have been. Anytime you leave the room during deliberations, leave your notes face down on your chair. 6. If you go home overnight without reaching a verdict, your notes will be kept by the court and returned to you at the start of the next day. Your notes will not be read by anyone. 7. After you have reached a verdict, your notes will be collected and destroyed. At the start of your consideration of this case, elect one of your members as foreperson to preside over your deliberations and be your spokesperson in court. You may take such time as you feel is necessary for your deliberations. You may inform the court if you have any questions about or do not understand the court's instructions. When you reach a verdict, the foreperson is to sign and date the verdict, an appropriate form for which will be given to you. When you begin your deliberations, and until you are through with your consideration of this case, or you are otherwise excused by the court, it is necessary that you remain together as a body. Court personnel will be sworn to attend you and take care of any personal problems you may have and see to your comfort. If you need to communicate with the court, send a note through the bailiff. please do not attempt to communicate with the court except in writing. During the course of this trial, you have received all of the evidence you may consider to decide the case. You must not attempt to gather any information on your own which you think might be helpful. Do not engage in any outside reading on any matter having anything to do with this case. Do not refer to dictionaries or other outside sources. Do not visit any places mentioned in the case. Do not in any other way try to learn about the case outside the courtroom. During your recesses from deliberations, when you are released to go home in the evening, you must not discuss this case with anyone or permit anyone to discuss this case with you. You must not read or listen to news accounts about this case if there are any. You must not discuss this case with any person other than your fellow jurors. You must not review to the court or to any other person how the jury stands, numerically or otherwise, until you have reached a unanimous verdict and it has been received by the court. You may bring in either one of the following verdicts. 1, not guilty. Or 2, guilty as charged of attempted murder in the second degree. Or 3, guilty of attempted manslaughter based upon extreme mental or emotional disturbance. Or 4, guilty of attempted assault in the first degree. Or 5, guilty of assault in the second degree. Or 6, guilty of assault in the third degree. Your verdict must be unanimous. After a verdict has been reached and your foreperson has signed and dated the verdict form, you will notify the bailiff and court will be reconvened to receive the verdict. Okay, ladies and gentlemen, we'll take our first morning recess. You leave your notebooks on your chair along with your set of jury instructions. As I indicated, the jury instructions, these 2 pages, will be amended. So 2 pages will be replaced. So the written instructions that you have will be as I read them out loud here in court. Okay, we'll take a recess. We'll take a 15-minute recess. Ms. McCallum will come get you at 10:10. When we come back in, we will continue on or start with the summation or closing arguments of the parties. All rise.
Okay, so we're going to have a 15-minute break here, which we cannot fast forward through because we're live. There was a couple questions that popped up during the reading of the jury instructions that we have to sort of talk about really quickly as the judge was reading. And one of them was the EMED, right? We heard about EMED, which is the extreme mental and emotional disturbance clause. This is an assertive defense. This is something that is raised by the defense, by Mr. Koenig on the stand. The way he testified, particularly if you remember when the prosecution...
19 of the jury instructions.
Prosecution objected and said something about tailoring.
Page 19 references guilty of murder in the second degree. The court read attempted murder in the second degree. So it should be amended. Last sentence in the first paragraph, the words between of and murder, the word attempted should be inserted. Same change. Last sentence of the instruction, it should be attempted murder in the second degree. That's how it was read to the court. Mr. Garner, any objections to the amendment to the instructions?
No objections.
How about you, Mr. Otake?
This is on page 19, correct?
Yes, sir. Yes, sir.
In the 2 places where it said murder instead of attempted?
Correct.
Yeah, no problem.
And
Thank you.
One more change, counsel. Page 24, and I need you to take a look at not just page 24, but also page 22. I read to the jury the last paragraph that's in page 22 that is not on page 24, indicating that, again, they need to consider the alternatives separately. They must be unanimous if they're going to come back on an alternative or both alternatives, and that if they do come back on 2, it results in only a singular conviction. It mirrors the language in page 2, except it's assault in the third degree. As it was read, and to the amendment, Mr. Garner?
No objection.
How about you, Mr. Otake?
No objection, thank you.
Okay, no. As the instructions are read to the jury, counsel, any objections to the instructions as a whole, other than what we've already settled on the record?
Other than our previous objections, nothing new.
None for this case.
Mr. Garner, have you had the opportunity to review the proposed verdict forms, special interrogatory, and communication forms?
Yes.
Any objections?
No.
How about you, Mr. Falcon?
No objections. I did review it.
Okay. Anything we should take up before we take our recess?
Nothing from the state.
Just that we're going to take a break after. I'd ask that I think we need to take a break after the state's closing so I can set up and also show the state my PowerPoint at that point.
That's fine.
Yeah.
I intended that anyway.
Lots of
I
breaks
did have
today.
one more thing. I'm sorry. I'm glad I remembered it. The normal course of closing is the state, take the break, defense, okay? And then go straight into the state's rebuttal.
Correct.
If the defense is going to argue the affirmative defense of extreme or emotional disturbance, then the defendant has to rebuttal.
Whoa.
We didn't discuss that, but that is the state. So if the defense is going to argue that, then there's a rebuttal. It'll come right after the state's rebuttal. And then I'll give the final charge to the jury before I send them to deliberation.
Rebuttal in the closing.
Yes, with the understanding that should that happen, the rebuttal is limited to the EMED.
Oh, it's only on EMED. Yeah. Okay.
Okay, we're going to talk about EMED just quick.
And off record, I'm going to now look at his PowerPoint.
He's going to look at his PowerPoint and make objections based on that. Okay, so EMED, it's a good thing we were talking about that while we look at the ceiling for a little bit. The extreme mental and emotional disturbance. This is an assertive defense, which means that the defense has to raise this defense to get the benefit of it. They raised it by Mr. Koenig taking the stand and using a very specific, very a legal term as he's describing the mental and emotional state that he was in at the time this happened. You'll remember that the state objected and raised the question of tailoring, which is imagine tailoring. You tailor a suit to make it fit perfectly on the person who's going to be wearing the suit. They're basically saying, we think that the defense did a little work on this testimony to make it fit perfectly into this. It just seems too good to be true that he just happened to quote a legal, the one line. He said the magic words to qualify for EMED, to have this instruction read, which honestly can, it has the potential of lessening the penalty that that's imposed on him if the jury finds that he was in this extreme mental and emotional state, because then it just goes to the extreme attempted manslaughter instead of some of the higher charges. So the state is mad that he got to use this. We didn't really get a resolution on exactly what's going to come in, what isn't, but it sounds like the defense is going to argue this. I think for sure Tommy's going to want sur rebuttal. Of course he wants to have the last word before the jury goes in and deliberates. I predict that there will be some objections in these closings, probably more so coming from the defense when the state is closing, but I can see very likely there would also be some coming from the prosecution during the sur rebuttal, which is going to be interesting. If he claims EMED, he can say bye-bye to his medical license. There's that side of it. But, he already was sort of concluding that that's what was going to happen. Remember when he was up on the hike with Ari and the nurses showed up. Okay, let's skip everything else that happened. Just the nurses showed up, and he's straddling Ari, rocking hand, blood on his shirt, hitting her in the head. They separate, and he concludes right then that he's lost his career, that it's over. Why does his mind go to that instead of, I can't believe my wife attacked me, and I had to defend myself? I don't know. Well, I do know. I think I know. I think it's because he knew what he had done, and he knew that would be a problem for his license. He already has a suspended license until this is resolved. Right, he can't practice. Obviously, he's not practicing now. He doesn't get drugs and syringes in prison. Defense is earning their pennies. They are. They're doing a good job, too. I mean, honestly, put yourself in the defense position. Say you're accused of something heinous, and you're going to court. Would you want a lawyer to fight for you as hard as Tommy does? Yes, I would. I would hope that I could still look myself in the mirror at the end of the day after the fight is over. But how can he argue EMED if no medical diagnosis to support it? Self-diagnosis? Well, it's just it would be like this if you were charged with murder, and you got up on the stand and you told your story for the first time on the stand, and you told the story in such that you said, the subject, the victim, came around the corner and I could just see the look in his eyes, and it was just dead and cold, and I saw what looked like a weapon in his hands, and I was in fear for my life. And at that point, I knew it was either him or me. And you've now triggered the right words to say this is self-defense. You've raised that affirmative defense of self-defense. Well, he's used those right words to trigger the affirmative defense of EMED, which would basically say because of the mental state you were in, it's going to be a lesser verdict. So he's triggered that defense, and I want to hear how Tommy argues this and how the state counters that as well. Joanna, I fear for Ari if he's found not guilty somehow. I think Ari's going to be all right. I feel for his kids though. Man, yeah. Is that like a crime of passion that people used to get away with? I'm not sure if crime of passion, is that an affirmative defense? I guess it might be. Could be the same thing. Medical board would have to wait for conviction unless before issuing a penalty against a license, so there won't be a revocation on file. I want to know why he had drugs, syringes, and IV bags in his closet. Wouldn't any hospital or clinic he worked in have those supplies on hand? It sounded like the controlled items were kept at the hospital, and the non-controlled, like propofol, he would bring home and actually pre-mix into IV bags. I mean, that just sounds weird because maybe there's a standard mixture, right? Maybe it's always like a 10-to-1 mixture of propofol, of IV fluid to propofol, and you can just pre-mix a bag and have it ready for when you need it and save some time. But I was just under the impression, having not been, worked as a medical professional, that medication was administered in a unique per patient need basis. And me being a certain size and weight and age of a patient, gender and everything else, might have a need A, and somebody else being a different size, weight, need, gender, age, everything else, might need a different amount for the same sort of effect to take place. And so pre-mixing it seems strange to me, but he did say that he kept that bag at home because he was on call and he would just run in and be, Johnny on the spot, ready to go with his medical bag. That's the bag that Ari found in the house and called her lawyer about, and the lawyer called the police, and they came and got. And that's the one we saw the pictures of with all the, the IV bag hooks and syringes and everything else. The other bag that's at play is the Patagonia merce, the man purse that he wore across his chest, which he was wearing on the day of the hike, and which he also says he wore to and from work, which would have his water bottle and paper and a pen and things like that in it. He says there was no syringe, no medication in that on the day of the hike. So it's a he said, she said at that point. But what we do know about that man purse was that at some point the back of that purse was probably in contact with Ari's head. And I envision this as if he had taken it off and had it up by her head while he's straddling her and trying to fish something out. Consistent with Ari's story, saying that he had pulled out a syringe and she had batted away and he was digging in his purse trying to get something else. That makes sense to me. It all adds up. The blood tells me that happened. We know that was true, and he had to admit that that's how it happened because he put the bag back on his back and he got a big spot on the back of his white shirt with her blood on it from the purse. But he says that he didn't have any syringes or anything in that. And of course, pretty much everything he had with him aside from the bag itself, when he was up on that hike after he was captured, went missing, and he doesn't know where it went. He just, where's her phone? I don't know. Where's her bag? Where's her purse? I don't know. So, yeah. How does he compare to Corey's defense? Haven't been able to watch. Well, obviously different cases completely. But this is he said, she said. Corey said it wasn't me. He said it was her. So he's literally using her as the third-party culprit saying the victim is the person who perpetrated this against me, and I was defending myself, and I'm wrongfully charged here. She's the one who was responsible for all this. Laura says, I'm a professional couch sitter opinion. In my professional couch sitter opinion, careful I say that, no emotional state defends against smashing someone's head with a rock because your feelings are hurt. But what do I know? Laura, with my limited training regarding self-defense, and I'm talking about use of deadly force self-defense, because I've taken a few trainings on that and been licensed to carry a concealed weapon and all that, and I wanted to be well aware of the law. In most concealed weapons classes, as they're teaching you about self-defense and using a firearm in self-defense, they will teach you the importance of knowing when there is a threat and when there isn't a threat. And when the threat is gone, you can't shoot. You can't shoot after the threat's gone because the threat was there before. For instance, if somebody is charging at you with a baseball bat, in some states, not all, just in some states, that would be enough of a threat where you could use deadly force because you fear imminent bodily harm or death. And you could use a firearm to defend yourself. If you pulled out that firearm and that person dropped the bat, turned around and started running away, you could not shoot at that point. And the reason why I bring this up is in this situation, Gerhardt is sitting on top of Ari. She supposedly has a rock and she's hit him once in the head with it one time. He is able to take the rock from her, and at that point, she doesn't have a weapon. I don't think a reasonable person could conclude that in that state, with him sitting on top of her, she's pinned on the ground, and he has the weapon, that he's in fear for his life, or that he is, in a state where, he has to defend himself further by bashing her not once but twice in the head, and getting those 6 different injuries on her head, which we just can't account for how the other ones happened. So I don't think that that's going to hold up that way. The jury decides that. People with a weapon do not decide that. Right. The reasonable mind. All right. I don't know who hurt their own case more by testifying, Murdoch or this guy. I think it definitely hurt Dr. Koenig's case to testify that he's basically a superhero. That that he's Superman, in his private and public life, and there was no flaws in him. There, aside from he felt bad that he had to defend himself and hit his wife with a rock. He just felt terrible about that. That's it. Other than that, the guy is he's perfect. He's Peter Perfect. He's done everything just great and never had a problem. Never gets mad, even when he thinks his wife is sleeping with somebody else. I felt a lot of things. I was confused. I was hurt. I was upset, but I didn't get mad. Nope. I didn't get angry. That didn't happen. Nope. I never did that, because that might indicate that I might lose my temper sometimes. And if you can picture me as losing my temper, then you can picture me possibly in anger striking someone with a rock. How unreasonable. He lied about his own son's testimony. That was sad. I got that feel as well. Obviously, I don't have any inside knowledge to say who was telling the truth, but my gut feel, as an outside juror looking at this, I didn't feel like he was telling us A, the truth, or B, the whole story in what was going on. And the way he's like, yeah, what probably happened, kids, he probably made a mistake. He probably heard me, the phone probably crackled right as I was saying, Ari said, and then he heard the part where I said, I tried to kill her, and now I feel terrible because now he thinks I tried to kill her. That didn't sell for me. That was not, oh yeah, that makes sense. that adds up. Just called her a bunch of names, right? You've got the lying, cheating, all the bad words, which we're not going to repeat right now, which he called her, and then presumably wanted to have regular, every other day intimacy with after that. I'm not sure. Most women have said, no way, not after that. At least that's what I saw in chat. Airplane-wise, it is island to island, so I'm sure it's a very small airport, and often those who have less security measures in my experience. Donald says, instead of email, I would lean towards narcissistic rage. Yeah, but that doesn't resonate so well with the defense. Tommy doesn't like that phrase. He felt so bad he hit her again. What good is the burner command if it doesn't work? I'm sorry, is our commands not working? Give me a second. I'll tell you what happens. You guys do so many commands, like you use so many sound effects at the beginning of the live stream that it just breaks the tool. And it just stops responding. Okay. Wait for it. Should be back up. 3, 2, 1. It's back up. Okay, it's back. It's working. I've turned it off and on again.
You don't put a diplomatic.
See, you guys go straight to the commands. Let's see. It was only text flirting. I'm not trying to justify or condemn the flirting. Okay, first of all, because if for no other reason, the Ari's not on trial for cheating. Those aren't the charges. Could there have been something? Sounds like it. Is it even reasonable to say that Gerhard should have felt injured or hurt or betrayed? Possibly, yes, 100%. Does any of that justify anything that Ari alleges happened to her at his hands? No. It's just because I talk to you ladies all day. There's plenty of men here as well who weigh in as well. Sounds like a you problem, says Troy. Thank you. Unplug and replug always works. One bad thing does not justify another bad thing. The doctor saying that, what was the context of his quote where he said, I didn't want to tell anyone to protect her reputation? Where was that? How does that jive with, and so I told her best friend and my best friend before I talked to her about it? How does that fit in anywhere? And honestly, look at the sources he went to for information.
Remember in the beginning when we started 110 years ago?
Oh, we're back. We're back. That was quick.
One of the president court with all 4 points of record. All jurors are back in the court. Ladies and gentlemen of the jury, the attorneys will now have their opportunity to give you their closing arguments. Keep in mind, what they say is not evidence, and you're not bound by how they see or how they remember the evidence. You should consider their arguments to you, but again, you're not bound by how they see or remember the evidence. Mr. Garner, are you ready with the state's closing argument?
Yes, Your Honor.
Please.
And for the record, the state is reserving some time for rebuttal.
Understood. Thank you.
A motive, a beating, a confession. Ladies and gentlemen, beyond a reasonable doubt, the state has proven that on March 24th, 2025, Gerhard Koenig tried to kill his wife, Ariel. The state has proven beyond a reasonable doubt that Gerhard Koenig committed the offense of attempted murder in the 2nd degree. There are 2 elements, as Judge read to you a couple minutes ago. Element number 1, on or about March 24, 2025, that if in the city and county of Honolulu, the defendant intentionally engaged in conduct. Element number 2, we'll get back to in a moment. But the conduct, starting with element 1, what is the conduct? What did defendant do? First, he tried to push her. That's the first conduct the defendant did. The second, the syringe. He tried to inject her with an unknown substance. And third, the beating with the rock. That is the conduct that defendant engaged in intentionally. That is the conduct that we are here to talk about for the last several weeks and for today. The second element, that conduct, under the circumstances under which defendant believed them to be, was a substantial step in a course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. So element number 1, simple, it's conduct. Element number 2 defines what that conduct is, what it's meant to do. And the conduct in this case was meant to kill. The intent behind each one. Plan A, the push. The intent was to kill. When Plan A didn't work, the defendant moved on to Plan B. Plan B, inject her with the syringe. Knock her out. Push her off the cliff. The intent behind Plan B was to kill. Plan C, when the first two plans didn't work, beat her with the rock, knock her out, drag her over, or just simply kill her outright. The intent behind every single plan was to kill Ariel. Every plan, every backup plan ends in Ariel's death. The substantial step starts with the plan. The plan's in yellow because it's not a substantial step yet, it's just a plan. Next, the hike. Again, it's in yellow because he hasn't taken that last step. That last step to show he's committed to carrying out that plan, that shows he's committed to killing Ariel. The first time you get that is with the push. When the defendant takes his hands, tells Ariel, "I'm sick of this shit," and tries to push her back off the cliff. That is the first substantial step the defendant took. That didn't work. Ariel went to the ground. Ariel protected herself. The defendant took the next substantial step. He took that syringe out and he tried to inject her. But Ariel fought back. Ariel fought back, fighting for her life, knocks the syringe away, and then the defendant moves on to Plan C, his third substantial step, where he takes that rock, Exhibit 2, this rock right here, the same rock that you've all held, he takes this rock and he beats her with it again and again and again and again. Those three steps are the substantial steps the defendant took to carry out his plan to kill Ariel Koenig. Before we get any further, what is not a defense? The result of the defendant's conduct. The severity of Ariel's injuries, you'll hear many times trying to minimize them. That is not a defense. The law treats somebody the same, whether they're successful or not. The law treats you the same no matter how good you are at executing that plan, no matter how good you are at actually succeeding in killing somebody. The law treats you the same. As an example, somebody who tries to shoot somebody, who points a gun and tries to end a life, but misses, they've committed attempted murder the same way the defendant committed, in a similar way, in a similar idea as the way the defendant did it in this case. You cannot look only at the results to determine intent. You have to look at everything together. And when you look at everything, it shows one clear answer beyond a reasonable doubt, and that's that the defendant intended to kill her. Let's review how we got there. First, we have Ariel's testimony, and she testified in 3 different areas. First, Ariel told you what happened on the Palipuka Trail on March 24th, 2025. She told you what happened when she went up the trail. She told you how she was afraid, how she was nervous about the heights. She told you how the defendant reacted. She told you what happened when she met up with the defendant later. That he pushed her, that she went to the ground, that he took the syringe, that she fought back, and then ultimately he took that rock, this same rock, and hit her in the head again and again. Then Ariel told you what happened leading up to that day. She told you about their marital issues. She told you about her messages with Jeffrey Miller. She told you all of that. Embarrassing as it may be, she put it all out there. And then Ariel told you about her treatment, her medical treatment, her recovery. She showed you the scars that she carries to this day. She showed you the scars on her head where she will never grow hair again. And everything that Ariel said is corroborated. These are the credibility factors. These are listed in your instructions that you should be considering for every witness who testified. And I'm not going to go through all of them right now, but there's a couple that are relevant for Ariel here. First, appearance, demeanor, intelligence, candor, frankness. Ariel testified in a straightforward, coherent manner. She testified clearly. There were no histrionics, barely any tears. It was straightforward. This happened, then this happened, then this happened. It was not over-dramatized. It was not over-exaggerated. It was straightforward and simple and coherent. She was open to cross-examination. When the answer was yes, she said, yes, sir. When the answer was no, she said, no, sir. And when she didn't know, she said she didn't know. But the last factor is the most important here. The extent to which Ariel's testimony is supported by other evidence. What this means, simply, is corroboration. What level of corroboration is there? There is a lot. Ariel is corroborated by the physical evidence, the scene and location, the rock, the blood evidence, the injuries, the medical supplies. Ariel is corroborated by the digital forensics. What was going on the defendant's computer corroborates what Ariel said. Ariel is corroborated by the other witnesses, by their sworn testimony, by Emil Koenig. Ariel is corroborated by Amanda Morris. She's corroborated by Sarah Buxbaum. She's corroborated by HPD. And in the most important ways, she's even corroborated by what the defendant told Emil. You've seen the photos of the scene. Ariel's testimony is corroborated. There's the cliff. It's right there. There's the bloody, the blood pool in the bush where the defendant was on top of her, where the defendant was hitting her. The physical evidence of the scene, the blood, the crushed plants, the location of this, so close to the cliff edge, all corroborates Ariel. The physical evidence, the rock, corroborates Ariel. You've held the rock. You've seen it. You know how much it weighs. You know how sharp it can be on the sides. You've seen the photos of Ariel's blood and Ariel's hair on that rock. The rock corroborates what Ariel said. The DNA evidence. The DNA evidence shows two things very clearly. One, every single sample that was positive for human blood had a likelihood ratio of over 1 trillion for Ariel Koenig. Every single one. The blood on the rock, the blood on the samples from the trail, the blood all over defendant's shirt and shorts. Every single one had a likelihood ratio of over 1 trillion for Ariel. Reason and common sense tells you all of that blood is Ariel Koenig's, not the defendant's. Second, Ariel Koenig's DNA was on both sides of the rock. And think back. Think back to how Ariel demonstrated what she did. She held up her hand. She held up her hand trying to block the defendant. She suffered defensive injuries from it on her fingers, on her thumb, and that's how her DNA is on that rock. Because she touched it. Her touch DNA is on the rock because she touched that rock to try and stop the defendant. The search warrant of defendant's work bag on Maui corroborates Ariel's statement. It shows clearly, conclusively, that defendant had actual possession. Not some sort of theoretical, oh, he's a doctor, he can get this stuff. No, he had actual possession of syringes, he had actual possession of vials, he had actual possession of drugs that can kill. This isn't some, he could have gotten them, he had them. This corroborates Ariel's testimony. And more importantly, these drugs weren't stored in a controlled environment. They were stored in his home, where he had access. He could take them Didn't have to log them or anything. Just remove them from his home and do whatever he wanted with them. This corroborates Ariel as well. Lastly, Ariel is corroborated by her injuries. The physical evidence of Ariel's injuries corroborates exactly what she said. Think of the injuries to the top of her head. The stellate laceration. Dr. Grosjean told you there was debris throughout the entire injury. There were rocks. The defendant swung this rock so hard that pieces of rock broke off into Ariel's scalp. There was dirt throughout the entire laceration. And the middle of Ariel's scalp, he described as macerated or crushed. Went all the way down to the bone. You've seen the photo of Ariel from the front. You've seen what's missing from her head. You've seen that there is a chunk of her scalp that is gone. It's right there in that photo. And you've seen that she didn't just have scalp injuries. She had injuries above her eye. She had injuries below her eye. She had injuries to her hand, not even to just her thumb. Her thumb was only where there was a break. But she had injuries to 3 of her fingers. Her thumb, her index, and her middle finger. Ariel's testimony is corroborated by the physical evidence in this case. Ariel's also corroborated by the digital forensics, the digital evidence. The digital evidence tells you what defendant was thinking, what he was thinking from December 2024 to March 2025. It shows you that, first of all, it confirms the motive. It confirms the strong motive defendant had to kill because he was looking up infidelity. He was looking up Ariel's financials. He was looking up his prior divorce. He was going into Ariel's hard drive to look up documents on her computer or from her computer about divorce. He even went to the point where he was buying a spy device to spy on Ariel. This shows what was going on in defendant's mind. It wasn't some simple research. It wasn't taxes. It wasn't self-help. It was obsession. It was an obsession with Ariel. It was an obsession with infidelity. It was an obsession with going over those financials, and it was a plan for divorce.
It's control.
The second thing that the digital forensics shows, most importantly, it shows defendant's familiarity with that hike. It shows you what the defendant looked at before deciding the Polypuka Trail is the hike that he should be taking Ariel on. It showed the defendant this picture right here. It showed that the defendant was only interested in difficult hikes. Easy hikes were not for him. The defendant wanted difficult hikes, steep trails, big drops, narrow trails. This is where the defendant wanted to take Ariel. This trail, about a foot wide, somewhere around there. One push. One push is all it would take on this trail. Nothing for her to grab onto. One push, and it's a tragic accident. That is what the defendant was researching. He knew that this trail was not popular from his research. He knew that 99% of the people wouldn't be going on this trail. And he knew that this is where he could execute his plan. And he didn't share this with Ariel. He didn't share this website with her, so she could make that informed decision before she went on that hike with him. She had no idea what kind of trail she was getting into that day. Lastly, Ariel is corroborated by the other witnesses. Ariel is corroborated by Amanda Morris. Amanda Morris, the first person on the scene. Amanda told you the sequence of events. 3 things. First, she heard a woman's voice screaming, "Help! Help me!" And she gets up the trail because she thinks somebody's fallen off. She knows it's dangerous. She thinks somebody's fallen. And she sees the defendant over Ariel. Amanda sees the defendant over Ariel. She sees the defendant with this rock in his hand, and she sees the defendant hit her. And when she sees that, Ariel cries, "Help, he's trying to kill me." And Amanda sees how the defendant responds. How the defendant responds is nothing. He just looks at her. Ariel's also corroborated by Sarah Buxbaum, the second woman on the scene, the second hiker who intervened. Sarah came in behind Amanda. She saw the defendant standing over Ariel. She saw the defendant standing with that rock. And most importantly, Sarah looked the defendant in the eye. Sarah made eye contact with the defendant and told you how that made her feel. It made her feel unsettled. It made her feel so afraid for herself and her safety when she was looking at the defendant in the eye. It made Sarah feel so unsafe that she and Amanda went back down the trail before they called 911 because they realized this was a dangerous situation for them. They realized, after looking in his eyes, what could happen to them. And they took those steps after seeing what was in the defendant's eyes. After seeing that look, they took steps to protect themselves. Listen to Sarah's voice on that 911 call. It's Exhibit 3. You'll have it. Listen to her voice, and you can hear what she's thinking about. You can hear the worry in her voice. You can hear that she's afraid for her own safety after she's seen the defendant. It's all there. And you may hear argument today, or have thought, maybe you thought to yourself, well, Amanda and Sarah only saw the end. The evidence shows that Amanda and Sarah didn't see the end of the incident. They caused the end of the incident. Because when they showed up, that is the only thing that stopped the defendant. Ariel screaming for help didn't stop the defendant. Ariel fighting back for her life didn't stop the defendant. The only thing that stopped the defendant, the only thing that was enough for him to stop, is two eyewitnesses coming up on the scene and seeing him beat her with that rock. The only thing that got him to stop was being caught red-handed. The responding officers, Corporal Wu, Corporal Chun, they corroborate Ariel as well. They showed you the hike. You saw the hike on their body cam. You saw their struggles with trying to get up the hike. They showed you the scene. Once more, right there, in the foreground of this photo, that's where this happened. That's where the beating with the rock happened. And right there, just a couple feet away, that's where the defendant tried to push her. They showed you Ariel's condition. Ariel's condition immediately after the defendant did this. They showed you that. They showed you the closest thing to what the defendant last saw Ariel as. And they even caught it on their body cam. They even caught Ariel's condition as she states her name.
Ariel Koenig, Arielle. Birthday is March 24th, 1989.
You heard Ariel testify for hours. But also, you heard in this video her slurred voice, her heavy breathing, her condition after the defendant beat her with that rock. She was not okay. The manhunt corroborates Ariel as well. It took 3 different agencies, HPD, DLNR's DoCare, HFD, several different units from them, SED, SSD, a canine unit, the major events unit to search with drones. It took 2 drones, 1 helicopter, and after 8 hours, or almost 8 hours, they were still not able to find the defendant. And that tells you one incredibly important thing. The defendant did not want to be found. The arrest corroborates Ariel just as much. Officers Nicola, Koki, and Borges approached Ariel in their vehicle. Officer Nicola testified he got within an arm's reach of of the defendant before he jumped out the car.
Objection. Misstates his testimony.
He got within an arm's length, or close to an arm's length, before he got out that car and tried to apprehend the defendant. He identified himself as police. And how did the defendant respond? The defendant tried to flee into the woods. It took a total of 835 pounds of HPD officers to subdue the defendant. That's how much he was resisting. He knew they were police. They identified themselves as police. And as Officer Nicola testified, the defendant, in his attempt to get away, fell on his face, and then Officer Nicola fell on top of him. That's why you see the grass on the defendant's head. That's why you see the dirt on the left side of the defendant's face, because that's where he hit the ground. That's where he hit the ground while he was being arrested. And the defendant's own actions, finally, also corroborate what Ariel told you. Defendant's actions corroborate Ariel's testimony. First, he fled the scene. Second, he collected the evidence from the scene. He collected Ariel's phone. He collected Ariel's purse. And he collected those syringes. He took all those items from the scene and he disposed of them. Ariel's mom still tried to ping her phone, and it was up at the poly hours later, but they could never find it. And think back, where Doe Care couldn't search. They couldn't search the bottom of the cliff. They couldn't get down that way. They searched the whole mountainside, couldn't find it, but the bottom of that cliff that's several hundred feet tall, that's where they couldn't search. Defendant confessed. Defendant called Emil just minutes after the incident and told Emil, "I tried to kill Ariel, but she got away." And lastly, the defendant hid in the woods for almost 8 hours. These actions that the defendant took corroborate what Ariel told you. They make sense. That being said, the defendant in this case has testified. And you need to judge his testimony the exact same way that you judge anybody's. At the beginning of this trial, you heard a theme, some alliteration with a theme, unwilling or unfaithful, unwilling, untrue. But ladies and gentlemen, after listening to the defendant's testimony, you only need one word to summarize it. One word. Unbelievable. The defendant's story. She started an argument. The defendant's story is that somehow Ariel, on her birthday, on an unfamiliar hike next to a massive cliff, decided to start an argument. Does that make sense to you? No. Ariel decided somehow to start an argument about she said she wanted to go back and continue to work with Jeff Miller. She wants to travel with Jeff Miller. Does that make sense that Ariel would bring this up on that cliffside? No. It contradicts common sense. It even contradicts the defendant's own testimony, where he told you they don't talk about this outside of counseling. The defendant told you that, and that's what worked for them. And somehow Ariel's bringing it up, ruining her birthday on a hike. Ladies and gentlemen, it's unbelievable. The next part, the defendant's story. She pushed me. The defendant says he felt a hard push from behind, that he was looking out over the cliff. He barely holds himself on. He turns around, and Ariel's already 5 to 10 feet away. Ladies and gentlemen, unbelievable. If Ariel was trying to push him off that cliff, she wouldn't be that far away. She would have been right behind him, trying to push him again. Defendant's story. She pulled me down on top of her. Think about how that makes sense. Defendant's story is that then he approached Ariel, that he grabbed her arms, and Ariel somehow responded by pulling him down on top of her and not letting him go. Defendant's bigger than her. Defendant's stronger than her. Ask yourself, what person would hold a bigger, stronger person on top of them as an act of aggression. It doesn't make sense. It's unbelievable. Defendant's story, she hit me first. Somehow while Ariel's sitting down, or while Ariel's underneath him, while he's in the position of power, while he's on top of her, the story is that Ariel held him down so he couldn't escape, grabbed his genitals, wrapped her legs around him, and then she picks up a rock and hits him in the face. And as the defendant told you, he said, she hit me one time really good, and that she keeps swinging. The same rock that defendant used to beat Ariel? Really? The same rock that defendant has told you he only used 2 times, that he only hit her twice with. Ladies and gentlemen, it's unbelievable. The same rock, no. You can tell it's different injuries. This is the photo of the defendant immediately after his arrest. This is the photo of the defendant almost 8 hours after the incident up on the trail, after the defendant tried to kill Ariel. Yes, there's a small dark spot on his cheek. Is it a bruise? Is it dirt? I don't know. This is Ariel. The idea that this same rock caused these different injuries is unbelievable, ladies and gentlemen. The idea that Ariel could hit him really good, and that's it, it's unbelievable. This is the defendant at the hospital that night, and this is Ariel at the hospital on the same day. Again, minor bruise, major laceration. The idea that these injuries were caused by the same rock, completely unbelievable. You can only see that by looking at the next day. Look at the defendant 1 day later. There's nothing. There's no more. Ariel's got her head wrapped up. She's still got these injuries on her eye. The defendant's story is unbelievable. And lastly, the defendant told you that he wanted to turn himself in. That's what he was doing when he left the trail. Sunset was coming soon. The sun was getting low. But instead of doing the logical thing and walking down the trail where he knew the police would be, the defendant decides he has to come out of the forest onto the road. The defendant doesn't go back to the trailhead. He doesn't put his SIM card back in his phone. He doesn't turn his phone on because he's not trying to surrender himself. He's not trying to turn himself in. He's trying to escape. And that's why he ran when the police apprehended him. That's why he resisted. The defendant's story, unbelievable. The defendant's story, unlike Ariel's, where Ariel is corroborated, the defendant's story is filled with contradictions. The defendant is contradicted by Amanda and Sarah. Somehow, Ariel finally let go of his private parts, and then he just stands there and looks. He's not on the ground writhing in pain? Does that make sense? He says that she held on so hard that he couldn't escape. Does it make sense that afterwards he would just stand there and stare? No. The defendant is contradicted by the physical evidence. He's contradicted by the fact that there's no blood of his up there. There's no evidence of injuries that support what defendant says happened. He's even contradicted by his own hired doctor. The defendant told you he hit her twice. No more. But even his own doctor said 2 to 3 hits to the scalp. Hits to the face. Hits to the fingers. So even the defendant's own witness shows that he hit her more than twice. He hit her, add them all up, 4, 5, 6, could be any of those times. He hit her again and again and again and again. And he only told you 2 times. Ladies and gentlemen, it's unbelievable. He told you he removed his SIM card with a paperclip. Well, State 72 through States 86, that's all the photos. That's all the contents of defendant's backpack. Where is that paperclip? He could have just as easily used that syringe. Open his SIM card, dispose of the syringe. Hiding evidence 2 ways at once. The substantial step again. He made the plan. He made the plan to go hiking that day. He didn't share with Ariel what hike they were going on. He didn't share the details of that hike with Ariel. He didn't share the dangers of that hike with Ariel because his plan was to push her off that cliff. So they start the hike, and Ariel deviates from the plan. Ariel doesn't go up to that section from the photo, the super narrow section with no trees. Ariel doesn't want to go up there. So the defendant improvises. The defendant takes a different cliff. The defendant sees his last chance when they take this selfie, his last chance before they get to that lower part of the trail. And he takes it. He takes that chance to try and push Ariel off. He takes that chance. He makes that substantial step. And plan A, the push, doesn't work. Ariel falls to the ground. He can't push her off anymore. So he takes that next step. He pulls out the syringe. Plan B. And he tries to stab her with it. Plan C, when that doesn't work, he takes that rock and he hits her well over 2 times. He hits her again. He hits her again. It doesn't matter that she's blocking. It doesn't matter that she's screaming. The only thing that gets him to stop is these 2 women who walk up. That's it. You have gotten instructions about self-defense. It should be clear. The defendant was using deadly force in this case. This rock is known to the defendant to cause death or serious bodily injury. You don't need to be a doctor, although he is. And he's actually treated patients who've had rocks fall on them. So the defendant is well aware of the damage that he was doing. He's more than aware because it was his intent. It was his intent to cause that damage. It was his intent to cause death. So yes, it is clear the defendant was using deadly force. And because of that, self-defense doesn't apply. Or self-defense does apply, but defendant cannot claim it because he was the initial aggressor. He was the one who started the physical altercation. He was the one who used deadly force. And lastly, he had a duty to retreat. When using deadly force, before you use that deadly force, the law states you have a duty to retreat. And the defendant didn't do that.
Incomplete statement on the law.
Objection overruled. Ladies and gentlemen, the court instructed you on what the applicable law is. You need to follow the court's instructions as read out to you and as it's provided in the jury instructions that you have.
The defendant did not follow the law. The defendant attacked her. Self-defense is not applicable. The state has disproven it beyond reasonable doubt because the defendant was the initial aggressor. The defendant was the first one to use force. Based on these facts, self-defense is not applicable. Next, you're given instruction on extreme mental or emotional disturbance. This is a long instruction. We'll keep it simple. There's no evidence that the defendant was acting under extreme mental or emotional disturbance when he tried to kill Ariel. Don't be confused by his testimony. He did say he was under severe emotional distress, but he said that after he tried to kill Ariel. He said he was under severe emotional distress after he started to think about how this would affect his job, how this would affect his life. He was under severe emotional distress after he began to think about the consequences of his actions and how his actions would affect himself. That's what that is. The defendant was not under extreme mental or emotional disturbance when he tried to kill her. He only became that way when he began to think about the consequences. The second part of that instruction states that the defendant's self-control, the defendant's logical thinking is important here. It shows the defendant, when plan A didn't work, he moved to plan B. When plan B didn't work, he moved to plan C. And when he got caught, he fled the scene, he hid the evidence, and he hid himself. That shows the defendant was using logical thinking, the defendant was solving problems as they came, he was not acting under extreme mental or emotional disturbance. Okay. You got a list of other included offenses. You got a list of a bunch of assault charges that are included in the attempted murder in the second-degree charge.
We're 37 minutes in.
When you think about those, just think one thing. He did more. This is what he did. Assault in the third degree, causing bodily injury. Ladies and gentlemen, that means physical pain. He did more. He did more than cause physical pain to Ariel. Assault in the second degree. He did more. Yes, the defendant caused a major laceration to Ariel's head, or severe laceration. The defendant caused a bone fracture to Ariel's thumb. Yes, he did those things, but he did more. But he did more because he was trying to kill her. Attempted assault in the first degree, same thing. Defendant took actions that he knew would cause a substantial risk of death. Yes. But he did more. Because the evidence all shows that defendant wasn't intending to do an assault. The defendant was intending to kill. All right. 3 things. Motive, a beating, and a confession. You've seen through this trial the defendant's motive. He was upset. He was angry. Wherever he turned, Ariel wasn't being punished. First, he talks to Ariel's best friend, tries to air the dirty laundry. But the best friend stays on Ariel's side. Deanna stays on Ariel's side. She's not punished. Then he emails Andrea Miller. Giving this other woman Ariel's personal contact information, her cell number, her personal email. But Andrea Miller never responds. Ariel's not punished. And then he goes to counseling. They go to marriage counseling. And instead of focusing on the affair, what do they focus on? These intimacy issues, these issues that Ariel testified about, these issues that were defendant's fault. Everything the defendant tried to do made sure Ariel was never punished. So he did it himself. Every response defendant had to this emotional affair showed the defendant's need to control Ariel. He wanted to control where she lived. He wanted to separate this woman from her 18-month-old child. That was his response. His response to finding out was, you should move out. He wanted to control her job. He wanted her to quit. He wanted her to be dependent on him. Because once Ariel quit her job, it's much harder to divorce. She has no more income. She can't go find another remote worker, nuclear engineer job. The defendant knew how much a divorce would cost. He was looking at his own documents, his own records from his prior divorce. He was looking at his own records that showed how much he paid in his prior divorce, because that's what he was thinking about. He was doing that math. He was doing that math on what it would cost to divorce Ariel, what he would give up. And he just couldn't stop thinking about it. He couldn't stop thinking about this emotional affair that he's built up in his head. And because he couldn't stop thinking about it, he made a plan. He made his plan to kill Ariel. The beating. Plan C, the third substantial step, the one that's the most visible, the one where she got these injuries. The defendant took the rock. He picked it up. He swung at Ariel again and again and again and again and again. That many swings shows that the intent was not just to hurt, It was not just to defend. The intent was to end her life. That's what the number of swings tells you in this case. Ariel's only relief, the only thing that stopped him, was the defendant being caught in the act. It was the intervention of Amanda Morris and Sarah Bucksbaum. That's it. So we end with the confession. 10:42 a.m., just a couple minutes after this happened, the defendant calls Emil. It's a video call, not a phone call. So Emil could see what the defendant was saying. He could see the defendant's face. He could see the defendant's mouth moving. There's no gray area with this confession. As Emil testified, he has no doubt about what the defendant told him. There's no phantom gust of wind that came up. There's nothing like that. The defendant confessed to Emil. He told Emil that he tried to kill Ariel. He told Emil why. He told Emil that Ariel got away. He told Emil that Ariel was having an affair. That doesn't sound like a goodbye suicide message, does it? He told Emil that he was at the end of this rope. And think back to the last thing that the defendant told Ariel before he tried to kill her. He told Ariel, "I'm sick of this shit." That's corroborated that he's at the end of his rope. Same idea. What didn't he tell What didn't the defendant tell Emil? Nothing about self-defense. Nothing about Ariel attacking him. Nothing about what he testified to you. Is that reasonable? Does that make sense? No. 10:42 a.m., the defendant FaceTime video calls Emil. He confesses. And Emil's next step, after being put in that situation, after being put in a situation as a 19-year-old that he had no want to be part of, Emil does what he does. He goes and tells his grandparents. He goes and tells them what the defendant said. And Judith Mast, ends up texting the defendant. 11:33. She texts the defendant, "Is Ari okay?" She asks the defendant about her daughter. And the defendant says nothing. He doesn't respond. But what he does do shows his intent. What he does do, he calls Emil again, and he asks him, "Did you tell anybody?" That shows the guilty conscience of the defendant. That shows that the defendant was not acting in self-defense. That shows the defendant was thinking about what his actions would do to himself. He was thinking about himself. He wasn't thinking about Ariel. He wasn't thinking about her condition. It was only himself. So, ladies and gentlemen, there's one verdict and only one verdict that does these things. There's one verdict that holds the defendant accountable for what he intended to do, for what he tried to do to Ariel. There's one verdict that's supported by the physical evidence, the digital evidence, the corroborated testimony of witnesses, and the defendant's own confession. There's only one verdict that's corroborated that makes sense with all of that. There's only one verdict that the evidence and justice demands. And that verdict is that you find the defendant guilty as charged of attempted murder in the second degree. Thank you.
Gerhardt continues to shake his head. Not appropriate, but nobody's called him on it. The judge hasn't said anything. Rocky goes back to the evidence pile with a mountain of other evidence against him.
Thank you, Mr. Gardner.
And defense wants a little break.
This is our second morning recess. Ms. McCallum will come get you, I'll just say 11:10. We'll reconfigure the courtroom during the recess, and we'll come back. The defendant will have the opportunity to present the closing argument. All rise.
As they go to this next break, the prosecution used 45 minutes of their time. If they are given an hour, it's reasonable to think that in closing the rebuttal, they'll use another 15 minutes. But 45 minutes. I've got 46, just under 46 is what they had. Excellent closing. Hit the high points. So many times that we see prosecutors who try to relitigate the entire case in the closing, right? Cram all the evidence in, cram every bit of everything in, and he didn't. He just hit the high points, and he got all of them in, and he did it. He presented it in a logical fashion, in an orderly fashion, with other than his choice of colors on the PowerPoint, which is hard for most people to figure out. It was like the bright white on bright blue. Just that was a little difficult on the eyes, but other than that, I would give him 10 points on presentation. It's good because defense doesn't like it. Even had a couple objections during that. But the shaking of the head, I wish the judge had addressed. I don't think that's appropriate for the defendant to behave like that, and maybe they will address it. He did the high points, yes. Pacing was good. It was easy to follow, easy to understand the logic. He drew the connections he needed to, right? Especially, things like the FaceTime call with Emil. When the defendant is on the phone, he's like, it wasn't just Emil hearing something over the phone. He could see his dad's face too. It was the sound matching up with the movement of the lips. He understood what was going on. There was no doubt in his mind what his dad had actually just said. Great way to lay that out. Thank you to Motor Troy for posting the poll from earlier. Has the state proven the case against Dr. Koenig? Yes, 87%. No, 13%. That's with 1,600 votes in. We'll do another poll here in a little bit about jury deliberation time, but that's a pretty substantial result. 87% on one side. Head shaking for dummies by Corey Richards. I think the prosecutor also proved what he set out in his opening arguments. I think he did. He delivered what he promised, which is great. I'm sorry, this is a prank call. If you guys are new to the channel, you guys know that sometimes I get called by...
Call from Melissa from Hawaii.
Oh, it's not a prank call. Okay, I'm sorry. Melissa from Hawaii. I thought for sure it was a prank call because of the phone number, but how are you doing?
It's real. It's me. Hi, Scott. Hi, chat. Aloha, everybody.
Aloha. You are in you were just in the courtroom watching what we just watched, but you got a little different view of the prosecution laying out their main closing. Tell us a little bit about what that was like to watch that.
Yeah, the jurors were very intent, not really taking notes, but just watching. It was a nice presentation. They watched everything very intently. The defense, I don't know what you guys can see from your end, but I am behind his parents on the defense side, and lots of movement from Mr. Otaki. He likes to move constantly and kind of distract, it felt like. And then also the defendant was shaking his head often, and his parents also in front of me. So, yeah.
That's usually a no-no. Usually the gallery has to sit very still and not show any emotion one side or the other. So that should be addressed. Tell us a little bit about the jury. We've heard there are 7 women, 5 men. What else can you tell us about that?
Well, let's see. 7. What did you hear? Because I've counted 10 women and 7 men. Of course, we don't know who are alternates and what have you. There's quite a mixed group. Everything from a younger gentleman with like dark purple hair to awesome. an older woman, African American. So there's lots of local-looking folks. So culturally.
Good representation, wide. I love that. Yes. Tell me also, the jury has been allowed to take notes but not ask questions during this trial. Have you seen other parts of the trial, or were they allowed to take notes during this closing?
They are allowed to take notes. In the jury instructions, I think there was something about the notes as well. I did see them taking notes during the end of evidence. And before closings, everyone had their notepads out, almost all of them. But then during closing, they shut and were just listening.
Wow.
I've got to go.
Okay, all right. We'll let you go.
Yeah, I'm nervous.
All right, good luck. We'll see you.
Yeah, and I'll talk to you later.
Right.
Thank you, guys.
Bye.
Bye.
Let Melissa get back into the courtroom as they're getting set up for the defense to now give their closing, which is probably going to be markedly different than what the prosecution looked like. Prosecution sort of teased us a little bit with what we can expect to see with the minimization of the injuries. We can expect that in there. That's been prominent throughout this case from the defense, the minimization of her injuries. And obviously just a different version of events based on all these occurrences and try to spin this just a different way. But they do have to overcome the fact that he basically says everyone else was lying except him. Nobody else told the truth. The police, the two nurses, Ari, Emil, and I guess even his own doctor. So that's going to be fun. Thank you very much, Melissa. That's mahalo. Yes. Wonderful getting a little bird's eye view inside the court like that. So we'll give them just a minute to get set up, and she'll be back in. It's interesting about the jury makeup. It's possible that Kathy Russin knows how this judge does the alternates. They might be consecutive. So like the first 12 jurors to deliberate and the next ones are all alternates. If that's the case, that would explain the 7-5. But a lot of women on the jury, and it makes you wonder how many of those, look at some of this evidence, look at the testimony, and just say, based on my own experience, I just don't see that as true. Also the men on part of that as well. They both get an hour. They should get the same amount of time. And we have heard that if defense is arguing that extreme mental and emotional distress in their closing, that they'll get surrebuttal on that alone. So we'll probably hear from the defense twice, and them being the last person to talk to the jury. I know Tommy's going to want that in a heartbeat. I'm going to count mentions of an affair in Tommy's closing. That's a great thing to count. I think there will be a lot. Listening to defense whining for an hour is going to get under my skin. Yes, I am biased against him because I don't like whiny, sulky lawyers. It's a love-hate thing, right? I love a lawyer that fights for their client, and you've got to give it to him. He's fighting for his client. I'd rather have that than somebody who sort of just looks like he's just showing up to get a paycheck, right? But, yeah. This is going to be good, Zen. I agree. Wish the state said she wasn't on trial for having an affair. They might say that in their closing. They might wait for the defense to bring it up prominently before they do it in the rebuttal. Count how many testicles, or how often they're mentioned. So I'm guessing the count of them is 2. That's just my guess, but yeah, we heard a lot about that the other day. I recently cut my hair from my waist to my shoulders. I think purple is my next adventure. That sounds great. Send a picture when you're done. Love it. A couple people have asked about closed captioning. The way we stream, YouTube does not enable closed captioning because we have an extremely short delay between what I say and when you hear it on live. It's too short for the live stream to put closed captioning on. So I can't, unfortunately, do that. Maybe we'll develop a solution here going forward that can get that. I know that's a benefit to some of you, and I apologize, but the alternative is we have, you guys ask a question, and 30 seconds later I answer it, and 30 seconds after that you hear the answer. It just becomes difficult to have the back and forth, which we love here. But the state has the burden for proof, so they should go last, correct? Yes, except for this EMED. EMED is the only thing that Tommy gets to talk about last. Arms folded across his chest. Dr. Koenig not happy. Looks like attorneys might be up talking to the judge or setting up the courtroom, preparing for the closing. Everyone's coming back now. Just waiting for the jury. I hope the judge addresses the shaking the head by people in the gallery as well as the defendant. That's just not right.
5-373, Mr. President, call the lawful counsel of record. Jury is absent from the courtroom. Counsel, you want to see it. Mr. Garner, you wanted to take up objections to the defendant's proposed closing slides.
Yes, Your Honor. The first is on slide number 14 on page 5 of the printout that defense counsel has handed to both of us. It's a slide that says examples of deceptive behavior. I do believe this is impermissible argument that is essentially stating that Ariel has been deceptive in the past. It's an argument that is trying to make a 404 argument that says that she is deceptive now. That is the one reason under HRE 404 that you cannot use prior bad act evidence for. It is explicitly stated that you are not allowed to use prior bad act evidence to show conformity therewith, and that's exactly what this slide is attempting to do. So we'd strenuously object to introducing this, using this slide, using this argument that is against the rules of evidence. It's asking the jury to consider something evidence for an inadmissible purpose. So I do believe that's not appropriate. And that's the first objection.
We'll start with Mr. Siriano. Mr. Otake.
Your Honor, obviously her credibility is at issue, and there's been multiple examples in this case that has come up in the evidence about deceptive behavior, and it is critical, obviously, that we be able to point that out. So I've never heard of, we can't point out in closing how a complainant has been deceptive or dishonest. I mean, he just spent half an hour saying how Gerhard was dishonest. So obviously that's fair game in any closing argument.
Anything else you want to add?
The issue is not commenting on the evidence. It's inviting the jury to not follow the law. That's the issue here. They are allowed to comment on the evidence that was introduced at trial, and I understand that. But what this is asking is not that. It's asking the jury to consider this evidence as, again, under the only improper purpose under 404B, conformity.
State's objection is overruled. The defendant will be allowed to argue the complainant witness's credibility. It might be inadmissible under 404 with no exception of 404B, but there is the avenue of admissibility to have found credibility with specific instances of conduct in those 608. So the state's objection is overruled.
The other objection from the state is somewhat throughout the defendant's proposed closing argument. There appears to be snippets of transcripts. And they appear to have been, some of them highlighted, some of them not. As the court and everybody here is well aware, the jury will not have transcripts available when they go into deliberations. They won't, and these transcripts are purported to be of the testimony during the trial. So they're not transcripts that were identified as exhibits and introduced into the trial. They're transcripts of the testimony of the trial. Everyone's aware the first question the jury always asks after going to deliberations is, can we have a transcript of the witness's testimony? And the answer is always, transcripts are not available. So it's not fair to the jury. It's to put these essentially unmarked exhibits into the PowerPoint. It does give undue weight to what that is, especially consider the jury is instructed to remember the evidence on their own rather than what a court reporter may have written, that it essentially gets around that instruction that the court gave to the jury. It puts undue weight on only these portions that the defense wants to put weight on. So I do believe it's not appropriate for transcripts to be referenced, trial testimony transcripts to be referenced in closing argument.
Can we drill down on that a little bit more, Mr. Garner? The real objection is the form with which they're displayed. Because if it wasn't question and answer, and it was just not even the paraphrasing, if it was just the verbatim testimony without the Q&A descriptions, that would not be objectionable.
That's correct. And that's why putting it in, this format with the new Courier font, when it's clearly a transcript written by somebody else, gives it undue weight. It takes away that.
Sorry, it's not the font. Only we know it's Courier font. But it's the format of the Q&A.
Yes. That's the main reason.
Okay. Mr. Otake.
Your Honor, I've done this in many trials. It's pretty commonplace. I've done it in civil trials. I've done it in criminal trials. We took the time and money to order the dailies, and it's what was said in court. It's the best evidence of what was said. And I'm just, whether it's in that format or another format, it's the same substance. There's nothing improper about doing this. I've done it many times in many courts. They had the option to order the transcripts and use their government resources to pay for it. They chose not to. And so this is what was said in court. And I'm not taking it out of context. I'm not going to argue it inappropriately. You know, I'm not going to, I mean, it's just what was said. It's I don't know if, I mean, what font it's in or what, like, it is what was said. And we chose to order it and pay for it, and I've done it many times, and I'm not aware of any rule that says we can't do this. So I'm asking that the objection be overruled and we get on with closing.
Anything else you want to add?
No.
Slides with the transcripts, and they are in fact transcripts, there's no dispute about that, are
not allowed.
They're the actual transcripts as represented by counsel. It's not a misrepresentation of what was said. It's not even a paraphrasing of that. Well, I'm uncomfortable about the form. At this point in time, I'll overrule the objection and allow the parties to proceed.
Thank you.
They're allowed. Wow.
What has been provided to court will be made part of the record to document the state's objections. It will be court's exhibit 1 for trial.
And Your Honor, I did show the state some demonstratives. I would like, I don't believe that an objection, but it's going to be facing away from you, so I'll show it to you now. Please. This is the first one. Accurately describes page 2 of the instructions. Okay. And then
that's the reasonable doubt.
Oh, shoot.
He just broke it. He just broke it. Like, I just spent $100 on that. I broke the corner.
To these two demonstrative aids, no objections.
Anything else we should take up before the jury returns?
Burden of proof. Now it's a big
no, Your Honor.
dented corner.
Actually, can we approach really quick? Sorry. On the record, it's fine.
Off record?
On record.
All right. Approach really quickly on the record. And we're about ready to start. The defense won the objection battle there. The state objected to a couple things. The judge struck down both of them. So defense is going to be able to present their closing the way they would like. They're going to be able to point to prior deceptive behavior by Ari. I just say tread carefully there. You might really find yourself turning off the jury really quickly. I think the jury liked Ari, and you come out swinging like it looks like you're about to, Tommy, and you might find yourself with an uphill battle, facing stern looks from the jury for the next hour. All right. Let's see. Trying to keep track of a couple world events going on as well. So interesting. All right. Yeah, Pickles, not politics. There's just, I'm getting word of some significant plane movements, U.S. military-wise. That's all. So we're just trying to track things in the background and see what happens. All right. What a day. What a day. Don't ask, Greeners. Don't ask. I just pulled up my flight radar, just keeping track of, the skies right now. That's it.
Remember in the beginning when we started 110 years ago?
110 years ago. Waiting for the jury to come in, and a very keyed up Tommy Otaki is going to kick off his response to the state's closing, which was epic. And honestly, he has to. Hello. I'm still under an NDA. I can't talk about it. Yeah, we won't. I'm just watching. He has to hit it out of the park because the state did a really, really good job in their closing. It was very easy to follow. I think the jury ate it up and were with him every step of the way. Now he's got to get up and he's got to undo the ground the state made, the state gains, and then recover the other. So we'll see. Man. Was the state that's good? It was. I would say it wasn't the best we've seen, but it was darn close. It was really good. It was really, really good at doing a couple things, mostly just summing up the evidence, putting it together, making it make sense, and hitting home the key points. So, ooh. Whoa, that was close. That was close. I think we just about saw a juror member. Yeah, let's stick to the case, please. Let's stick to the case. This will probably rile a few of us up because we've seen Tommy before, and his style is somewhat abrasive. But I'm here for it. I want to see how he comes out swinging. If he goes for the fences, if this is going to be his home run from the get-go, or if he builds up slowly to a huge crescendo.
All jurors are back in the court. Ladies and gentlemen, thank you very much for your patience. Before we hear from Mr. Otake, the argument that the state made about justice requiring a particular verdict that Mr. Garner made right before we ended is stricken from the record. You are to return a verdict based on the evidence that's presented, or the lack of evidence, or reasonable inferences therefrom, as well as the court's instruction on the matter. Mr. Otake, are you ready to present the defendant's closing argument?
I am. Thank you, Your Honor.
Misstatement of the law.
Good morning, ladies and gentlemen. I want to begin by thanking you all for your time and dedication to this case. Most people serve on juries, 2-3 days. You guys have been here for close to a month now, and I want to just express heartfelt thanks for that. It was your time and doing that made sure that Gerhard got a fair trial. That's what this was about, and we appreciate your time tremendously. We're at the end of the trial here, but I want to actually circle back to the very beginning. The very beginning, jury selection, and remind you guys about that. Multiple days, started off with 200-something jurors, whittled it down, excuse after excuse, people couldn't be here, couldn't be fair, couldn't set aside what they heard, weren't willing to give him a fair shake. And we whittled it down to less and less and less, and we ended up with the 16 of you here. And it wasn't by accident. It wasn't by accident. It's because we saw in you what we were looking for. Jurors that would wait until you heard everything. Jurors that weren't going to convict somebody based off of media reports. Jurors that weren't going to just look at one side of things. Jurors who had logic, reason, and common sense. And most importantly, jurors who had integrity to follow the law on reasonable doubt.
Objection, move to strike. None of this is evidence.
Sustained. Please continue.
So I'd like to move to strike the entire closing argument up to this point.
Sustain the objection. Mr. Otake, please continue.
The whole intro just got struck.
We went through that process. You guys promised us you would do certain things. And we knew that you would. Now, I'm going to walk you through the evidence and the law today, and it'll be clear that there's reasonable doubt all over this case. All over this case. Before I do, he wants to, whole unwilling, unfaithful, unwilling, untrue. We talked about that. He wants to say unbelievable. I'll add another unword. Undeterred. They're undeterred by the evidence. It doesn't matter what it shows. They're going to spin it in their favor. They came up with a theory and they went to search for facts to support it. They didn't look at the evidence and say, what's the theory that points that out? They came up with a theory and they tried to find any fact they could to fit it. They were undeterred. Undeterred by the DNA. The DNA shows, and I'm going to go through it, she's holding the rock. She's a trillion level DNA on the unstained side. Undeterred. Oh, must be because when she was blocking. Undeterred. The computer, I have to call Inuma again to say that sometimes the computer accesses these files. Undeterred. Still shows that he's looking at this credit card statement from 2018 to show that he has a financial motive that is cheaper to kill her than divorce her. Undeterred. Undeterred by the fact the eyewitness picks the wrong person out of the photo lineup. And still, she stared at him, looked into his cold, dark eyes, saw him very clearly. Picks out the wrong person. Undeterred. Undeterred by the bruise on his face. Oh, maybe it's dirt. Maybe it's dirt. Evidence should lead to theories. You don't come up with a theory and then search for evidence to spin it to fit your theory. That's what happened in this case. You know, ladies and gentlemen, I'm going to go through just some of the law initially, and then we're going to come back, go through all the evidence, and then I'm going to come back on some other parts of the law. So I want to start off first by reminding you, as you know, you took an oath, right? You told us that you would give your word that you would follow the law. You'd follow the law, and we know that you will. I want to start, you can follow along in your instructions if you want. I'm just going to start on page 2. Page 2. You know, I talked to you at the beginning about these 3 principles of justice and fairness that keep our system safe for all of us. Anytime the government waves its accusatory finger at anyone, these principles kick in, and it's a safeguard. It's a safeguard, and that's summarized on page 2. You must presume the defendant is innocent of the charge against him. This presumption remains with the defendant throughout the trial of the case unless and until the prosecution proves the defendant guilty beyond a reasonable doubt. The presumption of innocence is not a mere slogan. Not a mere slogan, but an essential part of the law that is binding upon you. It's binding on you. It places upon the prosecution the duty of proving every element, material element of the offense charge against the defendant beyond a reasonable doubt. Now, I'm a visual learner. I had this chart earlier to help you guys understand how that works. We talked about how the presumption of innocence, you don't start in the middle. You don't start in the middle. It requires that you start here. You start here. It requires that. And then there's a gap, and it's a proof gap. This has to be filled with proof beyond a reasonable doubt before you even step this way. Before you even step this way. If there's no proof beyond a reasonable doubt, you don't move. You don't move.
If we're playing
and
hangman, you've almost lost already.
Is. You must not find the defendant guilty upon mere suspicion or about evidence which only shows that the defendant is probably guilty. Probably guilty is not good enough under the law that you took an oath to uphold. What the law requires, ladies and gentlemen, what is required by law before the defendant can be found guilty is not suspicions, not probabilities, but proof. And think about that word. It's a strong word. We don't pay enough attention to that word. Proof. That's a powerful word. Proof of the defendant's guilt beyond a reasonable doubt. That's the law.
You've got
probably not enough. That's the law. Again, visual learner. I have a chart to help you with this.
It's broken. Please disregard
this
the
chart
dented
summarizes
corner.
page 2 in a more simple way. State's burden. It's their burden, right? We talked about they brought the charge. Make no mistake. This is not Errol Koenig versus Gerhard Koenig. This is the state of Hawaii versus Gerhard Koenig with their resources, the police force, their computer experts, their everybody. Their burden. State of Hawaii versus him. This is their burden. If they only provide, if obviously 100% you think he's not guilty, not guilty. Probably not guilty, not guilty. Possibly not guilty, not guilty. Maybe not guilty, not guilty. Maybe guilty, not guilty. If you're like maybe, maybe not, if you're left thinking, I don't really know what exactly happened, maybe, maybe not. If you're here, not guilty. Possibly guilty, probably guilty, not guilty. That's how high the burden is. It's a safeguard against convicting innocent people. This is what you took an oath to uphold. I'm going to circle back to this, but this is what you told us you would apply. Now, I'm going to go through more of the law later, but just very quickly, the law on attempted murder, the elements are on page 14. Page 14. Before we go through the evidence, page 14. Second paragraph. A person commits the offense of attempted murder in the second degree if he intentionally engages in conduct which, under the circumstances as he believes them to be, is a substantial step in a course of conduct intended or known to cause the death of another person. That his intentions was to kill her. That was his intentions all along. That's what they have to show. It goes down, paragraph 1, the elements. The defendant intentionally engaged in conduct. And 2, the conduct under the circumstances as the defendant believed them to be was a substantial step in the course of conduct intended or known to be practically certain by the defendant to cause the death of Ariel Koenig. That's what they have to prove, more than maybe, more than possibly, more than probably. That his intention and his knowledge was practically certain he was going to kill her. That's their burden. That's what they have to prove. We'll come back to this. There is an instruction on self-defense. I'm going to talk about that at the end after we go through the evidence. They are the included offenses. I'll walk you through those as well. But let's now look at the evidence, and it'll be clear there is just massive amounts of reasonable doubt. So the first thing, one second here.
Laura, that's hilarious.
This issue about, was this planned? Okay. Was this planned? This big plan, he just went through this motive, that Gerhard Koenig, you got to know him, that he came up with this plan in late December, that it was going to be cheaper to kill her than divorce her. Was this planned? Let's look at the evidence. Is there a reasonable doubt about that? Let's walk you through that. First of all, she brought up the idea of going on a trip to Oahu. That was her idea. Why would that be the plan? If you're planning on killing somebody, you're an anesthesiologist, you have access to, as they fault him for being a doctor, I'm going to get into that a little later, having these things at home that he uses to save people's lives, that your plan is, let me not stay on Maui, where there's probably 800,000 less people and more secluded areas. Let me sneak syringes through TSA onto an airplane, come to the busiest island there is in Hawaii, 1 million people, go to a place, a trail, a parking lot I've never been to, that I'm not familiar with, and in broad daylight, 4 minutes from a very busy parking lot, I want to try and kill her. That's the plan? That makes absolutely no sense. Logic, reason, common sense. Why would you do that? The life insurance issue. Well, this is the busy parking lot. So, I apologize. You saw this in, this was the plan, to come here. With all these cars, all these people, he says 99% don't hike or whatever. He didn't know that. He put in here, this is the plan, according to them. That he's going to come to this unknown place with all these people, all these cars, and try to kill his wife, instead of just doing it on Maui. That's the plan, according to them. The life insurance issue. Now, this shows two things. I mean, we're going to get into later about how he told her about it that morning, and she learned that morning if something happened to him, she would get $1.5 million. But it's relevant in another way. If in December and January and February, you're planning to kill your wife, why are you going through the process of obtaining $1.5 million on your life for her? That's not the sign of somebody plotting to kill somebody. That's a sign of somebody trying to work on, okay, look, we got to figure this out for our kids, and if something happens, there's, He's not planning to kill her. Now, the birthday card. He writes this morning. It's the only time she got emotional because she knows it was genuine. And I'm going to talk about that more later. He writes this. There isn't an obstacle in this world too hard for me to fight through for you. I would take on anything just to see your smile. You're one of the kindest, most giving, and selfless people I know. Selfless people I know. Putting others before yourself. So much love. You're the heart of our family. Fun, fearless, and a terrific mom. The kids and I hit the jackpot with you. He meant that. You don't write a letter like this because if your plan is to kill somebody 2 hours later. There was no plan. There was no plan. The Fed reservation. He made a reservation to go to dinner that night.
You don't make dinner.
Not planning on killing anybody.
Kill someone.
There was no plan.
Unless
this is from that day. They're having a great trip. You know, they had gone through some rough times, but they were making some progress. In part because they weren't really talking about it. And that's why she felt comfortable. She didn't, I'm not saying she was trying to hook up with Miller again. She wanted to travel for work. And that's why she felt comfortable bringing it up. Hey, we've been making progress, but, you know, I got to travel for work, you know. And then she says, you know, my mom can come with me. That's what Garrett told you about. So this is them on the trip, right the day before. This so-called big plan. There was no big plan. Now, why are they committed to saying that there was this pre-plan and financial motive? Well, because of course. It makes no sense anyone would have syringes on this hike unless this thing was pre-planned from earlier. So they have to stick to that, even though it makes absolutely no sense. There was no plan. And I got to tell you, you know, I got to tell you, okay, when they get into the fact that in like December or whenever it was, there's a text message where she's like, are you coming home soon? And he's like, this lady just got hurt on a hike and a rock fell on her, so I'm trying to like save her life. The fact that they're trying to say that at that time, the light bulb went on in his head and he was like, I got it. I can kill her on a hike with a rock.
Objection.
I mean, that's ridiculous. That's ridiculous.
And a move to strike.
Granted, that's why
Okay. Well, that's what he was pointing out. Okay.
Objection again to improper arguments.
It's a state. Well, remember it anyway. Look at that.
The idea that he came up with this plan because he was trying to save a patient's life who was hurt with a rock on a hike is ludicrous. So, ladies and gentlemen, as much as they want to avoid it, as much as they try to talk about witnesses and corroborations, the reality is this. What happened on the mountain before the hikers got there, it is essentially she said, he said. The witnesses told you. They didn't see much. One witness only saw one hit. The other didn't see a hit at all. One of them picks out the wrong person in the photo lineup. Okay? Everything before that, they told you they can't say what happened. They don't know how it started. It's she said, he said. Now, by the way, these witnesses who apparently stood there and stared at him for 30 seconds, looking into his deep, cold eyes, they didn't see no syringes on the ground. You know the one she says she flicked out of his hand that landed right there? They're nurses. They didn't see that because it didn't happen. The point is, ladies and gentlemen, when it's your burden of proof, it's this high, and it is she said, he said. Your she said. Better not offend logic, reason, and common sense. Better not offend be contradicted by the physical evidence. Better not be highly motivated. Better not have examples of many times where she was deceptive to the police and to you. And all of those are present with her testimony. I'm going to walk you through that. Now, logic, reason, and common sense. The bottom line is Ariel Koenig is not reliable. She's not reliable. We talk about credibility. The question is reliability. Okay? Logic, reason, and common sense. We don't ask you to leave that at the door. We want you to bring that in here and look at what was said. Let's look at what she said, right? I mean, basically she's saying she wouldn't take the selfie, and then he was like, I'm tired of this shit. Let me throw you off the cliff. And then he tries to stab her with a syringe as he's loading it first, and then he bashes her up to 10 times. That's her story. Okay. First of all, the way she describes it makes it sound like he had multiple arms, like an octopus. She says that she's covering, he's on top of her, covering her mouth, and then he has a syringe, And then he's loading he has a vial, and he's loading it, but he's holding her down.
Misstates the evidence.
Can we approach, Your Honor?
Sure, come on.
Oh, that was a rare sustain. Sustain misstates the evidence. She did not testify that he was trying to load the syringe. That he was trying to load the syringe. That was not what the testimony was. She said, I don't know. I didn't see where it came from. And got a rare sustain, and Tommy is not happy. Not happy. Okay, let's see. Give him a minute here. This is not going well. Tommy already had his whole intro struck from the record. Two more. This is the fourth objection sustained during his closing. Rare to see that. Usually you hear the judge say, closings are not testimony.
Is, why would you have a vial unless you're trying to load it? He has a syringe in his hand. The other hand, he's holding her mouth. He's down on top of her, doing all of this while she's supposedly kicking and fighting. He only has 2 arms. And in the middle of it, they're having a full conversation. Your mom's not going to be very happy if you do this. You know, the kids aren't going to be, you know, her story makes no sense. Now, logic, reason, and common sense as we look at her story, and it is a story, okay? If we look at her story, why, if this was a big plan that someone's going to bring a syringe to incapacitate somebody and stab them to make it easier to throw him off the cliff, don't you think they would load the syringe ahead of time?
He might have. Defense didn't win.
Don't you think they would load the syringe ahead of time? Their story is that he's that's the plan, and in the middle of it, he's like, oh wait, I gotta take out this vial and get it ready. That makes no sense. Especially given the fact that it's undisputed, he had just gone up the mountain by himself for 10 minutes. If he had it and wanted to use it, he could have loaded it. It makes no sense because it didn't happen. It didn't happen. The other thing, and I'm glad he brought up this thing about plan A, plan B, plan C, because it proves the point I was going to get to. Why in the world, if you bring a syringe to incapacitate someone to make it easier to throw them off the cliff, why would the syringe be plan B? It would be plan A. You would use the syringe first, and then you would throw them off. You wouldn't start the scuffle and make that, start this scuffle and then be like, oh wait, now I'm going to stab her with the syringe. That makes no sense. It makes no sense that, that's the plan. He knows if something like that happened, he's a doctor, a toxicology report would show propofol in her thing, in her blood, that this is
not in evidence.
It makes no sense that he would start the scuffle before using a syringe if that was his big plan. Because it didn't happen. This idea that she could just flick the syringe out of his hand. He's holding it tight, according to her. He just flicks it. None of that makes any sense. This idea about, well, he hid evidence. The rock is found right there. We don't know exactly where because HPD should have photographed it before they moved it. But why would he get rid of the syringes and leave the rock? None of that makes any sense. And then, of course, we get into him leaving her on the mountain. Leaving her on the mountain. If this is a big plan to use this hike as an opportunity to throw her off and kill her, why would he walk away and leave her there alone thinking he's going back to the car? And they're trying to say, well, all kinds of things about that. But the reality is this. If you think, even though it's not true, if he went off on his own, because if she said, well, it's too high, I'm getting a little scared, and his plan was to kill her, he wouldn't leave her. He would say, okay, you know what, that's fine, but let's just at least go over here and take a selfie and then try to throw her off, right? He wouldn't have left her for that reason. If he was planning to try and throw her, he would have stayed with her. And then her rationale, to get around the idea that, undisputable, that she clearly said, when he got back, she told the detective that he said, oh, you're still here. He was surprised that she was still there. She says, well, he knew I meant I was going to go exploring in that area. Where was there to explore? We heard from witness after witness. It was you either go up or you go down. You don't go off and go exploring. That was her way to try and cover up. That it was clear he left her thinking she was going back to the car, which you wouldn't do if you had a plan to kill somebody by throwing him off the cliff. PSA, we've all been through it. Sharp metal syringe objects, sharp objects, not going to work. Not going to work. Logic, reason, common sense, that he has this intent to kill her, but then he lets her crawl away. He lets her go down to the witnesses. Doesn't come after her. Doesn't make any sense. Her demeanor. They say, oh, she was very matter of fact and just told it. Ask yourself, if someone's describing what should have been the most horrific thing they've ever been through, bloody murder, someone's trying to stab you with a syringe, a monster's trying to throw you off a cliff, when you're recounting that, you might get a little emotional. Not at all. And she's not just someone who doesn't get emotional, because we saw her get emotional when we showed her the card. When she read the birthday card, she got emotional. I submit to you that was probably guilt, but whatever it was, she knew it was genuine, and she showed an ability to show emotion. That was real. The card was real. You cannot get emotional over a made-up story that didn't happen when you started the fight. Reasonable doubt. Logic, reason, and common sense. Now, Ariel's story contradicts the physical evidence. It just does. And this is a huge problem for them. And they try to come up at the last minute with, well, maybe when blocking it, her DNA got on it. But let's talk about that. Because we're talking more than probably, right? You know, he wants to say maybe blocking her DNA got on it. Maybe. Okay. But let's use our logic, reason, and common sense and look at the physical evidence. What does Scott Henderson say? The DNA guy. Generally, yeah, you could expect higher likelihood ratios with the more DNA that's present in a sample. The more DNA present in the sample, you can expect a higher ratio, yes? Generally speaking, yes. The more someone's DNA is on the sample, the higher the number. Higher the number.
So if she got hit
He
in the
then
hand with
goes
the rock,
on, we learn from him and Amarin,
there'd be a
that,
big sample.
very important, the rock. The rock. Swabbing from the unstained area. There was a stained area that looked like blood, and there was the unstained other side. They swabbed the blood. They tested. Of course, it's Ariel's blood. I told you that in opening statement, right? The blood side was Ariel. The unstained side, they don't test for blood. They test for human skin cell touch DNA from people holding objects, they told you, okay? The unstained side had a profile for two people, Ariel and Gerhard. Ariel's number was 1 trillion. His was 290. Let's go back to what Henderson said. The more DNA present on the sample, you can expect a higher ratio. Yes, yes. 1 trillion to 290. The rock was in her hand. The rock was in her hand. The DNA shows that. That blows away her whole story. That she didn't have the rock. The rock was in her hand. Her DNA is all over that. This idea, well, maybe when she was blocking it hit her, that's not going to lead to that much of her DNA on it, more than him.
Objection, speculation.
If he's holding the rock the whole time and she's just blocking, there's going to be more of his DNA than hers. She was holding the rock, and that blows away their entire theory.
So you're saying she hit herself in the head?
Scientifically, I asked Amarin, what about scientific evidence, Miss Amarin? And we talked about it. It's unmotivated. Scientific evidence is not trying to get full custody. His retirement. It doesn't lie. It is what it is. And they may say, well, maybe it was there because of this. Again, maybe, maybe not. A huge reasonable doubt. A huge reasonable doubt. She had the rock in her hand. 1 trillion to 290. Now, the other thing about the physical evidence is the injuries. They want to say, we heard about the stellate laceration. I'm going to talk more about it later. But it has one point and it spreads, right? And you heard. She at the end said she doesn't know how many times she was hit. The doctor, Grosjean, said 2, maybe 2. I cannot say how much more. Dr. Arden says 2 to 3. Okay. If she was hit 7, 8, 9 times with all his might, it would be way worse. Physical evidence doesn't support her version of events. Also, if she's under attack, she's going to be scratching, doing biting, as she says. He has no scratch marks, defensive wounds. There's no bite mark on him, even though she said she bit him. The physical evidence doesn't support her story. And that's a huge problem when it's this she said, he said, and this is your burden. That's a huge problem. Further problematic is the examples of deceptive behavior that we saw through her. Many examples of deceptive behavior that makes her unreliable. We heard about her deleting the text messages to hide it from her husband, to hide the extent of a relationship. That is inherently deceptive to do that. That's inherently deceptive. Now, the affair. Look, I'm not the morality police, okay? I'm not here saying she's an awful person because she had an affair. That's for you to decide, okay?
Objection.
The relevance.
Objection. That is not for her.
And move to strike.
Last argument of morality is stricken from the record.
The relevance of the affair is
not for
primarily
them to decide.
that she lied about it to the detective. The context is showed in the relationship in January, February, and December, but the relevance is she lied about it to the detective. And that is incredibly important when it is she said, he said, and is proof beyond a reasonable doubt. Let's look at this. This is, he said, well, she describes it to the detective as just some flirty text messages. He says, well, there's nothing in the text messages about sex. Well, she deleted most of them, so we don't really know what's in there. But we do know what we saw. On the trip, the day before he's going to confront her, this is at 11:22 p.m., presumably Hawaii time, or maybe it's California time, whatever, but it's late at night. She's sending this to Jeff Miller. Jeff Miller is sending her this. They have a nickname for Gerhard, HALEU, which is that radiology, nuclear, whatever. They call I have HALEU. They have a code word to let each other know when he's around. She's listening to an audiobook, How to Help My Spouse Heal from My Affair. That's what she's listening to. He says to her, you're engaged and continue an elaborate secret affair instead of coming to me asking to work on our relationship. And her response is, if anything, I learned how stupid it was this time and I know how to make sure it doesn't happen again. That's her response. Okay? Now, to the detective, no affair, just some flirty text messages. To you guys, no affair, just some flirty text messages. You saw 12/1, December 1st, all day long on a Sunday. Good morning, all day long, all day long, all day long, good night. And that's how she says it to the detective. She was misrepresenting, deceptive, and lying to the detective. Further examples of deceptive behavior is what she does with her primary care doctor and the records. After the fact, she tells her primary care doctor in an email to can you add traumatic brain injury? I want to make sure the documentation is consistent between my care at Queens back here in Mount. And that's the important part. Why is that important? Because, number one, she says she doesn't recall reviewing the Queens records. The Queens records doesn't mention traumatic brain injury. Ayden told you that, don't you think if traumatic brain injury was in her Queens records, they would have asked Grosjean or Carlton Whitney that? It wasn't in there. So this shows she is not just asking the primary care doctor to do this, she's deceiving the primary care doctor into believing that the Queen's record said traumatic brain injury, so the PCP will be like, oh, okay, I'll add it. It's deceptive behavior. It's incredibly misleading. Now, she says she's surprised about the work bag. She's surprised about the work bag. Oh, I didn't know. She knew he had it there. She knew there was syringes and vials in there. She calls her attorney. And then they turn it in and say, oh, surprise, look what I found. She knew it was there. She knew it was there. She lied about that. She lied about her affair. She lied to her primary care doctor. there is I really like quotes. So there's an author, famous author, by the name of Samuel Clemens. Most of us know him better as Mark Twain. Mark Twain was giving a speech once to some young people about the dangers of being untruthful. And what he said was, you ought to be very careful about lying. Because once caught, you can never again be, in the eyes of the good and the pure, what you were before.
Objection to improper argument.
You guys come in here, you give people the benefit of the doubt. They come in here, you say, I'll hear them out. And then they lie about different things, they deceive. In the eyes of the good and pure of all of you, you can't look at her the same again. It's dangerous. It's dangerous. If she's going to manipulate her PCP doctor, if she's going to be deceptive to the detective, do you think for a second she would hesitate to be that way with you? And then we get into bias, interest, motive. We talked about this. How she knew a divorce was coming. She wanted full custody, how they're using these allegations against him to get full custody, to make it where he can't ever see his kids again, to get half his retirement, to get all of the house, things that she might not get. She knows that. She said to you that their statement is, we want full custody, but if depending on the outcome of the case, that can be revisited later. She knows the ramifications. Now, let's compare that to Mr. Gerhard, Dr. Gerhard Koenig. You got to see him. Trust your gut. Trust what you know about people. Is he somebody that is a monster that came up with this plan to stab his wife and throw her off a cliff? Is that the sense you got from him? Or was he a hurt human being struggling with infidelity but trying his best? They talked about his parents, how they moved from South Africa when he was young. He worked really hard to become a doctor. He talks about, oh, he was trying to control everything about her. All of this awful controlling guy. What does she say? Prior to December, you generally describe your marriage as good, right? Yes, sir. This is what Ariel said. You don't describe your marriage as good if somebody is a controlling, coercive, violent person. There's a lot embedded in this. You don't describe it as a good marriage if unless they're a good dad. Look, domestic violence is horrible. There's some awful men out there that use their power, control, financial means to control women in improper ways. This is not him. That's not him. She wouldn't say it was a good marriage if he was like that. His version of events, they fault him for wanting to see her phone and things like that. The audiobook said that's what it takes.
The book
this
is
our
do it.
I asked you earlier, you understood the audiobooks you're listening to by these professionals says to give up privacy, give up access, get them to trust again. She says yes. They're faulting him for the professional advice, what is said. He's not trying to deprive her of her career. He's trying to stop her from seeing the guy that she had an affair with. He was fine with her getting another job. That's a very human thing. Why would you be okay with her going back to work with the guy that she had an affair with? Now, he went into detective mode when he found out about the affair. That's a very human reaction. Very human. He was on the computer looking up Reddit and infidelity and getting some advice. It's not easy when your partner cheats on you. He's struggling with it. They're making some progress in January and February because counseling, she turns it not about the affair, but about other issues. But they're making progress. They're kind of heading in a good direction. They go on this hike. And it makes sense that at that hike, she brings up this issue. Again, not that I want to be with Miller, but hey, I got to travel for work. Okay, I got to travel for work. And this is a detail that you just can't make up, right? He says, Then when they're fighting about it, she said, well, my mom can come with me to chaperone. He leaves her because they got into a fight, not because she's afraid of heights. She goes on all kinds of bungee jumping hikes all the time. He comes back and he's like, oh, you're still there. He described to you what happened. He's not saying, oh, he grabbed me and pulled me down. The scuffle started on this mountain trail and they ended up on the ground. Whether they tripped or fell, whatever, he ended up on her. And then he told you how she's grabbing his testicles. And she admits to it. And then I also squeezed his testicles. That's her testimony. It was all happening so fast. You know, we spent a lot of time going through it all. That's not real life. In real life, you don't get hours to be like, okay, and then you did what? Well, why didn't you do this? Well, did you consider that? Did you consider doing this with the rock instead? It was happening in seconds, and he reacted, and he had a reflex, and that's human. That's human. That's human. He reacted. And then he felt horrible about it, and he told you about that. He never wanted to hurt her. Never. He felt terrible about it. He was shocked that he could even do that to her in that moment. He felt horrible. The physical evidence supports his story. The DNA, and I'm going to get into the medical evidence a little more in a second. You have this, which apparently might have been dirt. Undeterred, might have been dirt.
It washed off the next day.
You have a cut? You have bruising? Right where he said he was hit. Reasonable doubt.
Right where the police say he hit the ground.
The FaceTime with Emil that they call a confession. There's no assurances of reliability. He explained to you what happened in that call. We need to consider it in the context in which it took place and ask ourselves, is this a reliable, thing that happened that we can rely on? Two highly emotional participants in the phone call. One is suicidal. One is thinking his life is over. He's very emotional, calling his son to say goodbye. The other, obviously, not blaming Emil at all, incredibly emotional. His grandma said she was shaking, crying. Two very, very emotional people. Then you look at the environmental factors. He's on the side of a cliff. And they made it a point to get the HPD officer to say, it's very windy over there, notoriously windy. Very, very windy day, according to the police. He's on speakerphone on the side of a cliff, talking. And he told you what he did. He was explaining to her, look, she was having this affair. She got hurt. This is her blood. She crawled away or got away. She crawled away. And she said, I tried to kill her. He was telling her that's why he was going to end his life.
She got away.
He wasn't confessing. He was telling her that's why I'm going to end his life.
She got away? You
Now,
said she got away.
We know this is his testimony. So as you sit here today, there's parts of the exact wording and timing of what was said that you don't quite remember exactly verbatim, word for word, correct? He said yes. He cannot tell us exactly word for word what was said. And then we have an example of him making assumptions. He first tells the detective, my dad said he tried to push her off the cliff. That's what he assumed. Not blaming him, that's what he assumed. But later on in the conversation, in the interview, the detective asked you about that, and he clarified, he said, the part about her pushing her off the cliff was what you assumed he meant, not what he actually said, correct? He said, oh yes, correct. So we have an example already of him saying something that he assumed that was inaccurate. He wants to say, it was so clear at the end of his redirect, he said, without a doubt, I know what was said. Do you recall how he had to try 4 times? The first 3? Emil said, yeah, I was confused. I'm kind of confused. And he asked again, yeah, I'm kind of confused. I'm kind of confused. And finally, Emil understood what the prosecutor wanted him to say and agreed. I'm not faulting Emil at all. Okay, this was a misunderstanding. The second call shows that. Gerhard calls the second time, and he wasn't saying, why'd you rat me out? He was saying, wait, what? You told Ariel's parents I tried to kill her? Oh, I gotta go. And he was gonna go kill himself again.
It would be for the first
time. This idea that he wasn't giving Ariel the blow-by-blow Emil the blow-by-blow what happened. He was trying to say goodbye to his son. This is not a confession they're making it out to be.
Well, he sucks.
I just point out to you, it's not his fault. He's lived with Ariel the last year. He wants to be on Maui. He likes it here. He knows the only way he can stay here is living with her. We talked about her and her actions with the detective and the primary care doctor. He understood what the prosecutor wanted him to say after the fourth try. This was not a confession. Gerhard's actions after the incident, they want to say it's consciousness of guilt. I say it's it's proof he's human. He went into deep despair, deep despair. He couldn't believe that he could cause that kind of harm to the person that he loved, and that can coexist with defending himself in the moment, in that reaction. He felt horrible about it. He went into where he was suicidal. What he was saying to Emil on the phone was, I gotta go, I don't want the police to find me, is because he wanted to keep open the option of killing himself, which was turning to be harder than he thought. He didn't want to get caught at that time because he was still thinking about jumping and killing himself. He wasn't evading the police for the purpose of, I don't want to get caught. He wanted to be able to kill himself and have that option. And we'll talk about when he turned himself in later. And that's why he did what he did with the SIM card. He didn't want the police to find him because he was thinking about killing himself. And this idea that in the middle of this suicidal place of being super emotional, that you open your SIM card, you bend a paperclip, open it, and you're going to take the time to put it back where it was instead of just leave it over there. It shows he's human, that he felt terrible about this. He told you how bad he felt. And that can coexist with self-defense. Now, this idea that he was fleeing from the cops, first of all, the officer didn't say we pulled up right next to him. Very clearly they said we pulled up, there was a lane in between us, and he was on the grassy area. This grassy area right here. They said he was here when they got out of the car and he started to flee, I remember? And I said, come on, how the heck was he not going to get in the bushes if that were the case? And then, shockingly, the prosecutor asks him, well, you played D1 football, right, officer? I mean,
shockingly?
The fastest man in the world, Usain Bolt, Olympic sprinter from Jamaica, could not get to him from the car if he's trying to get into the bushes. Look, I get it. Officer safety. Look, I'm not faulting them. They came in hot. They're the strategic enforcement detail. Apparently you got to be 300 pounds to be in it. I get it. They think he has a syringe. Okay? They come in hot. They couple strikes. Don't hit him in the face and arrest him. I'm not faulting them for that. I don't know about this, saying he was trying to flee. Okay, that's not cool. Okay? But I get it. Officer safety.
I'm not faulting them for beating him up when
he has an injury.
surrendered.
Look at this. It's dry blood and it's bruising. It's the kind of purple bruising that takes place hours later. When you first get an injury, it doesn't bruise. This happened earlier. Dry blood, purple bruising. That takes time to get to that point.
That's bright red. That is not dried blood.
A theory in search of facts. I talked to you guys about this. To try and use a computer to manufacture financial motive without telling us last week that sometimes, I'm sorry, how much time is that? Thank you. That sometimes the computer opens files and shows it was accessed. Don't you think that would have been fair to tell you guys that? Instead of leading you to believe that 100% Gerhard looked at all of these things? Look, make no mistake, he said 80% of it he looked at. He's not hiding that. He's just, when he's up here saying, like, I don't remember at 3 a.m. looking at a 2018 Amex credit card statement that was in my old divorce file. And, but undeterred. It shows he had a financial motive. He was looking up how much his divorce costed him in the past. What? He makes a lot of money as a doctor. The search terms: kill, push, shove, syringe. They're looking for the smoking gun. They have had it with his computer, looking for the smoking gun. What do they find? No smoking gun. Just some search about hikes that you would search if you were truly just going on a hike. Again, maybe, maybe not. They were looking for a smoking gun. They don't find it, so what do? They manufacture a motive, undeterred, theory in search of facts. Oh, no smoking gun. But you know what? It shows he's looking at financial documents. He has a financial motive. It's not fair. I submit to you that whatever they found on that computer, they would find some way to spin it. Whatever they found, they would find some way to spin it. That's not fair. The work bag. The work bag. And this, I gotta say, he uses these tools and materials to save lives. And they want to fault him for having it? He's a doctor. He talked to you about why he has it on Maui, not on Oahu. He uses these things to save lives, not try and somehow poison his wife. And she knew he would take it from work every day. Now, self-defense, first thing you got to decide is whether or not this was deadly force that he used. We know it wasn't. We're going to get into that in a second. But it doesn't matter either way because it's the same rock that she hit him with. So even if it was, even if you say it was deadly force, it was the force that was used against him. So it doesn't matter. It's the same rock. The only thing it does say about it, and this is the part that was incomplete, about the duty to retreat. It says, the use of deadly force is not justifiable if the defendant knows he can avoid the necessity of using such force with complete safety by retreating. You only have to retreat if you can do so safely. She's holding on to his testicles, hitting him. And it just talks about being reasonable. He used the same force that she used against him. And they want to say, well, look at the difference. How could it be the same rock? Obviously, if one gets hit cleaner than the other, the same rock can do that. You know, like I could throw something at a baseball at someone's head, and one it hits them in the face, and one it hits them in the arm. It's going to cause obviously it can be depending on how the direction, how hard the landing was. He stopped. He didn't keep going. What amount of force was used? We know. Like I said earlier, we know what Ariel says she doesn't know. I don't know the exact number. They are downplaying what she said because they know it doesn't make sense. They're saying, oh, up to 10 times. So what does that mean? 6, 7, 8, 9? Doesn't mean 2. But now they know that doesn't make sense. She was hit 8, 9 times. And oh, maybe she meant less. She doesn't know. Grosjean says possibly 2, maybe more, I cannot tell you. Ayden says 2 to 3. He says 2. Grosjean talks about, oh, there's rock in there or dirt. He's not a forensic pathologist. He didn't test the material just to show like what it was. You know, her condition after. You saw her walking. She's walking on the hill. Okay. But more importantly, this is her talking after. And I'm going to ask you to do something with me now. If you could help me out here. Either close your eyes or don't look at the screen and just listen to her voice.
Where does he work?
He works for TMG at Maui Memorial Medical Center. TMG is called it.
At Maui Memorial?
Memorial, yeah. So TMG is a group of anesthesiologists.
Did you guys drive here today?
Yeah.
Which is your car?
It's a Nissan Rogue.
Do you remember the license plate? If not, that's okay.
It's not our car. We live on the island.
What color is it? The Nissan?
It's like black or it's gray. It's gray. Can somebody just wet my mouth? I'm going to wet paper towel so that my mouth feels really gross. I don't have any more. Sorry, I know it's not No, you're an angel. Trying to stop the bleeding until they get there. No, I really
What was Jeff wearing today?
wearing like a light gray shirt and
Okay. Does she sound like she has a traumatic brain injury to you? She sounds okay. Look, I'm not saying it wasn't a bad cut. And look, I'm not, nobody wanted her to have that cut. I'm not saying it's not, I'm just saying the level of force he used, you can see. It was, he talks about chunks missing from his scalp. No doctor said that. It was soft tissue. You heard from Dr. Ayden, a very credible man, that apparently for 14 grand is going to sacrifice his integrity. Obviously, he's not going to do that. He told you the blood is not a good indication of the severity. The blood is not a good indication of severity. No skull fractures, no soft tissue. The tip of her thumb, he said, it was just the very tip. And sure, after the first hit, he puts her thumb, it hits it. Just the tip is fractured.
He puts her thumb?
We heard about that. All three doctors agree. No substantial risk of death and no serious bodily under the law. All three said that. We talked about the stellate laceration. The Glasgow coma score was 15 out of 15. Triage, they waited a few hours outside because she wasn't in that serious of a condition. She had a bad laceration. They sewed it up. She went home the next day. And I don't mean to.
Yes, you do.
He feels terrible that happened. But he wasn't trying to kill her. That's about the amount of force that was used.
52
now,
minutes in.
Her eye. Let's look at this photo. The orbital is the most fragile area there is. And he said, very fragile bone. If he hit her with that rock, it would have broke bones. There was a scuffle. They landed on the ground. They're fighting. There's elbows. He's going for the rock. They're fighting for it. There's no doubt her eye got hurt in this thing. But he didn't smash her eye with the rock the way they want you to believe. And then you have his injuries. We talked about that. Now, it's the state's burden to prove to you this was in self-defense. More than probably. That it wasn't under the circumstances, that he reacted as a human when she was doing these things to him and hit him. They have to prove to you it doesn't apply. It was a reflex. It was a reaction. It was a human reflex and reaction to defend himself in the moment. And that can coexist with him feeling terrible about it after. This happened extremely fast, and then he stopped. Now, we talked about the elements of attempted murder. He had no intent to kill her. You see on the bottom, and self-defense applies. They have to disprove those two, self-defense. Then there's something that takes you down to the others, right? The other offenses. If and only if you find the defendant not guilty of attempted murder, then or unable to reach a verdict, unanimous verdict, then you must consider these other included offenses. None of them apply. Self-defense is a defense to all of them. If you think that they didn't disprove self-defense, it goes all the way down. But you work your way down through these things. I'm just going to go through it quickly because I don't have a lot of time. The next one is attempted assault in the first degree.
He's been talking for 54 minutes.
That he took a substantial step in conduct intended to culminate in the commission of assault in the first degree. That he intentionally or knowingly was trying to cause serious bodily injury. Let's look at the definition of serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. The doctors say she didn't have that. He wasn't trying to do that. This doesn't apply. Self-defense, no intent to cause serious bodily injury. You go on to assault in the second degree. Again, serious, no intent to cause serious bodily injury. Self-defense applies to all of this. So you work your way through, self-defense applies to all of it. Her motive to try and get custody and conviction of any of these things helps her with that. Assault in the third degree.
for an improper instruction of the law.
So,
should be
ladies
substantial.
and gentlemen, you have the instructions in the law. That's the instruction that you follow.
Then you get to assault in the third degree, bodily injury, or negligent use of a dangerous instrument. Again, self-defense. He wasn't negligent. He was reacting. Reasonable doubt as to every one of these included offenses. So you just work your way down. And then there's something after that called a mutual affray. If this was a mutual affray.
Mutual combat.
Reasonable doubt as to all of these. Now, I'm almost at the end here. I have couple more minutes. I want to end by saying a few things. This is the law. I ask you to use this as a guide to your deliberations. It's not about trying to figure out what happened. Your only goal is to answer the question, is there a reasonable doubt? Did they prove beyond a reasonable doubt this was not self-defense? More than possibly, more than probably. Let that guide your deliberations. It's a way to simplify things. After you talk about any piece of evidence, come back and remind each other, yeah, but does that prove this beyond a reasonable doubt? Let that guide your deliberations. You know, I couldn't help but think last night. When they moved here to the United States, there's these constitutional rights that we all have. They didn't know it at the time, but it was for a moment just like this. When a jury of his peers would come together and follow the law and follow through on the oath that you took. I want to end with a quote.
Mark Twain.
There was a politician back in the day who was giving a speech, and it was to other politicians, but I think it applies pretty well to jury service. It says, "For those to whom much is given, much is required. And when at some future date the High Court of History sits in judgment on each of us, recording whether in our brief span of service we fulfilled our responsibilities to the state, our success or failure will be judged by the answer to 4 questions. First, were we truly men and women of courage? Second, were we truly men and women of judgment? Third, were we truly men and women of integrity? And finally, were we truly men and women of dedication?" I ask you to keep those 4 things in mind as you deliberate. Courage to follow the law and do what's right, even if it may not be popular. Judgment to see through some of these ideas that he had a financial motive, that it was cheaper to kill her. Common sense judgment. Dedication to these principles and our Constitution. Dedication to it. Uncompromised dedication to the presumption of innocence and reasonable doubt. Deliberate that way. Uphold your oath. Follow the law. Let this guide you. Enforce the reasonable doubt standard. Follow the law. Do these things. And integrity will be yours. Thank you for your time over the last month. On behalf of Dr. Koning and Manta Dirks, thank you all for your time.
Do we need another break? Can you take your board with you?
Appreciate it.
Rebuttal by the state. And then a possible surrebuttal.
Remember in the beginning when we started 110 years ago?
He used pretty much every minute of his hour there. Turn the commands off, you guys were listening.
Mark Twain also said, if you tell the truth, you don't have to remember anything. Think back to defendant's testimony. Think back to every time he was asked on cross-examination something that made him look bad, something that made him look like he had a motive, something that was incriminating. Think back to every single time the defendant was asked something like that. And what was his answer? I don't recall. Ariel Koenig was able to sit here and testify in front of you for 3 reasons. First, she had her intuition. She saw the defendant looking at her feet on that trail. She saw the defendant tracking her every move. She saw the defendant making sure he saw where she was. And that's what made her feel uneasy. It was her intuition. Second, she fought back. She fought for her life that day. And defense wanted to characterize it as a full conversation, but it was Ariel begging for her life from the defendant. It was Ariel saying, think about the kids. It was Ariel saying, nobody's going to believe this was an accident. This is Ariel trying to reason with somebody who is trying to kill. And the third reason, and the most important reason that Ariel was here to testify to you, is Amanda Morris and Sarah Bucksbaum hearing a call for help, going forward, looking at what they saw, and helping Ariel out. Because the evidence shows that is the only thing that stopped the defendant that day. The only thing that stopped him from continuing to beat Ariel with that rock, from continuing to hit her, from continuing to try and kill her, was Amanda Morris and Sarah Bucksbaum catching him in the act. Defense wants you to think about the life insurance. But you should think about it differently. This is a couple who's going through it in their marriage. Why is it time to renew life insurance? Does that make any sense? No. What the life insurance is, what many of defendant's actions are, is the defendant covering his tracks. The cover-up proves the crime. Defendant had control of the scene when he was done, so he took the evidence with him. He didn't need to take the rock. In fact, he knew that he was seen with the rock. He knew that Amanda and Sarah saw him with the rock. Why take it? And what reason would Ariel have to make up the syringe? None. Think about what Ariel knew. Ariel knew that he had tried to push her. Ariel knew they were right next to a cliff. Ariel knew that people walked up as she was being beaten with that rock. She had enough already. There's no reason to make up the syringe. Defendant's attorney said something. These are the facts you just can't make up. And that's what the syringe is in this case. It's a fact you just can't make up. Let's talk about the confession. Emil told you he has no doubt about what the defendant told him. If this was truly a goodbye phone call, if this was truly the defendant telling his son that he was going to commit suicide, what purpose at all would there be to accuse Ariel of having an affair? What purpose does that serve in saying goodbye? That makes no sense. It's just trying to throw dirt on Ariel. That's all it is. It's trying to throw dirt on her. It's trying to make her look bad. It's trying to justify his actions because he knew from the minute he did it, and he knew from the minute he planned it, that it was wrong. And then look at that timeline again. Why? It makes no sense. The defendant was simply trying to say goodbye. It was simply a miscommunication between himself and Emil. If it was a miscommunication, why wasn't it cleared up? Why wouldn't he just tell Emil in that second phone call? Why would in neither of the FaceTime calls the defendant say anything about self-defense? Why wouldn't the defendant say anything about Ariel supposedly attacking him? Because in that moment, he was confessing. In that moment, he had a guilty conscience. And that's why he did what he did. That's why he hid. That's why he tried to run from the police. Think about the list of people that would have to participate in this, what essentially is being alleged as a massive conspiracy to believe what defendant's saying. You have to disbelieve Ariel. You have to disbelieve Emil. You have to disbelieve Amanda. You have to disbelieve Sarah. You have to disbelieve the medical evidence. You have to disbelieve the doctor that the defense hired. And you have to disbelieve what you saw with your own eyes. That's why the defense asked you to close your eyes when they played that video. They wanted you to ignore what you see. That's what this case is about. That's what they're asking you to do.
That was good.
Open your eyes. Make a decision based only on the evidence, and the decision is clear. The defendant tried to kill her. The defendant tried 3 different ways, and he learned out multiple times that day. It is harder to kill than you may imagine. You were told earlier about the defendant's constitutional rights and the founding of this country and how important that is. What are those 3 phrases that this country was founded on? You've probably heard them before. Life, liberty, the pursuit of happiness. And in this case, the defendant, beyond a reasonable doubt, made a conscious choice to try and take Ariel's life. He made a conscious choice to kill her. And that is why the only verdict that is supported by the evidence is that the defendant is guilty as charged. Thank you.
Thank you, Mr. Bernie. Just about to stand the jury in for deliberation. Before I do, to the first 12 jurors, is there anybody here who feels for any reason they cannot participate in deliberations in this case?
Wow.
I see no hands. So that means
The first 12 jurors are asked.
Mr. Kiyama, Ms. Kishi, Ms. Pang, I'm able to let you go, but you're not quite yet done. If one of the other jurors cannot complete deliberations, you may get a call to come back and participate in deliberations. Okay. So, even though you get to go back to your regular lives, and you're not sitting here in the courtroom, those 3 rules still apply. Don't talk to anybody about this case. Keep an open mind. Do not try to learn about this case outside of the courtroom until one of 2 things happens. Number 1, you get a call to come back. Or number 2, you get a call letting you know that deliberations are complete and the case is done. So unless or until you get one of those 2 calls, those 3 rules apply. Don't watch any media, just in case you might have to come back and do further jury service. On behalf of the parties and the rest of the judiciary, thank you very much for your time and your service. I talked about Gold Star jurors early on, you're weathering 2 storms to be here, and all the flexibility and perseverance that all of you showed, that still remains true today as more storms come our way. So again, thank you very much for your dedication, your perseverance, and your service. If I do not have a chance to talk with you later on, I hope you and your families remain safe during this upcoming storm. And again, you have our gratitude. Thank you very much for your service. You're free to leave the courtroom.
So the alternates are released here. Trying to work on the timer. We're using our Trial TV timer. Thank you, Trial TV, for this. Trial TV Live, great friends. We'll be keeping the timer running here to count. We do have a poll up. How long will the jury deliberate?
Thank you for being seated. So, ladies and gentlemen of the jury, as you already know, lunch is going to be brought in for you while you're in the jury deliberation. I do have a couple of final instructions before I send you in. Your deliberations take place during what I call banker's hours. So you're allowed to deliberate up until 3:45 today. If you're unable to reach a verdict, I ask you to come back, start again at 9 o'clock. And the reason why if you ask why is it so early, because if there is a verdict, there is time needed to assemble everybody to receive the verdict, and it won't happen before the end of the day. So that's why I released jurors at 3:45. Have you come back at 9 o'clock if you don't reach a verdict today. You will have communication forms along with the verdict forms that will go into the jury deliberation room along with the exhibits. One note about the communication forms. If you do send a communication to the court asking a question, it does take some time before an answer can come back to you. Sometimes it takes up to 45 minutes, sometimes an hour. Okay. If you're waiting for a response, if you can continue on with the deliberations, please do so. A couple of other things. You will not have the opportunity to ask for any additional information that you think is helpful. So you have all of the evidence that's available to make your decision on this case. Also, there are no transcripts available for the testimony of the witnesses. So you have to rely on your collective recollection as to what the testimony may have been. Before I send you in, is McCallum, Ms. Alvin Fisher. Will you stand and raise your right hand? Do both of you solemnly swear or affirm that you will take this jury in charge, that you will not communicate with them except by order of this court, that you will allow no one to communicate with them, and that you will conduct them into court again whenever so requested by them or by order of the court?
I will. I will.
Thank you. So, ladies and gentlemen, I'm going to ask that you take your notebooks, take your jury instruction packets, and all your personal effects as you go into the jury deliberation room. All rise.
As soon as the door shuts, we're going to start the timer on our verdict watch.
Seated. Jury is out of the courtroom. Mr. Barner, anything you want to place on the record before we recess?
Nothing from the state, Your Honor.
Mr. Otake, anything you want to place on the record before we recess?
No, Your Honor.
To all of you, thank you very much for the work that you put in on this case. I remain impressed by the lawyering talents. I haven't been here that long, maybe it's long for some people, but one of the true joys of this job is watching excellent attorneys represent their clients and privately. And I'm truly privileged to watch that in this case. So thank you very much for excellent lawyer. Until we hear from the jury, court will be in recess.
Thank you, Your Honor.
All right, as we go into recess, we're gonna keep our timer here on screen, and we've got a call here. Hello, hello, hello. Are you there?
Hello, I'm right here.
Hey, how's it going, Angela?
Happy, it's going great. Happy Easter. No, I'm a day and whatever late, but happy Easter.
Thank you. How are you doing? Sorry, I'm getting our timer back on screen.
I'm doing good. I'm just watching some Big Bang Theory. here. Now I just put it on. I watched the closing arguments, and even though I missed like 99% of the trial, I think he is guilty.
This is one where there's just a ton of evidence, and he wants us to disbelieve everything, which is it's just difficult for me to accept. It just screams guilty.
It sounds familiar. It sounds familiar. It sounds familiar, yeah. But since I missed like a huge part of the trial, I don't know how long will the jury go. But I am with the consensus of the chat. He's guilty. More than that, I don't know. Since I missed like a lot.
Yeah, this might be an easy one. We're always surprised when we think it's an easy deliberation, and then the jury takes forever to come with an answer. So it's.
Okay, let's put it between correlations, not less than correlations, but between maybe who knows? Maybe as fast as was that Florida trial. That ad for the lawyer. Who was that? It was Sarah Boone. Somewhere in between Sarah Boone and like I don't know, tomorrow maybe.
Yeah. I don't know. I think it might be. I think it might be today. It's early enough in the day. They only started 3 hours ago. They've got 5 hours. I think they can do it. I have to sort of leave the phone open. We've got a court watcher in court we're waiting for a call from. So I've got to sort of.
Yeah, I'm sorry. I just wanted to ask one question, and that is: are you going to follow the TikTok trial, this Sarah Patrick trial out of, I think, Florida, but I might have the state wrong, and that is in June.
I wish we could plan that far out, but just courts move so much, and literally we sometimes the week that court's supposed to happen, it gets moved. So there's some that we're watching.
I'm sorry for asking too much.
Yeah. All right. Thanks, Angela. Good talking to you. We'll see you.
Bye-bye.
Bye. All right. We'll see if Melissa's able to call. I'm curious right here. I'm curious if here we go. There we go. This is her.
Call from.
Hey, Melissa.
Hi, Scott.
Hey, thanks for calling. I've been wanting, I was going to say, I've got a question. I want to know, did you happen to look when the defense attorney asked the jury to close their eyes and just listen? Did they close their eyes?
Great question. About half. Some of the men just sat there. There's one gentleman in particular who just has this strange look on his face, and I'm trying to read it so carefully, but he was one that definitely kept his eyes open. Not everybody went there. No, not everyone went there.
Wow. Interesting. That's a quick way to get a read on the jury to see if they're with you or not. Give them instruction that visibly you can see if they're following, and if they don't, you might be in trouble.
Exactly. There was a lot of squirming, too, a lot more squirming on the defense's closing. If I was just going to make an observation, maybe people are tired. But it just seemed to me just a lot more movement. And Gerhard, too, I think he's under the weather, coughing and sneezing. And I said, bless you. I didn't mean to, and I said it out loud.
You're now in the record.
Because I'm so used to saying it.
It's all right. I think that gets a pass. But.
Okay, thank you.
So we saw the 4 alternates got dismissed. So the ones that deliberated, did it end up being the 7 and 5 that we thought the first?
You're correct. Okay. Yes, 3 women and 1 man left.
Okay, so 7 women now and 5 men in the deliberation room. They're going to pick their own foreman. They've been told by the judge, basically, you've got all the evidence. We can't help you from here on out, but if you have a question, you can ask. We just won't be able to answer it. So they're pretty much. I'd be surprised if we get questions at this point, right? He did a good job, basically saying you've got it all. Either you can get a solution or you can't. But
yes,
can I ask you, as far as the people in the courtroom who were attending, was Allie there?
No.
Anyone else family wise other than the defendant's parents?
I want to say that they are with his parents are with two others, and I did. There were a lot of reporters from the AP. I sat next to an AP reporter, but all of the local affiliates were in the room. I didn't see a lot of just anyone that I recognized to be her or his family, besides his family.
Interesting. What was your take on the prosecution, or excuse me, the defense closing?
Well, he has fine-tuned his craft. He is good at what he does. He commands attention. People pay attention to him. I think that he ran out of time because I think he had a bigger case to make around self-defense. And I saw when the woman put up the timing thing on air. It's very interesting how he presents his arguments. He has file folders, no papers inside, but he just writes on the outside of these file folders. So all morning with the court, he was playing with these file folders. It was so distracting. He would clip them, and then the clip would fall off and whatever. Then I got to realize what he was doing with that. And he took them all up to the podium, and he just makes his argument from there. I could tell he still had a bunch of file folders when his time went out. And I was under the impression that he was going to get some more time to argue that self-defense a little more. So I was surprised when it wrapped up like it did. I think he was rushed at the end. But overall, a good closing, effective, I think.
Yep. Any read on the jury? What's your gut feel from what you observed there? What do you think the result's going to be?
Gosh. I don't think it's a slam dunk. I think they're going to take some time. I'm going to go home. In fact, I was deciding whether I'd stay over, but I think I can do the rest from my couch again. It was a good experience, though, and I'm glad I got to call in and share my experience with all of you.
That's awesome. Can I ask a little bit about Hawaii for those of us that are jealous? How long's Hawaii been home for you?
Since 2001. I was going to go to law school, and my father got sick, and he ended up passing away. We did not have hospice when he passed away, so I moved to Hawaii, and I showed up at the university there, and I said, I'm here to be a hospice nurse, and I've been a hospice nurse since.
Wow.
That was on Maui. Lived Maui 10 years. I lived Lanai 11 years, and now we just moved over to the Big Island 2.5 years ago. Still hospice nursing.
As any of the facts of this trial, specifically the Polypuka Trail, is that something you're familiar with? Have you been to or had heard of?
No. Nope. I have not heard of it, but I don't doubt that, there are a lot of scary, dangerous places where people get hurt here. So, no, I've never been there.
All right. So what's if I do go to Hawaii on vacation, what's the number one thing I need to do?
Well, Pele, our volcano, it's been going off every 2 weeks now, and that is here on the Big Island, or there on the Big Island where I'm living now. That is quite spectacular. I wouldn't miss that. So I would do an island tour. If you can hit Lanai, that's really exclusive. It's lovely. Find an Airbnb because there's just 2 Four Seasons there. It's expensive, but hit Lanai. They have the most beautiful bay called Hulapoi Bay, dolphin sanctuary. So I would definitely hit Lanai. Maui needs so much love after the fires and now the floods. We've got another storm coming as well. So I would love for you to spend some money there too. But those are my three tops.
Wonderful. Did they sell the little Hawaiian hulu skirt girl for the dashboard? That's the only thing I know. I'm not sure if they make grass skirts my size.
I'm going to have to get your information because you expect one in the mail.
All right, Melissa, thank you so much for being a wonderful court watcher. Appreciate you weighing in and being there, letting us know what's happened behind the scenes. Thank you so much. Safe travels.
You're very welcome.
All right.
Thank you so much for all you do, too. Thank you. Aloha.
Aloha. Bye. Wonderful. Melissa's amazing. Thank you. All right, we do have a poll. We're just going to close up right now as we are in Verdict Watch, which I also have to update our title to let everyone know that we are in Verdict Watch. Let's see. All right, there we go. The poll we're going to close right now with, we have, waiting for the results, still tabulating. There we go. The question was, how long will the jury deliberate? We have just under 1,000 votes, and we've got the following results. Wait for it. I need to put spaces in there because YouTube loses the spaces. How long will the jury deliberate? We have 2 to 4 hours at 51%. Less than 2 hours, 24%. Hey, ooh, got food delivered to me. 46 hours, 17%, and let's sleep on it, 6%. So let me go ahead and post that right there. I got some taco enchilada roll Mexican food delivered. So wonderful. There's the results, and I lost the H somehow. How long will the jury deliberate? Right there. There are your results. Still not over the tie. Laura pointed out, and it was a great spot as well. Hang on, let me get. I need the timer and me on the screen at the same time. Is that all right? You don't want. I just don't like looking at the ceiling. 3 is going to be 4. There we go. Laura pointed out that the attorney, Mr. Otaki, was color coordinated his tie with the guilty label on his 10-foot tall exhibit there in the closing, which was an unfortunate match. I would have gone maybe with the green, the not guilty one instead. So that's a little funny. We posted a little funny picture on Twitter about that as well. But great spot there. It is Taco Tuesday. That's why we're eating tacos. I'm not sure if these are chicken or pork. I'll eat them and find out. Quite honestly, I think there's bacon in these too, so they're sort of Tex-Mex. All right, subliminal message to the jury. What I did not hear from the defense was to find my client not guilty. They did not come out and ask for the not guilty. I thought they were going to, especially they're asserting that he was not guilty. The only thing he did was the self-defense human reaction, and it was self-defense, so it shouldn't apply. But they didn't go so far as to say, do the right thing and set my client free. He didn't ask for it. Sometimes you have to ask, and I think that should have been the right move for them to do, but they did not. Defense attorney kept saying that he's a visual learner, and as an actual visual learner, I had to point out the tie. He's learned. Let's see. Anything else? Spent too much time on whatever that first 5 minutes was and quoting people. Yeah, the Mark Twain quote, that was, well, I'll give him this credit. He seems to have it memorized, and it was accurate. I fact-checked him. That's a Mark Twain quote. It does check out. That was from a speech that he gave back in Advice to Youth back in like 1882. It's a satirical piece, but it's got some good quotes in it. And then the prosecutor coming back with another Mark Twain quote to counter it is even better. Let's see. Did the defense ask for a trial to be dismissed due to a lack of evidence? It possibly happened at the bench. I don't remember them doing a judgment of acquittal motion or the Hawaii's equivalent of that motion. Cauliflower says, "What do we do while we wait?" Twain and Kennedy. Yeah. Mark Twain wants to be excused from this narrative. Is attempted murder the only charge? That's what they're charging him with, but they have a bunch of what's called lesser includeds, which could go all the way down to like attempted manslaughter. If he is found guilty at the highest charge, the way things work in Hawaii, he could be convicted for a period of life, up to life, with the possibility of parole. And the parole is not after a set period. Their parole board, just like, if we feel like now's a good time to review your case, however long that may be, and it's entirely up to them. So life with a chance of parole is basically what they're going for. Let's see. The burner phone number, it should be up on the screen here in just a minute. Let me see if we can pull that up here. I think that was one of the most discombobulated closings for a defense ever. I think the prosecution's A game knocked them off a little bit. It made them have to respond, and the prosecution did such a good job putting the whole argument, the theory together in a clear, concise. The understandability was like way up there. that they had to respond to it. Let's see who's
Call
on the call.
from AWOL.
AWOL, my friend, how are you doing?
Hey, how you been?
Good, good. How's your
been
Easter?
a while. It was good.
Wonderful.
Chill with the family.
Wonderful.
How was yours?
I still see it as Easter season. Basically, Easter season goes all the way through when all the flowers outside stop blooming for me. So it's going great. Thanks for asking.
That's great. I have a you know me, beating a dead horse, critical thought question here.
Mm-hmm.
Thought experiment. Does a defendant, due to his alleged crimes, make people dislike his attorney? Meaning, like, if that attorney represented somebody that we liked, would they get a pass? Or is it because we so strongly dislike a defendant that we go, oh, this guy's so annoying, or she is so annoying? And I feel like it always happens when a community, not here, just overall, in world, any trial you watch, any channel, that if you don't like said person, defense or the state, that attorney now becomes almost as if they committed the crime as well.
The pariah, yeah.
And I get it.
It's like
I
a
do
co-defendant,
get it.
right? The attorney becomes a co-defendant.
I do understand it, but I'm like, I think we're too intelligent for that. I think they're doing their job.
I know it. I love it. I've said over and over. We might not like his style, but man, I want someone as go-getter. Just will chase after, the interest of his client as strongly as Mr. Otaki does. He is a great person. I'd want somebody who would put up that strong of a defense, and it's great. His style is different, right? It is a little bit abrasive, and maybe there's a little too much theater worked into it for my liking.
Right.
But you can't fault him for trying. I mean, that guy works his tail end off for his client, which is the number one thing I want in a lawyer.
And to that, Nico in the Uvalde, I'm not going into specifics, but Nico in the Uvalde was, in my opinion, was a little too over the top. Even though I thought he was effective and he won his case, but it was a little too much. Even though I thought that he ran a master class on putting on a defense. But even me, being pro-defense, I was like, okay, tone it down a little bit, right? But he won, though. You get what I'm saying?
I didn't follow that one. Obviously, that was a rough one. We didn't follow that one,
yeah.
so I don't know exactly.
I don't want to get into the specifics of the trial, but
I know the basics.
But just as an attorney, it's like even in that case, I was like, he could have been a little bit less. So I'm not saying that I don't judge an attorney by a defense attorney for fighting for their client. But I mean, I just don't understand the complete dislike where it goes to look at what they're wearing, look at his hairstyle, look at her shoes. And I go, all right, now at this point, you dislike the defendant so bad that now it comes down to nitpicking on attire, looks.
You've got to admit that choosing a tie that matches the guilty label on the exhibit was a choice and a half. But
yeah, that was not a good look. I don't think he thought.
Yeah, I'm not a big fan. We're not a big fan of picking people apart for looks. I can't change the way I look very well, and if everyone pointed out all the flaws and how my face did not meet the Greek goddess model, goddess, probably the god model instead of goddess, but you know what I mean. I'm not the picture of human health and beauty, but we don't attack people for their looks. That's just not
right. I'm not saying that I'm not saying that we're doing that here. This is just a grand observation on multiple channels because I'm watching like 5 trials at the same time. So it's just a overbroad view.
I don't know.
Like a consensus that I'm taking.
Yeah.
Not this channel. This channel's the best. I'm already
present
ride or
company
die.
excluded.
So.
Right. No, I'm not saying we're perfect. Yeah. I'm me myself. I've failed in this area many times, so I've got room to improve here as well. But I don't know. I think there is something about once we decide we don't like a side, once we don't like something, it's easier to see the flaws, right? If we feel or are sympathy lies on the prosecution side, we're probably going to give them a little more leeway if they flub up and say something completely wrong. And like, oh, he misspoke type thing, instead of like, whoa, that was completely wrong. Why would he say that? And really, I guess that's just you used to call it a thought experiment, but it's just showing that we all have just a little ways further to go to give people grace and space and all
Right.
that.
And that's a trait of being a human. So I get it. I do get it. But I think that at some point maybe I should draw the line between trial watchers and like normal people. And I'm like, wait, we are trial watchers. We should be better than.
Are you insinuating that we're not normal people?
No, we are.
I'm sorry, I had to go there. No.
You know what I'm saying?
Yeah.
We're normal, but we're trial watchers. We're not a layman. I would like to say.
I'd say a lot of us have a lot more experience with court and understand what's happening more than just somebody who flipped the channels and like, wow, I'm seeing a court on TV or on YouTube. That's weird. What's happening? Yeah, I'm with you there.
Right. So it was just a thought that I had running through my mind, and I haven't talked to you in a while. So I was like, you know what? Let me call him. But
awesome.
Anyway, it is what it is.
Yep.
I'm glad your Easter was good.
Likewise.
I love chat. Blessings to you and your family, and everybody be safe. And that's it.
Thank you, AWOL. Good talking to you. We'll see you.
Yes, sir.
Bye.
Bye.
Okay, I just realized that I need to charge my phone. We're sitting here taking burner phone calls, and I've got like 10% left on the battery. Let's figure out what our schedule is right now. Okay, let's do a quick little analysis of where we are. Can you turn up your mic so I can tell if it's my speakers? Larry, I was down a little bit there, and AWOL has a good voice for radio, and so he was just coming through a little hot, but it's all good. All right, just looking at where we are, it's 7:30 p.m. Eastern right now. That puts us at 9, 10, 12, 1 o'clock Hawaii time. Right, 1 p.m. Hawaii time, which gives them 4-ish more hours, possibly to deliberate if they so choose. If they come back with a verdict today, I would like to cover it today live. That's my goal. But I know it's late in the day, and I know a lot of you have things you normally are starting to do. I think the best thing to do right now is probably not just drag this out and watch the timer click on the screen, although I like doing that. It's 7 o'clock, not 7:30. Oh, sorry. I typoed. My brain swapped those numbers around. Thank you very much, Tishfish and Miss McGuire. I think having a new live stream set up and go live as soon as a verdict comes in, if there is one, that would be let's watch the clock. We can do that. I just know that it's the end of the day. We've been live all day since about 9 o'clock this morning, so I'm about spent mentally, and I just can't guarantee that I can bring you the great intellectual stimulating comments and commentary that I hope to bring throughout the day as we get later and later. Set up a new live so we can get notified. If I set it up right now, it might tell you. Yeah, I can do that. I just don't know how. I want the push notification to go out. That's the only thing. Eat your dinner and see your family. Can you leave a blank portal? It won't let me do a blank portal. I have to have the new live set up. And the problem is the push goes out when I set it up. And so if I don't want to send out a teaser saying, hey, we have a verdict, which we don't yet. And then also I don't want to burn that one push we do get from YouTube to say there's a verdict. We'll just summon you. Here's what you need to do. Click the subscribe button. I know a lot of you have been clicking that today, and I thank you very much. We're over 70,000 subscribers, which is, I can't even fathom that number, honestly. Click the subscribe button and ring the bell. Make sure your notifications are turned on for all notifications when we go live. YouTube should let you know. And then we can come back if we have a verdict. If, for some reason, you hear that there's a verdict or you hear a rumble somewhere, my burner phone is always available. Like, I answer it day or night. I do not turn on the ringer. Weekends, in church, doesn't matter. My phone's on. I turn the ringer off during church, but let me know. We'll go live. The judge says they're going to go home at 3:45. That's only 2 hours and 45 minutes. It's tempting. 2 hours and 45 minutes is not that long. It's 2:45 a.m. Oh, no, 2:45. I thought it was 1. Now I'm confused. The mods are like, fine, just leave this one up. You can do it. I can leave it right here. Let me step away for a bit. How about that? I'm going to step away. I'm going to say hi to my family, make sure they still live here and love me. I'm going to eat my delicious tacos that my wife made for me, and then we're going to come back. I'm going to charge my phone as well, and we'll have the clock up, and you'll get to just watch that on the screen for a little bit. We'll have audio. Audio from court is live, so in case something happens, you'll hear it. And now I'm going to go eat. How about that? And then maybe when we come back, we'll play some music. We'll see. We're okay. We don't need to start a new stream for another hour and a half, but we'll do that. No music yet. No music yet. We'll just sit tight and let me eat. I'll be right back. Thanks. Alrighty, I am back. I'm back. Oh, I forgot the battery. No. There we go. Just plug it into that computer. I left you without any funny buttons. My dinner was already made for me. It was like served up on a plate, just ready to eat. Did you chew? Yes, they were just little tiny tacos. Bacon chicken ranch.
Hello.
Tacos. Ooh, that was loud. Did you even taste it? Your wife's a saint. She is. Thank you. Were they better or worse than Lori Vallow's enchiladas? Oh my goodness. Those green chili enchiladas, the ones I made, these were good, but it was like the pre-cooked bacon, like the Black Label bacon you get at Sam's Club that's pre-cooked. That's not the most flavorful bacon, but it was good. I'm glad you appreciate your wife as much as you do. I love her. She is amazing. The ones we made here live, those were good. I liked those enchiladas. I think they were better than Lori's.
I was kicked back, taking it
Missed all the close-ins. How did the poll look? 87% guilty on the poll. I've had a couple people, I have not had a chance to watch Dr. G's breakdown on this, and I've had a couple people suggest a couple other breakdowns on these witnesses as well, both behavioral analysts and a few others. What's the general consensus? I mean, are they across the board? Is it everyone on the guilty side, everyone on the not guilty? Let's see. He's guilty 100%, says Cruella. Still 2.5 hours for today's deliberations. They might come back today. They could, and we could be here for that. We can watch and wait and see. We did get a request. You guys know I love the court system, and I love how it operates. I have a lot of respect for it. Sometimes court can be a little bit slow and monotonous as the process plays out, and it just takes a lot of time to get through the steps we have to do. Sometimes the testimony is a little bit tedious, and sometimes it's a little bit funny. And we try to take some of those lighthearted, funny moments and memorialize them in song. And we've done this for many songs over many trials over some of the last several months that we've watched together. And we did write a song for this trial specifically, and we try to do this in a way that's respectful for both the defendant and the victim. And so we wrote a song about your tie is going over well on your tweet. Is it? Thank you, Laura. I stole that from you, like 100%. Let's see. I might have some questions here. Anyway, we've got a song about the bush and the hole in the bush, because there was a hole in the bush that was testified to a ton during this trial. I'll allow it because it's funny and I'm all for funny. Thanks, Laura. I appreciate that. Did anyone catch during the trial, including today, Tommy a lot used his middle finger to point? Do you think if GK is found not guilty, Ariel and her team parents will move out of Hawaii for their safety? I did not catch the bird, the middle finger pointer, which sometimes we'll see a little bit, but I don't think there was anything deliberate. Not like we've seen in some trials where people, like put it up on the side of the face, like, oh, I'm just scratching my face on the side of what you're looking at. We saw that. Remember, I think that was even in Florida, the school shooting one. I don't think they'd move out of Hawaii. I don't know. I think they probably love it there. Let's see. Anyway, we told you we make these little songs, and I'll play it just one time. We've got a song called The Hole in the Bush. The Hole in the Bush. Which we're going to play a little bit because it was featured so much on this trial. Just a second here.
I was minding my business on a Tuesday noon. Then I wound up watching this courtroom cartoon. Every second sentence like a legal ambush. Someone's back again at the hole in the bush. Was it north by the gate? Was it south by the tree? Every lawyer in the room had a PhD and pointing at a poster like a kid playing whoosh. Where exactly is that hole in the bush? Oh, the hole in the bush. There it is, Your Honor. Got more airtime than the actual case. On the screen, on the map, in everybody's face. Ask about motive, they just shush, shush, shush. Let's go back again to the hole in the bush. One side says it's tiny like a 6-inch gap. Other side swears you could drive a car flap. Experts take a ruler like they're measuring the moon, arguing in circles till the afternoon. Was it here? Was it there? Was it God's design? They could build a theme park by the property line. Exhibit A, B, C in a tidy stack. All pictures of a shrub from the front and back. Oh, the hole in the bush. Replay the footage. Every witness doing horticulture school. Oh, the hole in the bush. You may approach. Turned a deadly serious day into the weirdest duel. Ask about facts. They say hush, hush, hush. First we need to talk about the hole in the bush. Students tired and pale, highlighting transcripts for a final exam fail. Page after page of deadpan prose, all rise for a hedge and a gap between the rows. Oh, the hole in the bush. Last time we promised, tattooed now on my poor brain stem. See a shrub, I'll be thinking of them. History books will gently blush, 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 with a whole long chapter on the hole in the bush.
There you have it, a little hole in the bush. Yes, and I break all the rules. You can find that and all our other songs we've made about various different trials over there on our Top Mark Media page, or straight on our Suno court list. So good stuff. Yeah, let's see. Never thought there would be a song about a hole in the bush. We managed to slide that one in there. Blackbirdier overtime hazard pay. Thank you very much, Blackbirdier. Appreciate it. As we do wait and wait for a verdict, I wouldn't be surprised if we don't get a verdict today. I can't say anything about it. It's all taken out of context. I wouldn't be surprised if we don't get a verdict today. I think I don't remember the judge giving the jury the instruction about deliberating. When you go into deliberate, I advise you not to do a quick straw poll. They might do that still. They might walk in there and say, "Where's everybody stand? Are we all not guilty, or are we all guilty?" And just get a feel for it. They might be on the same page of just filling out the verdict forms, but at the same time, they might be taking it a little bit slower as far as evidence that has been admitted. I don't think there's a lot that they have admitted they will have back with them that they weren't actually seen or read in detail during the trial. It's not like we have 900 pages of text messages to peruse. So, I mean, maybe some of the WhatsApp stuff, but I don't think they're going to find anything there that's just really pressing. I picked overnight, says Mary. What about Greener's t-shirt design? We're working on that. Greener's actually he's sent me the design so we can try to make it happen. Let's see. Oh my goodness! And on the undies. Okay. I'm a fan of this. I think we might try to make a couple shirts for some of the cases that we follow, in a tasteful way that can commemorate some of the court cases that we've enjoyed watching or learned a lot from, or had some memorable moments with. Yes, Greener's designed some undies as well. Probably won't make the cut on the undies. Can we see the verdict sheet? I don't have the verdict sheet yet. I haven't heard where that's at. If anyone's seen that, if it's been released yet, let me know. Last time I picked 2 to 4 hours. The jury came back on an hour, so I picked 1 to 2 this time. But definitely wear a shirt or a hat. We'll see if we can get them made. They're 6 hours behind Eastern time. Yes, it's actually the sun is just setting. I'm probably just past golden hour here on the East Coast. So in another half hour, it's going to be dark where I'm at, and it's still middle of the day there. Okay, we got a call. Let me switch the phone over.
Call from
Allison. Hey, Allison. This is RA. How are you doing?
Good. How are you today?
Fabulous. What's on your mind?
Well, I just wanted to give a shout out to the prosecutor for redeeming himself after I was getting so frustrated with him before the closing. I felt he did. He totally redeemed himself. I felt he's a little fresh or a newbie, maybe, and he wasn't crossing the guy like I would prefer, being a SOPA critic or whatever, but he did a really good job on the closing. I was like, oh, don't do a rebuttal closing, but he came back and made it short, so it still was good.
It was good.
And
it was really good.
I'm feeling guilty for hating on him. So I wanted to say that out loud.
All right, we'll pass the message on to him. He's all is forgiven. I don't think he holds a grudge, so you're good. But he did great. I don't know. He looks young, right? He looks young.
He does.
I think somebody said he graduated in 2020.
So
he is young. Just a handful of years of experience, and he's there prosecuting what is a high-profile attempted murder case. That's pretty cool. So,
well, I'm glad they didn't snatch it away and give it to someone like seniority-wise, or maybe that is the most. I doubt he's the most senior in the department or whatever, but I'm glad they didn't take it away. That's good.
Yeah.
And they let him do it. I just was like, oh my gosh, because I think he needs more experience with with cross-examining and letting the guy, use his own rope, let him talk instead of yes or no questions.
Yeah.
But
I was worried when he didn't object, like early on in the trial, and the leading on direct, and I'm just like, oh man, you've got to. I know you don't want to be petty and like call every single thing just because you can, but at the same time, you can't just let that slide. You've got a defense lawyer who's just testifying in court. Like, he's just laying it out there, and you've got to push back.
It was the worst leading I've ever seen. It was the worst I've ever seen. Because it was literally testifying everything he said. He rephrased it, and I can understand like a mnemonic device to repeat things, kind of like the closing of the prosecutor kept saying, unbelievable or not believable, which was good. But the repeating of the testimony, it literally was testimony. You're absolutely correct. And I can't believe let it slide. And I was also like, defense attorney, look, I'm usually on the defendant side, but it's such a blatant, to me, it's so obvious. It's so ridiculous, counterfeiting no retrofitting excuses for
you would be
everything.
beyond reasonable doubt on this one.
Correct.
Yes.
And the judge, I was getting mad at the prosecutor, and I was getting mad at the judge. I was not putting my anger toward my internal anger, not liking it, not anger. But the defense attorney was very, very aggressive and very good for his client, but I did not like his style. The moment that tips me over for him is I don't like snarkiness. I don't like chuckling when they're trying to argue a point. That's it. But the judge and prosecutor was on my bad list because they weren't standing up to him. It was so annoying. So
you've got to give the judge a little credit for not getting mad, right? The judge maintained composure through the whole thing, and I'm not sure I could, because there were some points where he was really, the defense guy was just like right in his face, and the judge was just calm, cool, and collected. But at the same time, he let him just push him around. He let him overturn his decision while he's giving the decision. I mean, it was crazy that way. But what was your last question?
Glanville with YSL did that a lot too. They let him talk and talk and talk and talk and talk, and it's like when something's final, it's final, and move on. But yeah, the last question really is this. Oh, number one, I really hope the jury comes back very fast just to rebuke ridiculous, like it's almost insulting our intelligence, the defendant's stories. It was almost insulting because it was like, really? Yeah. But my question is, do they have prisons in Hawaii? Are they the best prisons to be in if you commit a crime? No.
I don't know. It's got to be the worst. You're literally incarcerated in paradise. Everything is so close yet so far away.
But you get to walk outside in paradise.
Yeah, that 1 hour a week of being able to see the palm trees over the fence, I guess. I don't know.
Yeah, I'm lazy and I don't want to look it up. So if I think it was Melissa in Hawaii, what's her name? If she calls back, ask her if they have a prison there.
Yeah, I'm sure they've definitely got some jails, but I don't know if they would house them in prison or not there. So we'll have to find out. Thanks for the call. Appreciate it.
Thanks for your coverage. I appreciate it.
We'll see
you.
Bye. Morgan Shadrake says, question, Marianne here. Just found your channel. Love it. Great commentary. What's your background? It's a bit diverse. It's a long story, but we have some time, so I can share it with you. The short version is I have been interested in the law since I was in junior high. I mean, that's when I started studying the laws and reading how the laws applied to me, and applying and using the laws for my benefit in some cases, even getting us out of school one time because of laws. Fun times. I've always enjoyed it, and always enjoyed the legal system and respected that. My expertise, my degree, my education is in communications and electronic media. So I've worked in the news fields. I've run cameras and news studios out on the road, filming events and TV productions and sporting events and everything like that. That's why I have all this tech gear and love to use it. But then after that, I worked in the Department of Defense in a fun position there in IT. Managing a whole bunch of classified and unclassified servers, just maintaining their health. And that was a blast, and I love it. But none of it is as much fun as coming back to the thing I love, which is the law. I am not a lawyer. I've never gone to law school. I just love to study it and love to learn about it, and love to watch the justice system, and then incorporate technology and my love for technology with sharing the justice system and courts with everybody else. So hopefully that answered some of your question. There's more to it about Recovery Addict and why the channel's named that and everything. But Gwen says, just came on. I do not think I can listen to defense closing argument. Is it bad? It's an hour long, I can tell you that. And it's basically everything you heard during the trial repeated again. There was nothing really new in what he said in his defense closing. It was just rehashing the same positions they took during the trial. And you heard that through the questioning of witnesses. It was just summing everything up. So it wasn't different. If you had a hard time hearing the defense attorney during the trial, you might want to skip it. But I think he did a good job for his client. He was a little bit rattled though. Yes, they have prisons in Hawaii, just not right on the beach. All right. Let's see, any other questions? Was there a poll? There was a poll. We had 87% on the guilty side on this one. Guilty as charged, with the balance, the 13% not guilty. We also came in with our deliberation time frame, and we think that 2 to 4 hours would be the sweet spot for most of us. So you're doing things that you love. That's wonderful. I do, Joe. I absolutely do. This is such a blast, and I'm excited because just this last week, I finally have put together, or I'm finishing putting together a kit that will be the travel kit, the Go kit, for whether if we are pool media in court somewhere, which we want to have all our equipment so we can do. It would allow us to have our multiple cameras set up and basically have a very compact unit that I can take anywhere, just plug in and be ready to go. So we're just finished getting that set up. It's 4K capable, so we could literally stream a court in 4K, which I don't think anyone has done before. And I'm talking streaming live in 4K, not just 4K on the app upload afterwards. So we've got that. I've got parts arriving for that tomorrow as well, as for some of the streaming encoders and some more cables. Did you get your meds figured out, Gaily May? I decided to stop taking the meds. I wasn't liking what they were doing to me. I'm not a big medication guy. So another call on the phone here.
Call from Josh Hutchins.
Who gave you this number, Josh? No, just kidding. Josh, how are you doing? One of our great mods on the phone with us.
The channel gave me this number.
Yes. It was in mod chat somewhere. How are you doing?
Good. I see my name was being mentioned in chat, so, I figured I'd call.
Oh, let's see. What was it about? Does Josh Hutchins ever call in? If so, I was probably working. Just see him doing the mod thing. Josh works a ton, but he also plays a ton, usually while he's working.
Banished from the state of Georgia.
I'm banished from your state, Josh.
Yeah, don't tell Laura not to do that again.
Josh is the only one I know who's ever done mod work in chat while fishing.
It's pretty impressive, isn't it?
It is. I'm impressed every time, and I know it because he sends pictures of the fish he's catching between deleting comments and everything.
It's not a lot. So.
That's cool. I'm jealous. I have not been fishing in way too long, but I appreciate it. Josh is the one who hates mustard. Tell me, do you also hate Miracle Whip? Was that?
Yes, I do. It's diabolical. It should not exist.
But it has paprika in it.
Okay, so does Old Bay.
Both of them are good. Yeah, I answered wrongly, and I missed the super chat as a result. So next time I know the right answer. So.
And I also figured if I called that maybe a verdict would come in within the next hour or so.
Well, we are. If you look at the timer, we're just hitting the 1 hour mark on the deliberation timer. So we've got about another hour and a half or so, maybe an hour and 45 minutes left on deliberation today before the judge will probably send them home and say, go to the beach, relax, come back tomorrow, try again.
And aren't you proud of me doing the pins all by myself?
It's been awesome. I mean, look at this.
I mean, I know you told me that you gave me access a long time ago, but you also said in the same day you just gave me access. So I have the time stamp for that.
Yeah, well, I gave it to you a long time ago, and then I took it away, and then I gave it back.
Okay, I got you. See, there's no relevance to this phone call. I'm just calling just a call.
All right, Josh. Good talking to you, my friend.
All right, see ya. Bye.
Bye. All right, let's see. What about Cool Whip? You can't eat pie without Cool Whip. I mean, I guess you could use ice cream in place of it, but there's something about a slice of pumpkin pie that just needs Cool Whip. Katybug says, thanks for the overtime, RA. Katybug, I'm happy to be here. Thank you for being here as well. Let's see. Oh, we've got an emoji recap. Northwest says, hike, climb, the drugs, the rock, the 2 nurses, and no death. I'm liking this one already, Northwest. I'm just taking a quick look at it. Great little emoji recap here. I think there might be a little bit more to it. Let me go back and see. No, I think that's the whole thing. What's the nuclear scientist and the thought that she didn't love the doctor got mad. There's the plane to the birthday to the Big Island, and they went on a hike and had to climb up. You got the Needle Rock. Yeah, that's pretty good. That's a good one. Is Cool Whip? Sorry, is Cool Whip the heavy cream in a can? No, Cool Whip is the frozen light. I guess you could. I think you can get spray Cool Whip as well. I don't do the spray Cool Whip. I do the spoon it out one. All right. The real Emily Ross says, I'm confused though. Is Red Pen Amber? No, Amber is Calypson's Vixen right here. This is Amber. Red Pen is my English teacher, my honorary English teacher right here. This is Red Pen. Both moderators, both wonderful people, helped me immensely in this. But Ready Whip is a can, and Cool Whip is in a tub. Thank you. Ready Whip works in a pinch, right? But I prefer the tub method. All right, I can hear Cool Whip without hearing I can't hear Cool Whip without hearing Stewie from Family Guy. Cool Whip. Cool Whip. It's aerosol cheese. I'm too old to eat aerosol cheese anymore. As a kid, yeah, that was great and fun, a fun snack, but not anymore.
In front of the Walmart.
I do have a jar of spicy maple bourbon pickles in my fridge right now, cooling. All right, I have to unplug the phone and charge it again because it's charging very slowly.
Remember in the beginning when we started 110 years ago?
I remember that, Kitty Bug. Sending a picture to the burner to show Josh, says Mary. Let me see if I can forward it to him.
I don't like podiums, Your Honor.
Oh, wow. Josh, this is the one you got away. Hang on one second. I've got to send this to you. Save image. It's a fish. It's a massive fish. Like, it's huge. All right, 6 volt. 6 volts in the house. How are you doing? Welcome, my friend. Hope things are going well with you. We're working late tonight, so it works with your schedule to be here. Thank you very much for popping in. Do we have a channel in Discord to send pics from overseas? We do have a channel in Discord, but it's mostly for chat. We have Facebook for overseas pictures. I'm just not very good at Discord, is why. As a kid, I got the squeezy cheese on my dad's car, and it took the paint off. I never ate it again. Coke will do that, too. Mary, that is a beautiful largemouth bass. It's massive. Unfortunately, it is bigger than the largest one I've ever caught as well. Still love the squeezy cheese when I was young. Now it's gross. I'm a connoisseur of cheese now. So now I'll go to the cheese section of the grocery store and try something completely new and different. Although I'm not a big fan of blue cheese, but I like all the other ones. And my favorite though was cheese curds from the Cheese Factory. Those are delicious. Gene, welcome. Good to have you here. We're here now, so it's all good. We're just waiting for the verdict. Are you going to cover the FedEx trial? Isn't that a Lumpy? Isn't that a young child death? I think That one's out of Houston, right? Am I thinking of the right one? FedEx, he pleaded guilty this morning. Need to learn how to make Swiss fondue. Ooh, good stuff. So no trial for the FedEx guy if he pled guilty. Replied to the Bass photo, but I need you to embiggen it. That, my friend, is a red-tailed shiner, and in somebody's hand. It's a fingerling at best. Bait. Ari's grandchild was a girl, a baby girl. Yeah, the FedEx one I think is pretty awful. Probably not. I'm debating really hard about what we might do if Letitia Stout, if that goes through with a new trial, which it looks like it is. We covered that initially, so I'm aware of the facts, and it was really difficult. But it just puts it back on reset with her conviction being overturned. So I'm not sure what we would do there. Those are some really difficult cases to follow. Kind of want to see justice for Gannon, even though it's a hard case. That's where I'm torn, Laura. It's just, man. Sandra Birchmore case had a huge breakthrough finally. I saw J.M. McCarthy World. I saw, and I forget who posted this. It was somebody on Twitter. Please, if you know whose post it was, please shout them out, because I hate stealing something without giving credit. But there was a discovery or information came out that there was a DNA on a strangulation device that would tend to point the evidence to more guilt instead of innocence. And yeah. Do we think Rex H will plead guilty tomorrow? I don't know what's going to happen there. A FedEx retiree, the guy was not FedEx employee, he was a contractor with the company FedEx hired. It is a notable difference, and I appreciate you, Shelley, being saying that. A lot of delivery companies have a last mile company that steps in on the end, and they're people who have never been related directly to the company. They're just literally hired to run the packages, and whether or not they're screened properly, everything else is different. Carla Larson, member for 35 months, joined this channel during the Letitia Stout trial. Just so heartbroken for Gannon's family. The fact that they have to go through this again is just brutal. It is so, it's terrible. Scandalous details in the new info for Birchmore. I was watching I had the FedEx trial feed going as well. As you guys see in my office, I can see I can watch 16 different things at once. So I did have the FedEx one, and I saw the picture of her in the truck. I'm like, oh man. Don't imagine any trials immediate. I imagine probably within, I'd say 120 days at the most. Once a new trial is ordered, they sort of have to go back to a speedy trial schedule. Do you think we'll get a verdict today? I'd put it about 50-50. Probably not within the next half hour, but towards, as we reach the 2 hours on the timer, there's a possibility. Right. Laura, I do think it would be quick. A lot of the prep work for the case has already been done, and we don't have to wait. I mean, it's not like we're still getting testing back from the lab. Expert testimony has already come in. That the results are in. We can basically it's a scheduling issue now, more than anything. Oh, Letitia is probably a joy to be around right now. Apple is down? What's wrong with Apple? Let's see. Amber says, the Recovery Addict, I plan on reaching out to some of my contacts connected with Gannon's case that I've befriended through the years, including the neighbor, Nicole. I'll keep you posted. I think that trial was the first one we ever had somebody from the area call in and speak to us. And it was a rough call. It was a terrible connection. That's the first time we ever had somebody call in and sort of give us a on the ground view of what the trial was like, as someone who was, there where the search went on and everything else, also with connections to the whole case. She was the awesome witness. Yes. Is Dr. Lewis still around? She wasn't looking good when she testified. I wonder if they would take her testimony by her sworn deposition instead of through court again, because she was right at the end of her career, I think. I don't think she's passed. She's now 88. Man. The state is appealing Letitia's retrial, so it might take some time. Yeah, it depends how long that appeal takes. I say pro se or Judge Simpson for the next trial or hearings. Putting a relative of the DA on the jury seems crazy. It was crazy. Let me tell you that. That was actually, it was absurd that that's what actually happened. Let me see if I can find. I thought I had that here. No. I don't know where it went. I thought I had that document pulled up. We could read it. But previous testimony can be read in. It's not my favorite way to watch court, but I do understand why it has to be done that way. Jody says, my third super chat to say I'm planning on being a court watcher for Sandra's trial. Just an FYI if you plan to cover it. Jody, that would be awesome. That would be awesome. There are a couple big trials coming up that we'd like to cover. And we're at the point where we have options as far as if there's some people who have a little bit of technical expertise, it might open some doors for us as well, where we could send you in as a representative from our Top Mark Media side from the company, and just send you some equipment to plug in to get us access to some of the court cases without you having to know how to program video equipment at all. It's just a plug in, push red button thing. Sandra says federal. If it's federal, it's not going to be televised. As much as I'd like to change that, and I wish I could do something about that. I wish we could get in federal cases, but so far there's not a lot that way. If Birchmore is federal, then we have nothing. RA tags us in like WWE wrestlers. If Sandra is not going to be televised, that might be one that being a watcher in could be really important, because there's a ton of interest, and a lot of people will want somebody who can take great notes and tell you what happened in that one. Melanie Little's been posting about it. I think I saw a post from her on that one today as well. Count me in, says Jody. Do you have the ability to record trials? It's not the ability to record. Yes, I have the ability to record trials. I have HyperDecks and all sorts of equipment that way. It's the access with the court. So we have to file with the court as members of the media. We have to agree to the terms of the expanded order of media coverage that the judge, if there's a decorum order that's released, we have to go through all that and make sure we're in compliance. And once they're satisfied with us, we can go in and either be the pool photographer, where we then provide the feed for everybody else, or we can also be a member of the media pool and just record the feed that somebody else is recording. Andrea Burkhart, yes, I think that's the I saw her tweet. She's the one that broke it on that one. But Laurie, yes, I have the ability. If there's a trial you want us to cover, We want it to be something that where there's a lot of interest because, quite frankly, it runs many thousands of dollars to cover a trial. Like my cost to cover the trial is many thousands of dollars, and I've already dumped the cost in the equipment. I'm talking about the ongoing cost just to be there during the day and equipment and service and stuff. So it has to be a big trial for it to work out right, but we have the equipment for that. Trial TV is here. Hey, Trial TV, check out our cool timer right here over my head. That's yours. Thank you for that. Can't believe we're still streaming. We did take a little bit of a lunch break today, waiting for the live stream to start this afternoon. So good to have you here. Welcome. EDB wants to send cameras for Corey Richland's financial trial. That would be awesome. That would be awesome. And I don't know if she'd be up to, how she envisions that happening, but we might. Depends on the dates when that happens.
Call from Megan. To accept.
I heard call from me. Who is this?
It's Megan.
Megan. Okay, Megan. How are you doing? I'm sorry.
Megan. I'm great. How are you? All right.
Doing fabulous. What's on your mind?
Good. So I've been mulling over the closing arguments, and the Tommy Otaki, our infamous defense attorney, continuously saying all of Dr. Koenig's responses were, it's just human. It's just human nature.
Yeah.
It's just human nature.
Just hitting somebody in the head with a rock is human nature.
Yeah. Doing all this detective work is just human nature. Doing all of the things that he did in looking into the files of the previous divorce is human nature. If I was a juror, I would have found that extremely off-putting. And again, saying, I'm not trying to minimize her injuries, but I'm minimizing her injuries at the same time.
Yeah, but it wasn't bad. I'm not minimizing. I'm not saying it wasn't serious, but it wasn't serious. that's what
it wasn't serious.
Yeah,
it didn't.
It looked worse than it was.
These rocks and dirt in her scalp down to her skull, they weren't tested, so we don't know what they are.
Yeah, there was no expert that told us they were actual rocks. It could have been what? No. We know what it wasn't. It wasn't the blood and skin and hair. This was foreign objects that need to be washed out of her skull.
1,000%. If I was that jury, and I hope they are seeing through this, because I think it's a really thin veil that the defense is presenting. None of this is human nature. You don't react that way. And the evidence, as they showed, doesn't support what he says. And I didn't believe his testimony, not one bit.
Yeah. It was everybody who testified against in this trial basically was lying, according to him.
Of course. The detectives, the police, her,
we've seen witnesses we didn't believe before. Like, we've seen people get on the stand and we're like, I'm not sure, this guy, I'm not sure why they called him. Not believable. But everybody,
of course,
all three police officers, what they saw didn't happen. The two nurses, what they saw didn't happen. The wife, the son, what they saw didn't happen. Don't believe your lying eyes, right?
I really appreciated the prosecution finally, absolutely stepping up to the plate and saying, it's unbelievable. Yeah. This is unbelievable. That's unbelievable.
Yeah.
And it is. It's completely unbelievable. But in his mind, he's the best person in the world. So I guess we'll wait and see what happens.
Megan, I'm hoping the jury sees it the way I see it, because I do think it would be a travesty if it went another direction. But, juries do what juries do. So we'll sit and wait.
They
and see
do.
what
They do. I hope they're like this incredible chat and community and see it the way that it should be and come to the decision that we all, I think it should be. Yeah. And if they don't, I guess they don't. And appreciate their time and consideration. Absolutely. And congratulations on being a grandpa. We're watching from California.
Wonderful.
All day, every day. Lurking, don't chat, but love all you guys and wish everybody the best.
Okay, but you have to get in chat just a little bit and say hi, so we know which Megan this is.
I'll try. Okay. I'm Megan with 5 letters, not Megan with 8 letters.
All right. Thank you, Megan. Thanks for the call. Appreciate it.
Thanks.
Bye.
All right. Bye.
Emily, I know everyone's covering it. What are your thoughts on Nancy Guthrie and what TMZ said the last few days? My heart goes out to the Guthrie family. The idea that that this sort of thing can happen, your loved one, especially an elderly loved one, could just be gone in the night, quite literally. It's scary. It's terrible. The fact that this had to play out, in the public, for them to, go through this process of hope and grief and uncertainty, it's miserable. I wouldn't wish that on anybody. I've not covered it very much. I don't think I had a lot that I could bring to it that wasn't being covered by other people, and very well. There's some individuals who did a lot of effort and work there to bring reliable updates and news and interviews and perspective to that story and exposure as well. The fact that these notes keep coming in to TMZ, I don't know what to make of it. For half a Bitcoin, apparently we can find out where her body is. That's basically the last I heard. Something's, yeah. I don't know. I just don't know. When is Corey's financial? That's coming up soon, isn't it? It's got to be soon. There's some things that don't make sense to me, but I don't have all the answers, and I wish no date set. Okay. I wish we had answers. I wish there was closure for the family. If either resolution or closure, and I guess closure is resolution. But Corey's sentencing is on May 13th. Let's see. We cover. See, sorry, I'm getting a ton of questions. I really like Brian Enton's work. I'm a big fan of him. He's done some amazing stuff. I was just talking to Ivan on lunch break. He's around. He's just been busy. He called me on lunch. Let's see. Found Brian with Gabby Petito. It takes a special kind of person to be able to hop on a plane at a moment's notice and cover a case the way that Brian Enton does, and I'm a big fan of how he does that. That's really cool. Bitcoin's at 79,000 right now. I think Ivan sent me a text about what he thinks Bitcoin's going to do, and I think he thinks it's going up. So, found RA during Daryl Boxfort Brooks. There we go, Cheryl. Got it right. Another call. This one from Utah. Selena, how are you doing? Selena, our
Hey,
court watcher from the Corey Richards trial. How are you doing?
good. Yeah, when Corey Richards' name come up, I'm like, yeah, I'll be there in May. And then
You got a loop.
I've got a loop. I got an inside loop. Yeah, and
Well, you got an audio loop,
her.
like we can hear us again through your phone.
Sorry. Is that better?
I can still hear.
Is that better?
You still have the other feed on, but so just listen to your phone and not the computer. That's better.
Okay, is that better?
Yep.
Yes, no.
Yes, it's better. I'm not sure
sorry.
if you can hear me. But yeah, we're talking about possibly covering the Corey Richards financial crimes side of things.
I know you guys are they're laughing at me because I know how to call in. I did it twice a day.
Yep. I don't know. I don't have plans yet. Although we're at the point where I could, I don't know. We might see. We might see what happens. Who goes where?
And I really, really, really am looking forward to Tyler Robinson. Don't ask me why. I just think it's going to be. Not that I love Miss Nestor and have to watch her again for another month or whatever, but I don't know. I just think it'll be fascinating again.
It's a big one.
The circumstances are so much different. I mean, I believe he definitely shot Charlie Kirk, and I think keeping him from the death penalty will be about all they can do, pretty much.
I think the difficulty in that one is that the case is so big, it's attracted a lot of sort of nutters on every side, quite honestly. Some people that are just far out, and they've brought all sorts of just absurd
conspiracy theories.
Yes.
Yeah,
we don't need that. I mean, that doesn't help anybody. And so I don't like the case for that reason. I do like it for a couple other reasons, but
yeah, true. See, I didn't even know half of those conspiracy things, and then I was having lunch after Corey Richards' trial with my sister and my aunt, my cousins, and they were like, "Well, there's this being said about Tyler Robinson." I had no clue, so. Yeah, I was in Corey land, I guess, but yeah, crazy. But I know you guys don't like Miss Nestor that much, or some people don't like her, but she may not have done the greatest job for Corey. I think they fought as hard as they could. They fought hard for their client, and I think she's doing the same for Tyler. Just saying.
Who would represent Corey in the financial trial? Would it be Sky?
I don't know. Why did Sky, she had a conflict. Why did Sky leave in the first place? Do you remember how that all went down?
I don't know if the conflict was because of the other trial and things were going on there. Usually when there's a conflict like that, they don't really tell us all the details.
True.
I want to watch the trial with Sky. She is a firecracker.
Oh my gosh.
She is.
I love that she was there.
Sky's still conflicted? Oh man. We've got to find a case that Sky's working and cover that one.
Does she work? No, when she walked in, she just can take over a room,
Yeah.
Sky, her presence is so, yeah. I was happy that she came and sat with the family. I thought that was cool. But I don't know what is the confliction. Maybe we probably never know. But anyway, here's a question I'm asking you as an expert. So she'll have to have different attorneys than her criminal ones, though, right?
Yeah. Laura was saying Emily Baker covered the filings. All of Corey's attorneys withdrew the day after the verdict.
Oh, they did? Okay.
So she basically has to get a new set. They're probably going to be court appointed because she's out of money.
Right.
Doesn't have any way to pay for it. And now that it's just financial stuff, there's probably a lot more attorneys that could be appointed to the case that are capable of handling it than the criminal trial itself. But
yeah, I don't know. I didn't realize that they withdrew that fast. I was like in a coma for a week or so after that trial. So.
You put in the hours. That was awesome.
I was sleep deprived.
Yep.
Okay, I have something else to ask real quick.
Yeah.
Asking for a friend, because I've been mentioning that I might be going to Hawaii Tuesday. So since you're the tech guy, I was wondering if you know, can we take our drone in the suitcase?
The problem you're going to have is not with the drone. The problem is with the batteries. The batteries are the big concern. So the drone itself is usually no problem whatsoever. You might have to check local regulations about flying, especially down in Hawaii. Obviously, you've got like no-fly zones within like 5 miles of airports and hospitals and things like that. That really, I mean, that buffer zone can be huge. But depending on the size of the battery, I would Google the model of drone and say, you know, am I allowed to fly with batteries for the XYZ drone? If it's a DJI Phantom, that you'd list that, or whatever that way.
All right.
And then also
call the
just
airline.
to be safe, call the airlines, let them know. And they you might be able to fly as long as your batteries are usually in carry-on with you or something like that. But they have to be under like 20,000 milliamp. There's all sorts of rules that way.
Warren has to take batteries for his oxygen concentrator, and we have to go through that with the airline. We have to get a certain kind and everything for that. And so I will call and check because we want to take our drone.
The batteries for drones are the kind the airline does not like. They're usually nickel metal hydride, and they're foil wrapped. They can be punctured and rupture and flame. So they're literally the worst kind for the airline. But you still might be able to fly.
Are they super expensive?
Yes.
Oh, because I was going to say we could just get one when we got in Hawaii if they weren't like super bad.
It might be like $80 to $100 for a battery for a drone, and that gives you 20 minutes of flight time. Just depends on the drone, the size of the drone, and the battery that's needed. But
okay, well, we'll check it out. But I thought I knew you would know. So thank you for your insight on that.
I definitely say
everyone.
Make the phone call to the airlines and let them know first. It's better to know ahead of time than find out it's a problem halfway through.
Oh, absolutely. That's why I want to find out before I get to the security. So, all right. And yes, I'll bring you all gifts. I'll bring you,
Thank you.
I don't know what, but okay. Bye.
Bye. We'll see you, Selena. Bye.
Bye.
All right. We're up to an hour and a half on the deliberation timer as we are waiting for the jury to reach a verdict in this case. Sounds like awesome. You can buy drone helicopter videos there for the sites you visit. That might be a good option, just to buy a pre-existing video. Lithium batteries have to go in carry-on, and there are restrictions. Some airlines have more restrictions than TSA. Sometimes they require it to be in a burn bag type thing that is flame proof in case there is a rupture or damage to it. But Ari wants a grass skirt. Hey, there's something about those grass skirts. I think I could rock that look. I've been practicing my hip to hip movement, so might work. No, I'm not going to demonstrate. Josh, hit me up. How are your hips for hulaing? I used to be really good at the hula hoop, but that was when my middle was smaller than it is now. What size do you need? Big. big. El Grande. Grass. Mostly I want like multiple layers, so the grass skirt, make sure you want it to cover everything, right? You just don't want little wisps and strands to be flying in the breeze. Just get a Hulu bobblehead. I'd be happy with that. It's all on the hips. We need to talk about something else. I'll bring you one, but you have to try it on for all of us. All right, hour and 36 minutes on the timer. Let's go back to that. The Ferris trial has bothered me since she was found guilty, says Laurie. That's an interesting trial for us. Obviously, our channel got featured in that case, and I didn't know. I didn't know it was going to. So that was not a comfortable moment for me, but an interesting one. A coconut bikini top. I think I could rock that look as well. Can you imagine me wearing that to the beach here in North Carolina? That would just be funny. Out metal detecting with a coconut bikini top. It can't be comfortable, right? Martha Jane's song is still one of my favorites. To see Canero's motion for a new trial. So many motions for a new trial. I think Clegg as well. The girl, what's her name? Carly. Carly is going to get her hearing, at least a hearing for a motion for a new trial as well. Did we ever hear about Sarah Boone's appeal? No, and Laura, honestly, this is we mentioned this a little bit in some of the phone calls or the letters we got from Sarah Boone towards the end of her case, but there was a point where I became more sympathetic to Sarah Boone's cause, specifically the idea that she was not getting the legal representation that she deserved. And by deserve, I use the term loosely because obviously she's a handful and, she made it difficult for her lawyers to represent her. But there is a point where it seems the lawyers just weren't doing anything, and because of that, she was losing out on rights that she had due to time constraints, like an appeal. If an appeal is not filed in time because your lawyer didn't file it, that's an issue because it's not something that you can just file on your own readily, especially when you have representation. The court would expect it to come from a lawyer. So I think she gets a pass or got some passes. Isn't Corey appealing? She said she wants to. Yeah. It's one of those things where if you believe in the system, right? You believe that you have the right to representation, you have the right to a lawyer. That right exists even when that person who has the right to the lawyer is someone who's very abrasive and we don't agree with. It's why we can look at a defense attorney who is representing just, sort of like a scum of the earth type client and say, I appreciate what you're doing. I appreciate you representing this client because everybody deserves representation. And I just hope you don't win. It's hard to have good counsel when you constantly accuse them of misconduct and refuse to work with them. I'm not saying she's infallible here. And the judge at the end basically said, this is on you eventually that you don't have a lawyer. She went through a ton of lawyers. It's been a while since the new Sarah Boone letter. Not as long as you think. Probably just a couple months is all. I have not listened to her jail calls. Strongly recommend. Like 8 out of 10 type recommendation. I'm a veteran of the Canero trial. I'm not sitting through another of his. Boone has an appeal attorney. Last week she got a 45-day extension. Okay, that's good. I like the part about the extension because I think she should get it, especially if the missed deadline is because of her attorney and not because of her. Take it easy making fun of Polynesian culture. I'm not making fun of it. I love it. Coconut bras and grass skirts aren't Hawaiian. I know. It's basically the cartoon representation of it. But the Hawaiian people, just the whole island culture, amazing, amazing. Do you think a verdict will come in today? I don't think it will. I mean, if it does, it's going to be after the 2-hour mark, so we've got at least 20 more minutes to wait. I don't think it'll happen before then. Why? Because they have lunch, and they needed to pick a foreman. And then after that, you've got all the paperwork as well. I can't see that happening in less than 2 hours. unless the jury is very experienced. As soon as the corn rake case ended, I did not hear another peep on this trial. And people have been asking me periodically for months afterwards, even till now. And I've heard nothing about it. 10 out of 10 on Boone calls. They're that good. I've got to keep my phone charging or it's going to... I think there's a battery out in my car that I need. Okay. Corey was 2 hours and 59 minutes to a verdict, and that was on 7 charges.
Banished from the state of Georgia.
I am banished from the state of Georgia. Y'all got me dying of curiosity over these calls. Maybe missed it earlier, says Aaron Blackman, or don't want to bring it up mid-trial. Sorry, I was wondering if you're going to cover the Stouch part. Letitia's? I mentioned it briefly, but I haven't made a decision. I'm leaning against it, Aaron, only because even though absence makes the heart grow fonder, I remember just how brutally, soul-suckingly depressing it was to cover that case. I mean, the facts of that case are terrible. And we sat through, the just terrible facts tied to, hair forts from Letitia and her attorneys and 3 people, 1 cup, all drinking out of the same water cup. It was absurd. Things I like about it. Judge Warner, if we get him back, he's amazing. He's amazing at explaining things. But part of the problem is that he did something wrong. I'm not sure if he would be recused on this one or what. The real Emily Ross says, well, I have you in one ear, but I got to go hang out with my boyfriend until verdicts. I'll be at work tomorrow. Is that considered an affair? Say hi to your boyfriend from us. Get him listening as well, and then it can be like a couple's night. It can be date night. Then it's all good. Thank you, Emily. Have a good night. Thank you very much. It did bring a lot of subscribers. But it's, I don't know. I love having a lot of subscribers, but that's not what it's all about. I miss the community we had when we started early on. And, we were doing roll call back then and welcoming everybody by name as they came into the chat. That was just a cool time. I know we're never going to get back to that point. But going forward, as we get new subscribers, we've met just some incredible people that I'm so glad we met you, that I'm so glad you found us. So I don't know. I would love to hit 100,000 subscribers eventually one day, but that's just for fun. You still recognize a lot of us though. I try. Can we not be there for Gannon? I think that's what I feel like, right? When we cover a case, part of me says we cover the whole thing, and we sat through some very difficult testimony because of Gannon, and wanted to treat that case with respect, and just knowing that he didn't get that treatment from the people who most should have given it to him. One in particular, at the end of his life. And so you want to be there for Gannon and for the community, honestly, who poured their heart and soul into the searches for him and everything. At the same time, I've got to sort of make sure that it doesn't put us in a bad headspace. Thank you, League of My Briefs. Welcome. Y'all are making me uncharge my phone here. Hello? Hello? Who's on the phone? This is Scott.
Hey, Scott, it's Hidden Phil from
Phil.
Hidden Phil Investigation.
Are you wearing your sleeves? Your media sleeves?
No, no, I've got them right here. I have. There's a problem with them. I got to send them. I need to talk to the factory, but those will be on the market soon.
Awesome. How are you doing?
But in other news, I'm running an investigation currently on this trial, the Koenig trial, and I was thinking about you today and your arm. If you grab yourself in the right way, momentarily, you will, I guarantee, forget about the pain or whatever's going on with your arm.
I appreciate you solving my medical dilemmas here. I can't demonstrate, obviously, nor would I want you to demonstrate for me what this right way is. But
I've got a video. I've sent a video to the burner. And don't worry, I used blue paint, which, by the way, I think it's oil-based. I think I ruined my hiking pants. But look for the video.
You ruined your Fruit of the Loom.
Yeah, it's all over the place. My carpet. Judd Welcher sent it to me, my colleague.
Yes, that is awesome. Phil, I appreciate you doing the important investigations that just need to be done in the true crime community. So many people have just left these areas unexplored, and you boldly go where no man has gone before in that area. So appreciate you very much. It's always great talking to you. Can't wait to watch the video. I gotta go here. Scam call. We'll see you. Bye. He hangs up on me for a scam call. That is great. Phil took one for the team, for sure. Phil's great. Was there bruising? That's the question. That's Phil. Tayo Toys on Twitter. So give him a follow. He's a lot of fun. He follows a lot of the great. He follows us and a lot of the great people in the whole LawTube and LawTube adjacent community, and picks out some of the best things that happen, and just put some great clips together. So love him. He's great. Even though he clips the worst moments from my live streams. All right. Oh man, Shannon, that sounds terrible. I can give you my update. Here's my medical information you guys didn't ask for, and I'm going to tell you anyway. Nerve pain in my right arm, okay? And it's like, it was so bad. If you go back on like at the beginning of March and you see me just like sitting there waving my arm around, it's because it hurt so bad I just could not hold still. Sitting here just trying to find, I was about ready to rip it out of my socket because it just hurt so badly and just nonstop pain. Spent forever, went to physical therapy, didn't really help. The therapeutic massage didn't help. Ended up going to the doctor, x-rays, said lots of mean stuff about arthritic deterioration that I didn't want to hear, which I'm just trying to ignore right now. But it still has all sorts of problems, nerve problems. Put me on some medication. I'm not a med guy, okay? I mean, to give you an idea, when I got my wisdom teeth out, they gave me Lortab, and I took one of them and didn't like how I felt and just never took any more because a little bit of medication goes a long way. They put me on a couple meds that now both of them say cause hallucinations and stuff, and I was having those and still am, for the record. So I'm not driving right now. But I see things that aren't there, and it's just like, it's crazy. So, anyway, I've decided no on the meds, and we're doing stretches and exercises and things, which are fun. Yeah, it's my fear that we're live. Hey, it's my fear that I'm going to comment about something that it's not there, and you guys are going to know that I'm just losing it. It's my fear in life. So, what kinds of things? You're going to laugh, cauliflower, but mostly bugs. Like peripheral, I see bugs that aren't there. And in one situation, I was watching the video on TV, and it was like full-on Picasso. Somebody's face was just melting on the TV. And I knew it wasn't happening. Like in my head, I know it's like my eyes are playing a trick on me. But I see it. So anyway. So my family, I just walk around like swatting flies that don't exist now. Yeah, that's what it's like. Hide the bug spray. Anyway, we're trying to get things all fixed. So Phil giving some advice about how to grip appropriately to take my mind off the pain in my arm. I appreciate that, Phil. Thank you. What were you taking that made you hallucinate? I think it was the prednisone. Or it could have been the baclofen. Prednisone or baclofen. Wait till you get old enough to start seeing floaters in your eyes. I'm there already. I'm on Southern Febreze restriction. I already am on light duty when it comes to Southern Febreze because I like the smell of it, and Mrs. R.A. does not like the fact that it's a nerve agent. And so we always have to sort of like compromise if we ever do need to spray it. She thinks that a single molecule is enough to do the job, and I'm more of like make it swim and raid, and then we'll know it's dead. So we have to find a happy medium there. Got a new hip. Wow, it's tempting.
Remember in the beginning when we started 110 years ago?
I'm bringing you a coconut top to match your grass skirt. Just make sure you keep the nugs. Thank you. Thank you. I already had a kilt from Scotland, so this is like the island version of, well, the other island version of the man dress. Let's face it, we're all falling apart in one way or another. Katie Bug, yeah, and I complain a little bit, but honestly, I mean, I've talked to a lot of you, both in chat and just one-on-one on the burner phone, and my medical issues are so minor compared to what most of you are going through every single day, and I feel like a wuss even complaining at all. It's like, oh, my arm tickles a little bit. Yeah, other people are dealing with serious medical issues, and I feel bad. You guys are an inspiration with how you handle it day in and day out. Let's see, Cauliflower says, I didn't know what Southern Febreze meant and was mightily confused. Yes, that's what we call Raid here, because you can buy it in a variety of scents, like lemon and lavender and things like that. Southern Febreze. It's all a matter of perspective. It's a lot to you. If it's a lot to you, it's a lot. It doesn't have to be compared. Yeah, but I do compare, and it's not a lot compared to everyone else. Baclofen started out weird for you? Okay, it got weird for me as well. Show them the stitch. What video? What video? Scroll up. I'll play the bug video. Let me see if I can find it. Where would it come in on? All my feeds are tied up right now. Let's do this one. Law and Lumber Recovery Addict bug video. Let me see if I can find it. I think it's this one. Let's go to camera 6 real quick. For 9 months, so they can't believe. Okay, stop. I need the Southern Febreze. Hey, can somebody bring me the Raid? There's a bug. There's a bug in my studio, and I don't want to turn the camera on it because I'd have to zoom out so it would all fit in the camera lens. It just went behind the cabinet. It's you guys. Oh my goodness. This I will tell you what's going to happen. What's going to happen is this. That bug, and when I talk about bug, I'm talking, you know, it's those, they call them water bugs here in the South. We know what they are, and they're not water bugs. That was like, it was the size of a small dog, and occasionally when we get one of these that come inside from outside, usually when the fall down, they're around the leaves outside, but when they get into the house, I have words to say, and now it's literally it's crawling towards my green screen. So I'm going to be on camera like this, and then on the green screen, you're going to see a bug crawl across the wall. That's what's going to happen, and it will be mortifying. It will be so bad. My family is ignoring me. They're playing the tuba in the other room, but nobody's bringing me the Southern Febreze, which is also known as Raid. You can get it in all different scents, but let's see. You guys, this is. We might have to stop the show. It was right there. It was like within arm's reach. Oh my goodness. We need an indoor cat that eats bugs. Okay. Oh my goodness. Get the raid. Get the raid. You guys, this is literally. I have a couple fears in life, and one of them is definitely having one of these bugs make it into the house and crawl across my green screen. It might be irrational. It might never happen, but if it does happen, I will never live it down. And that bug literally is like 4 feet from my green screen, and it was headed that direction. I need you guys to keep an eye out for it. I need you guys to watch for it. Oh my goodness. I need the raid. I need the raid. This is bad, guys. It's going to be a bad day. I can't step on it because it was like at waist level on the wall. And my feet don't go that high. All right, so Southern Febreze is ready. Here we have, not sponsored by the way. This is, it looks like this is lavender scent, Southern Febreze. We're going to put that right where I normally keep my drink and make sure I don't confuse the two. But I'm going to be looking like this until I find the thing. Oh, it's up high. It's literally
on your head.
Don't you dare. Don't you dare. Okay, here's what we're going to do. I'm sorry. Usually we're a little more professional in the mornings than this. We're going to get, I can see it. It's above me, almost straight up. We have 11-foot ceilings in this house. It's an old house, right? We have 11-foot ceilings, and there's a picture rail that runs around about 10 inches down off the ceiling, and it's between the picture rail and the ceiling, but it is almost straight above me. And when you spray a bug that high above you, I've learned from experience, they fall, they fly, and they aim for your eyes. This is how. Angie, please, nobody clip this. I don't want to see this on Twitter or anywhere else. If this appears on my green screen, it fell. It's so help me, you guys. Okay, it could be anywhere. It's now halfway. It's 2 feet from my green screen. It's now on the ledge that hangs over the top of the bookshelf. I've got 8-foot bookshelves in here, and it's on the top ledge, which hangs over my desk. I can touch the bookshelf. I'm not going to right now because there's a bug on it somewhere. And the fact is, I have to stand up. To
Musical
get this.
Notes Happy
And it's
Day,
No Pants Friday,
cockroach.
so I've got all sorts of issues going on that are presenting problems. Can't go anywhere. You have to. Did you see it? All right, let the cat in. Will cats eat these? Will cats eat these? Bug will be dead by the end of this show for sure. Bug has nowhere else to go. I mean, it's not like there are wires it can hide behind here. Yes, cats will eat them. We're keeping the cat. All right, there you go. That's the clip. That was a long time ago, and wow, my studio's different. I mean, some of it's still the same, but a lot of it's very different from how it was back then. Why is my camera crooked? All right, that's a little bit better. All right, the studio was much different. Why have I not seen this before? Katrina Bunny, Rob from Lawn Lumber put that together, clipped. It was obviously a bad day when that happened, and he clipped it. It was funny because lawyer, Peter Tragos had a similar, same type of bug, and he just smashed it with his hand. He's like, whop. I'm not that brave. I don't know. I'll have to look for the other version. It's around there somewhere. Anyway, the Halloween music makes it. It's very funny. All right, where were we? We're watching Court, actually, is what we were doing. Let's go back to to that view. That's when I found you. that was funny. I have done so much to make sure the bugs stay outside my house, and for the most part, it's working. And then the little hallucinations with the baclofen or the prednisone, that is just, it's not right. It's not fair. So it was basically a horror movie. We are at the 2-hour mark, which means now we can possibly expect a verdict, but we'll see if it actually develops, if it comes through. That's not it. Let's see. There we go. Jody, don't do it. Yes, Rob still has his channel. He's just got some life things going on that have kept him busy. I mean, he does run a very successful and very busy law firm as well. In his spare time, he tries to do some YouTube, but life's going on. How long were they going to eat lunch for at first? I thought it was about an hour.
Call from
Denise.
Hey, Denise. How are you doing?
I'm good. So I figured I'd call and just say this over the air since I've been lurking for a hot minute.
Welcome.
The one thing that I noticed rewatching that video, we've turned you gray. Your hair was much darker in that video.
I get a gray hair every time I get a new person who calls on the burner phone that I'm just like not sure where it's going to go.
I just thought I'd say it out loud for everybody.
Yep. Well, it's the truth. It definitely is, but I don't think it was you guys that did it. I've got plenty of stress in my life that causes that. So this is my happy place.
Okay, that was all.
Yep, just for men. Looking for a sponsor. Hit me up. Thank you, Denise.
Bye.
Good talking to you. We'll see you. Bye. Denise, long time supporter on the channel as well. Let's see. Gray is the new green. Yes. It's distinguished. That's what I like to tell myself. It's distinguished. 50 Shades. Wow. Rob's newly married. Yes, he's just got life going on, and wish him the best and all that. I know he's when the time's right, he'll be back on YouTube, and it's gonna be great. So, all right. That said, I've got weird stuff pulled up here that I don't know what I need. Yes, he did get married. Shelly Small gifted 5 memberships. Shelly, thank you very much for your generosity. At least I saw him. I think he got. I saw the engagement pictures. I think he got married. I think it was a family affair. So, I didn't invite everybody. I aged 10 years watching 1 hour of Defense closing today. My husband turned totally gray within 3 years of us being together. I prefer him this way. Gray it is distinguished. It's nice. Shannon also gifted a membership. Thank you, Shannon. And that went to Brooklyn Basement. Congratulations, Brooklyn. All right. It's funny because you guys noticed the gray. I didn't see it. I was not looking at that at all. I was looking at the buttons. I'm like, holy cow. I ran that show back then with like one computer and a switcher and a soundboard on a little tiny desk. And that was it. That was it. And the quality was just as good then as it is now. So how much longer today? Possibly about another hour. We're thinking probably an hour, maybe an hour and a half of deliberation time. I've had some gifted memberships. We sure have. Thank you, Josh. We've also had a huge super chat, Josh. Thank you very much for that. For that, as well as Shelly Small giving 5 memberships. Also, Shannon S77 comes in with another membership. And just now, Hilda B. Thank you very much for your generosity. Rob is definitely married. Definitely. My hair didn't turn gray. It deserted me, says Tarkin. I was noticing the no glasses. We might have to go back and spot the differences. I thought it was a good closing battle. It was a long trial. Ace King, I liked it as well. I liked that both sides fought hard in this case. I've enjoyed it. Debbie, hubby's home. Wonderful. Enjoy your time with your hubby. Jay McCarthy World gifted 5 memberships. Thank you, Jay. McCarthy World gifting 5 memberships. Goes out to great people. Holly McIntyre, Jen, Lynn Hoke, Kat Williams, Jesslyn B. Lots of good people. Have to do a side-by-side. I think the jury goes home in 30 minutes, 3:45 Hawaii time. What time is it in Hawaii? Is it 3:45? I'd be cool with that. If they do, I know the judge is going to take some time just to gather people if there's a verdict. We might not have a verdict tonight as well. They have 2-hour lunch. That is nuts. And lunch is provided. Jay McCarthy World, thank you very much. Paying it forward. That is wonderful. It is very generous. 1 hour left and then they stop. Let's see. Hawaii sounds like a different planet. We are on verdict watch. The Hawaii time frame is really throwing us off. Realize that when we go back tomorrow to continue on verdict watch, it will start at 3 p.m. Eastern time. So another late day tomorrow. And we'll see, maybe, hopefully, the jury comes in the morning and says, we slept on it, we feel good about our decision, we have a verdict. That would be great. I missed a milestone. Let me go back and access that. Just 1 second. Grubba Krista, thank you very much. You haven't changed a bit. What's your secret for staying young? Deer Park Water, not a sponsor. No, I don't know. I didn't think I had looked staying young. I'm like, well, my face is rounder than it used to be. And I've got like 3 extra chins now. Jody says, I bought my husband a kilt for the Renaissance Fair. He was appalled until he put it on and wore it all day. And now he has several to work out outdoors. You can get a utility kilt. Is that what you're talking about? It's like a construction worker's kilt. So it's got like a spot for your hammer and everything and everything else. Lego My Briefs, thank you very much. Shelly Small. Now, come on, you know I'm unforgettable. Yes, Shelly. Let's see, there's a couple more I missed here. She can't get court appointed for civil court. I think that we're talking about Corey. Are you? I think her financial crimes are still criminal. They're just a different. They're not as serious a crime as attempted and murder. I know everyone was covering it, but your thoughts on that? Guthrie covered that one. Jody, thank you very much. 3rd super chat. Sandra's trial. That's going to be exciting. Carla Larson, member for 35 months, joined during Letitia Stout. Just so heartbroken for Gannon's family. Likewise. And that whole community getting dragged through that again is going to be hard. The spot for your hammer is crazy. I tell you, they're nice kilts. Why did I move from Utah? We just felt that there was somewhere else we were supposed to be, and didn't know why or where, and did a lot of research. And North Carolina ended up coming from the bottom of the list to the top of the list. I flew out here. I don't think I even told my boss I was flying out here, because I just brought my laptop and worked. I worked from home, and so maybe I'm confessing to a crime here. But I flew out here and one weekend, so I flew out on a Friday. was working on the plane, looked at 8 of the 9 houses that we had picked out on Zillow, just to see, which ones would work for our family. The first 8 were terrible. Got to the 9th one, and it felt right. And I called my wife and said, "This is it." She said, "Okay, buy it." She had not seen it, and so we bought it. We put our offer in. I flew back home. We sold our car. We did a home equity line of credit on our existing house. We got a huge line of credit, used that to pay cash for our new house, and then sold our old house and paid off the home equity line of credit. You're not supposed to be able to do that, but we did, and we asked very carefully about the rules, and they were okay with it. And flew out here, and my family hadn't seen the house until we landed here when we moved here. So moving in was the first time they saw it. And I lost all house buying privileges at that time. What time does the judge say the jury will go home? It is a crazy story. But honestly, just on a personal level for me, living in North Carolina has been really, really good. It's not just I like the weather and the people here are amazing. Both of those are true. It's just been a period of growth for me personally, like both on the spiritual side and personal that I needed, that it just wasn't going to happen where I was. And it was just it was a big thing. I stepped away from politics. I was involved quite heavily in politics before, and when I came out here, I made a change in my life that I needed to make because the politics were just killing me. Just the fighting and the back and forth. And it was just a good choice for me to step away and see life differently. So. Pickles, not politics, yeah. No more World of Warcraft driving. Yes. I'm interested to see what happens with Rex tomorrow for sure. That's going to be quite interesting. If we'll keep our ear to the ground. We might be able to watch that while we're waiting for Hawaii court to start. The real Emily Ross says, "I'm a heavy equipment operator. Female work around all men except for our wonderful secretaries. My boyfriend is the mechanic. We are perfectly fine. My crew tries to mess with him. He knows they're playing." Awesome. As far as when you say heavy machinery, are you talking crane or like loaders and diggers and trucks and all that, or D, all of the above? I love watching videos on that. And I grew up not far from an area that the mountain was literally being carved away, dynamited and blasted and carved away.
From the state of Georgia.
Probably like a 1,000-foot cliff that was all different colors of rock that were just constantly just being collected and gathered. And so watching bulldozers work on cliffs and things like that's just been fascinating. Politics will eat you alive. Yeah, it was eating my joy for life was what it was. And I thought I loved it. That's the funny thing. I thought it was like, yes, this is what I want to do because I'm right in there in the fight, and and it sucked the joy for life out of everything. So yeah, there's honestly, and this is the last time I'm going to talk about it, because obviously I do think it's good to be involved politically. That's great. And I think no matter what side you're on, whatever what your opinion is, I would encourage you and strongly support you being involved politically, because that's what, a lot of involvement makes a better process. But I was involved at such a level that I was almost like picking sides, but whether I liked someone or not based on whether they agreed with me politically. And man, that's just a crappy place to be. I hesitate to think how many just amazing people I never allowed myself to get to know because I focused first on our differences instead of what we had in common. And yeah, so yeah. Anyway, it was a very good thing. Is your moving story before or after your recovery story? After. Yeah, I've found that that some of my best friends are people that have very different opinions than me, politically or religiously or anything else. And they're still just amazing people and best friends. And I still, would go to them and ask their opinion and value it and consider it when I'm making my own decisions. Because, people are amazing. And if we just look at them and try to boil them down to one opinion or, one place where we find a difference with them, we're cheating ourselves out of what life's all about. And it's people and relationships. All right. That said, let's see. My mom's surgery went well. That's wonderful, Shelly Knuckles. Wonderful. That's great news. We all knew it would, but that's great. Even people who dislike pickles. Well, you have to draw the line somewhere. Hedgehog in space. So, the pickle is a great line. All right. Let's see. So tomorrow, just looking at the schedule here, we're anticipating not getting a verdict tonight. Just as we get closer and closer to the witching hour, if that's the right term. Murder is so much better than politics. Yes, I'm not saying I made the perfect jump, but it was a better jump. I'm not like trying to preach a religion to anybody, and I wouldn't even say that everyone needs a religion. I needed more balance in my life. And for me, my balance involves religion. But I was so skewed in what I thought was important in life with, politics and winning the fight, that I didn't realize what I was missing until I was able to step away from it. And I couldn't have done that in the current environment. I had to be in a new area where I basically had to start over from scratch and didn't know what the fight was in the area, right? What are we fighting for? Which side am I on? I didn't know. And it was, for that reason, I'm just so grateful that we moved out here. All right, let's see. We love our Canadian followings. I've sung the national anthem for Canada countless times for the Scottish Highland Games, which my family plays a part in, as they've been in the leadership of the Scottish Highland Association and back out west. At Estes Park and a couple other locations, but we need the Runkle soundbite now.
Here in Canada, hate you and hope for bad things for you because we hate you.
There you go. It's been a very long day. It has, and it's 9 o'clock, you guys. Here's what we can do. Let's just wrap it up right here, because honestly, you guys have some sleep to do and everything else. We're tomorrow morning. Courts are going to start on the East Coast. We've got the Rex thing going on. Rex H. We might have to keep an eye on that. We've also got some court hopping we can do, and then of course we've got our trial itself that's going to be starting around 3 o'clock. And you say we get a verdict just after the third hour. I feel bad because I feel like right now I'm not giving you anything of value. I mean, and I value your time, as you, I imagine all of you do. I don't like just being on to be on and have you here waiting. Because of that, I know that, there's your family wants to see you and you've got things to do, and, run to the store or fill up the car with gas or whatever it is you've got on the agenda, as little or small as it is. It's important to do that as well. So I feel bad just sitting here watching the timer. Although I do feel like I'm just watching it with friends, which is good. My husband thinks you and he misses me. Red pen, that made the decision for me. There we go. Here's what I can promise you. If we get a verdict tonight, I'll go live with it. So we're going to wrap things up here, and thank you all. Appreciate all of you. This really is the best place to watch true crime, and it's because of this community. It's because of all of you. I am very grateful for that. I love that I get to do what I love to do and call it work because it's just amazing. It's a blessing that I know that most people in life don't get to experience, and that's not lost on me. So thank you all. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again in remarkably few hours. So it's about 12 hours. It's Hump Day tomorrow. Just as a warning, if you haven't been here on Hump Day before, we do a Hump Day yell, where we welcome you to the midpoint of the week. The weekend's halfway here. So if you're here early, you're going to get to hear that tomorrow, and then you'll know not to be here early. So there's your warning. Jelly beans, lots of time. Lots of time. Thank you. 9 months. Jelly beans, appreciate it. Y'all are amazing. Have a wonderful night, and maybe we'll get a verdict tomorrow morning. We'll see you guys later. Bye-bye.
I don't like podiums, Your Honor.
Remember in the beginning when we started 110 years ago?
I'm not a cat.
In front of the Walmart.
I was kicked back, taking it easy.